But, my lord, may I have your lordship's kind leave to mention, my lord, item number 41. This I am mentioning because, my lord, we are aware that, my lord, your lordship will not be available for Monday. Under these compelling circumstances, my lord, presentation of plain 41, your lordship will find there's a GA along with that. That's the interlocutory application. So, my lord, I can understand, my lord, there are today 3-4 fixed matters. If it could be taken up any day tomorrow, convenient to your lordship, anytime tomorrow.
A non-commercial matter.
Non-commercial. Just presentation and the interlocutory we will ask for.
Let us see till before lunch how far I can go.
My lord.
Then come at 2 if we'll time.
Again, we'll bother your lordship at 2, my lord. Your lordship is, because your lordship has, I have found out from your lordship's office, 3-4 fixed matters today.
Okay. 2 p.m. fixed matter?
Yes, my lord. 2 p.m., 3 p.m. and your lordship has appellate side at 4 p.m. That's why I was requesting, my lord, if it could be any time, just give us 10 minutes anytime tomorrow. 10 minutes, no more than that.
Tomorrow is a commercial day.
Give us tomorrow.
Tomorrow is a commercial matter.
After commercial matter, your lordship will give us at 2 p.m.
I think tomorrow also it is fixed.
Tomorrow 2 p.m. At 3 p.m. we can come tomorrow.
Tomorrow 3 p.m. 1 p.m. matter is there. Tomorrow 1 p.m. is there.
Or at 10:30.
1 p.m. tomorrow. Come tomorrow at 1 p.m.
Tomorrow 1 p.m. Grateful. Deeply obliged.
My lord, I'm praying for leave to file affidavit of competency.
Yes.
Affidavit of competency, praying for leave.
Affidavit of
competency, my lord.
In which matter?
My lord, CS 275 or 2016. You also remember this matter was referred to a special referee, my lord.
Special?
Special referee appointed by division bench.
Okay.
The matter is already, my evidence is closed.
Okay.
But when evidence is going on,
Yes.
then it was detected that due to inadvertence, the previous advocate expired. From the new advocate appointed, he filed ukalat now, but unfortunately, he didn't file any affidavit of competence accordingly.
Today is there. No? Yes, it is there. Today it is list.
Lordship, it is there in the list today. I'm appearing for the plaintiff.
Matter will be called.
My lord, may I have lordship kindly to mention one matter? I am mentioning this matter upon notice to the appearing defendant, my lord. This is an originating summons suit. An amendment was directed to be carried out by your lordship on 25th of April 2020. But there, my lord, the order in terms of prayer C, my lord, may I hand over the master summons, my lord, has not gone down. That was for re-verification and reaffirmation of the. This is the order passed by your lordship. The prayer in terms of prayer C has not gone downward.
Okay. So what you want now?
Well, I was praying before your lordship for inclusion of the prayer C. Otherwise, the re-verification and reaffirmation portion cannot be made.
So appearing for the plaintiff. The plaintiff has mentioned the matter after notice upon the other party. Other side, police. Counsel for the plaintiff submitted by an order dated 25th April 2024. This court has disposed of GA1 of 2024 by allowing the prayer A and B of the master summons, but this court has not allowed prayer C of the master summons, wherein the plaintiff has prayed for the verification reaffirmation of the plaint of the amended plaint. Consider the submission made by the counsel for the plaintiff. The plaintiff is allowed to re-verify and reaffirm the plaint after the amendment is carried out within a period of.
Madam?
How much time you want?
Madam, 1 week will be enough.
Within a week from date.
1 quarter week from the.
This order may be incorporated. The amendment within a week from date. After the amendment is carried out, full stop. The re-verification and reaffirmation be carried out within a week from date. This order may be incorporated with the order dated 25th.
My lord, may I have my lord's kind leave to mention a matter, my lord?
My lord, may I permit to mention a matter. In this matter on 29th April, my lord directed our client to file a call number within 2 weeks from date, my lord. What happened in this matter? My lord, client is out of India. I'm praying 2 weeks time, my lord. He is not able to return India, my lord. I'm praying 2 weeks time for in last paragraph of the second page, my lord. Learned Himalaya Roadway Limited to file Wakalatnama subject to verification within 2 weeks from date. That time should be extended by further 2 weeks.
The matter is listed and the matter is mentioned by the learned counsel for the plaintiff.
I'm for the
responded, Your
respondent,
Lordship, I appear on behalf
For
of
the
the petitioner.
respondent, in presence of the learned counsel for the plaintiff. Plaintiff prays for extension of time to file Wakalatnama on behalf of Himalaya Global Holdings Limited. In view of the submission made by the counsel for the plaintiff to file Wakalatnama on behalf of Himalaya Global Holding Limited is extended for a further period of 2 weeks from date.
grateful.
Lordship, may we please allowed to mention a matter
Yes.
for inclusion in
Who is
Lordship.
senior? Who is senior?
Lordship, he's my other side.
Okay.
I'm mentioning a matter for
I'm
inclusion
appearing for the defendant.
and I'm appearing
There's
for the
another application filed on behalf of my client, which is under Order 7, Rule 11. May that also be listed
Lordship,
along
there are
with.
2 GAs from my end and one
What is your GA? What is your GA?
One is for judgment upon admission and one is for injunction. Lordship, it was
Judgment upon
supposed.
admission.
Lordship,
Another is injunction.
Lordship,
And you have filed an application for rejection.
Order 7, Rule 11.
Lordship,
Yes. The pleadings have been completed.
Lordship.
After vacation.
Lordship.
My lord, may I have my lord's kind leave?
Just fix the matter.
May I have your lordship's kind leave to mention a matter, my lord?
But I appeal for the defendant.
He is preparing for the defendants, my lord. This matter was supposed to come up. The interim order is expiring tomorrow, my lord. My lord, in the meantime, my lord, my learned friend had given a notice, had mentioned this matter on 23rd of April 2024, saying that there were certain errors in the names of the defendants, hence he could not file the Wakalatnama. Your lordship had fixed it on 6th of May. My lord. It did not appear on 6th, 7th, 8th. Yesterday was a holiday, my lord. So I am mentioning to
A commercial matter?
non-commercial.
No, partition suit.
Partition.
So what is your submission now?
My lord, the interim order your lordship had granted is expiring tomorrow, my lord. The auditor.
But I'll tell you, Lordship, as per your Lordship's order dated 4th April 2024, matter was to appear on 10th of May, which is tomorrow. But in the meantime, I had mentioned the matter because there was a misdescription in the cause title. That is why I could not enter appearance. The defendants could not enter appearance. In those circumstances, Lordship was pleased to keep the matter on Monday. It did not come up. But tomorrow, 10th of May, is a commercial day. If your Lordship allows me to enter appearance on behalf of all the defendants with the cause title remaining intact. And Mr. Gupta's prayer for extension of interim order, I can't possibly oppose at this stage. Lordship will extend the interim order.
It will be listed tomorrow.
Tomorrow is a commercial day. If your Lordship takes it up tomorrow, as to be mentioned, we have no difficulty.
Okay, you mentioned tomorrow. It will be listed
Very
tomorrow.
good. I shall
Mentioned
mention it.
tomorrow will pass.
Grateful.
My lord, may I have my lord's kind leave to mention a matter, my lord?
Yes.
But I'm praying for my lord leave to my lord file a suit. My lord, the suit has been the uploading has been done. It is going to be filed today. My lord, I shall give the number to my lord's officers if it could be if it could appear tomorrow. It's a commercial suit. It's a foreign company, my lord, who has been defrauded by Indian company. Monies have been paid, but goods have not been given. So my lord, there is some urgency in the matter, my lord, and we are also praying for dispensation of 12A and also move an application.
It will come tomorrow. Tomorrow is a
Yes,
commercial day.
yes. My lord, I
So
shall
what
give
you
the
want?
number.
So what do you want now?
The urgency because there is an urgency. I'm praying for that it could be listed. I shall give the number to my lord.
Unless and until it has not been.
It has been uploaded. The number will be getting shortly. So we'll give the number to my lord's officers.
Some precedents.
Some precedence may be given. That's my only.
Yes, next. Call the list.
May I have my lord's kind leave to mention one matter? My lord, this is an original side non-commercial matter. I am mentioning upon notice. My lord, my matter is, my lord, appearing in the monthly list as item number 30. My lord, I was praying for some precedence, my lord, because my lord, it's a judgment upon admission pending since 2019. There is a transfer application which I have filed, my lord. My lord, may it be taken up, my lord, on this side of the vacation, subject to my lord's kind convenience, my lord.
Tell your date when you will be able before
My-
vacation. I will pick
any
that.
day, any day, my lord, any day,
dates.
any day.
Who is for the other side?
My lord, Shurjonil Das is appearing for the defendant, my lord.
So have you informed him?
Yes, yes, my lord. The mentioning notice, my lord, my advocate on record is carrying. My lord, any date, my lord, subject to my lord's kind convenience.
Fix on 17th May or 16th May.
Lordship is there. Then
They wanted to fix. I am fixing it. What can be done? 16 May. Yes.
may I,
I-
Lordship,
I'm
kind-
deeply obliged.
mention your Lordship, Lordship, the plea, suit areas, Lordship, they have filed a written statement for the normal directions, your Lordship. It can be listed any day for the filing of the
What is the
inspection.
urgency? Come up.
Urgency, nothing
You
urgency,
file
your
the
Lordship,
written
but,
statement. When is
they
the
have
day?
filed.
Ah.
They have filed.
Hmm.
Only like the
You
formal
do-
directions, your Lordship.
First the reopening day you mentioned.
Lordship.
J is dismissed. Considering the above facts and circumstances, this court finds that the plaintiff has paid the total sale consideration to the defendant number one. The plaintiff is in occupation of the premises and is running the business in the said premises only to avoid the registration of the sale deed. After the receipt of the total sale consideration, the defendant has made out a case for mortgaging the property of the defendant number one by the plaintiff does not stand as no document filed by the defendant number one to prove the contention. Accordingly, it was found that the plaintiff has made out a prima facie case, balance of convenience, inconvenience in favor of, and if an order of injunction is not passed, there will be a chance that the defendant will alienate the property to third party, and the plaintiff will suffer irreparable loss and injury. Accordingly, the defendant, his man, agent, and employee servants are restrained from alienating, transferring, and creating any third party interest over the suit property, and for disturbing the possession of the plaintiff over the suit property till disposal.
Lordship, I was appearing for the respondent bank, but I
Yes.
had also prayed for dismissal of my name from the suit.
Because this is an injunction, if suit will be taken, then I will pass appropriate order.
Lordship, I'm grateful.
We will be expediting the suit because they have not filed any written statement, the first defendant. So we'll
After reopening, you mentioned that.
deeply obliged.
Absolutely.
I'm
for the plaintiff, Lordship.
To be mentioned.
Your Lordship, Mr. Ayan Dotto
Adjourn motion.
is appearing for the respondent. I'm praying for a small Passover, Your Lordship.
Okay, it will take as a adjourn motion. It is wrongly taken as
I
a.
was directed to file an affidavit taking leave to retire from the brief. On that day, I could not file it. So kindly give me leave to retire from the brief Scott defendant number one. The China-based company, my lord. Lordship, I already passed the order that it is giving direction to serve
Sir,
on the China.
Item number 3.
Sir, B.
No, that is correct. Whether you have to file the affidavit of service.
No, it's not.
Who is for the plaintiff?
I'm for the plaintiff. He's for some other matter, Lordship.
Next
He's
item.
confused actually.
I'm sorry.
This
It was
item number
supposed-
3, you are appearing?
Yes, Your Lordship.
You are appearing.
I'm for the plaintiff, Lordship. It's
Ah.
supposed to come under the heading adjourn motion.
That's, I will take as in the adjourn motion matter.
Lordship.
I will take as a adjourn motion matter. Pass over.
I appear for the plaintiff, my lord.
I filed the
My lord, by my lord's last order dated 24th April 2024, my lord, we'd already concluded our submissions. This is an undefended suit, my lord. I am being led by Mr. Shubhashachi Chaudhary.
Ah.
My lord, we'd argued the matter out.
Ah.
It was only for the special officer. Since there's been a special officer appointed since 2016, my lord, we only kindly take my lord's last order. 18 January 2016 was the order appointing the learned special officer.
Correct.
My lord, the special officer is present in court, my lord. He's filed his report.
I will serve.
My lord, may a copy be circulated?
Circulate the copy.
But my lord, we kindly reserve the. My lord, since we completed our submissions, my lord, we kindly reserve it for judgment.
I am taking,
Yes, my lord will take it on record and reserve it to judgment.
so and so appearing for the plaintiff. So and so then a special officer is present in court in person and has filed a report after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. As the learned counsel for the plaintiff has already completed his argument and the special officer has also submitted the report. CAV.
My lord will recall when we had argued the matter out, since there's a decree for accounts, my lord, that needs to be drawn up as per, my lord, the report of the receiver, my lord, but we are not seeking discharge of the receiver. So the receiver, or rather the special officer, my lord, we're seeking his appointment to be confirmed, my lord,
Let me see.
my lord,
I have not passed any discharge.
no, my lord. Obliged, my lord.
For the plaintiff, Lord, it required two things from your lordship. One, Lord, was mentioned at our instance. The tenure of the special referee is coming to an end, Lord, on this month. Lord, and lordship is not sitting for 2 weeks. So, Lord, we are mentioning for extension of the tenure. Evidence is complete. Only it's due for argument. Now, on the time of mentioning, lordship indicated that why the special officer would hear the argument. But in that context, Lord, by an order dated 19th of July 2018, the division bench who had appointed the special referee had permitted the referee to, Lord, adjudicate the claims, counterclaims, damages, compensation as made out in the suit and counterclaim. So its adjudication part is left to him. He'll file a report. Thereafter, lordship will consider the report and Lord. It's like a calculation of mean profit. Probably, Lord, this is how I'm handing over a copy.
What is the suit for?
My suit is for recovery of money. His suit also for damages.
Damages are counterclaim, my lord.
His counterclaim is for damages. Now, Lord, that is
as well as rent, my lord.
Now, Lord, parties filed a terms of settlement in court. In the terms of settlement, parties, Lord, I can hand over a copy to your lordship, Lord. In the terms of settlement, Lord, parties agreed that the special referee will adjudicate the claims, and accordingly, the
what is the claim regarding damages?
His claim, Lord, counterclaim is regarding damages. My claim is for recovery of both. In fact, recovery of money.
8 years late, my lord.
Both are for recovery of money. He is claiming
Both are
rent.
with the government.
I am claiming security deposit. Primarily, that is the. So, Lord, the parties, when parties agreed that the special referee will adjudicate the whole thing. I think because of that.
If the special officer adjudicated, then what is the necessity of the court now?
Court,
if the special officer has been adjudicated.
I think it is the lordship sometimes appointment for special officer for calculation of mean profit.
So that is for inquiry.
Yes, inquiry of mean
that
profit.
That is inquiry, but here kindly see the terms require the special officer to appoint adjudicate the claims and counterclaims.
Yes.
If it the special officer adjudicated what the court will do now further.
That is.
I will not. You act according to law. I will not do anything.
I only want extension. Today, I only want extension of time to finish the proceeding. For finish this proceeding for the special referee.
Go for before the division bench. Take the time from the division bench.
Lordship
this has been appointed by the division bench, not by this court.
No, Lordship has already.
That has been by misleading the court, suppressing the division bench order.
This order was. I will not suppress this order. This order was passed.
When first order of extension was taken, this order was not placed before this court. Only you submitted on mentioning the commissioner report. The time is to be extended. The simple way now it has been given. It is the division bench order. How the division bench order can be extended by this court?
But we have no. Both parties will not have any problem if lordship says the special referee to after completion without
argument. I will not say anything. You mentioned before the division bench.
But we don't have any problem with lordship. I
will not touch once the division bench has passed an order upon the special officer to adjudicate the matter. How this court can enter into that?
Lordship is a suit court. For the time being, lordship is taking the suit matters.
Suit matters taken, but the division bench has taken out from this court. It has been given to the special officer. You mentioned before the special division bench. How this court can sit over the division bench order? You kindly clarify me.
If Lordship, I can clarify, my lord.
Yes.
Lordship takes the terms of settlement once, my lord, for my side.
I will not go to your terms of settlement. I will go to the division
Yes,
bench order.
That order, my lord, refers to terms of settlement, my lord.
Yes.
Settlement says that special referee will file a report with the suit court. Within that is the direction of the my lord.
Kindly come. Terms of settlement data executed on so and so parties are countersigned advocate so and so so and so.
Yes.
The terms require special officer referee to appoint adjudicate and claims of the counterclaim, damages, compensation, etc. made out in the suit and the counterclaim.
Yes.
So-
But that same terms, my lord, says the special referee thereafter file the report with the suit court.
Where it is? Where
I
it
am
is?
carrying the terms.
Not your terms. Where is the division bench order?
Sir, order only record the terms, my lord.
Then
But it's a.
so you go to the division bench. You go to the
We were
division
not
bench.
there, my lord, at that point of time. Only thing that the
You
terms
go to the
required the
division
special
bench or clarify from the division bench how this court can say toward the
That's a
division
confusion.
bench order.
I know. I am not on that.
Tomorrow anything will happen, who will responsible? The court will responsible.
Parties
Either
alleging.
he will give the allegation to this court or you will give the allegation
Lordship
to this
record our
court.
consent.
The court has accepted the report.
Lordship will record our consent. Both of
Why
us are
I should
consenting.
record your consent? You go and give the consent to the division bench.
I can not. It's only the.
Next.
My lord, super my lord, he granted to file the
No, I will not allow. Once the division bench is altered, it is the
Yes,
success
yes.
of the division bench. You go to the division.
We'll come back, my lord.
You
With
clarify
the-
and come back.
The division bench, my lord, thereafter says no. Then we'll come back.
Whatever the direction will pass with the division bench, I have to obey that. Today, the division bench order is hearing before this court.
Lordship is.
I can't.
Reading of the order is that, my lord, Lordship only that order by division bench only said terms is there. So let this.
Where is that to file the report before the suit court?
That's there in terms of settlement.
Terms of settlement has not accepted by the court. That's why the special officer referee was appointed.
But there are there are other.
Where is the order? The terms of settlement has been accepted by the court.
terms of settlement, my
If the
lord.
terms of settlement is accepted by the court, why the special officer?
The term said special office. That's the problem. The term says special office. So court also will had to go that way.
So you are going here and there. What the court can be done?
But my lord, I can not.
Pass on the basis of terms of settlement, man.
Then why the special referee will decide further?
But what I am saying, my lord, in terms of the single court judgment order, my lord, we, the defendant, deposited 3 crores with the register. Subsequently, the order was challenged by the bank. Then, my lord, matter was settled between the parties on the condition they will withdraw the money from the register, they'll hand over my person, and my lordship there's no order. The both were agreed. This person is appointed. He will adjudicate the dispute difference, and the matter will be referred to the single bench. But this was the
Where is that's why show me
Understood.
any line, any word that the report should be submitted before the suit court. Show me order.
terms of condition দেখান একটু।
না নেই টার্মস অফ সেটেলমেন্টে আছে আচ্ছা আচ্ছা চাইছে না ওটা
But in terms of settlement, মানে the order was passed, my
Then
but I can the lordship is reading the 19 January 2018 order.
yes.
But that order with the third paragraph,
Hmm.
Mr. Mola Kumar Ghosh, senior advocate, is appointed special officer referee. In accordance with terms, special officer referee should submit his report within 6 months of the receipt of the copy of this order. Now,
Where?
But that is referred in the terms of settlement. The lordship can see that the court is repeatedly relying on the terms of settlement. Settlement says that that will be filed with the suit court. And that this is the suit court today, Milad. So, but we can
Go and
these are
clarify from
there.
the division bench, then I will.
Because the only thing is that
Go and clarify from the division.
we all blood. In fact, Mr. He's a special
That
referee.
can be done.
We all blood stuck when the court said that he will adjudicate.
You
because
could have been taken the clarification
It
from the
happened in
court because
2018,
the court has not disposed of the APO.
the
Court has disposed of the APO.
the appeal was disposed of there.
Then
The appeal is over. Now
Then?
the suit remains.
what has happened to that suit?
Suit blood, the report will file in this. That is the understanding. Report will file
And
in the
against
court.
which order you filed your appeal?
But that was a Justice Sen's order. That
What is
order
the
I'm
order?
carrying.
What is the order?
This order by which the this suit court at that point of time handing over the order. But she could find it from the order, that was the order from which the appeal was preferred.
So what has happened to this order?
But that order in appeal party settled. that portion of deposit of
This has
money.
not been modified.
No, the order party settled, so order got appeal disposed of. And now we have withdrawn a portion of money, remaining portion is
This
still.
order has to be modified, then it could have been done. This order has not been modified, still this 60 per month is the.
I know this was the trouble. The special referee also asked me that what do I do? Do I pass a? He in fact said, "Am I entitled to pass a decree?" Sitting in the I can't do that. We all very embarrassed, but then this is the order that we all know. So I only with consent of parties that we have no problem if the special referee is directed to file the report at this stage of evidence. He is also will be very happy, I guess, not to adjudicate. So we have no problem with Lordship. Evidence recorded, Lordship decides it. We have no problem. Parties can still agree here, Your Lordship. We are here.
No, first thing you satisfy me. If the special officer has decided all the things, what the suit court will do? What the suit court will do? You go to the decree department, tell the decree withdrawn in terms of the.
That is where I am like.
That is where we all.
How the court can now this court? How the court can act?
Let's see the inquiry of mean profit. That kind of a proceeding. We will
see inquiry. What has happened? Men's profit. I have several orders. Yes. Correct. Min profit. Preliminary decree pass. Min profit. Inquiry. Report. Submission of report.
Yes.
Correct.
There not somebody
inquiry. That is inquiry. Here, what the decided
claims, counterclaims.
Appointed according to terms of service report within this. Damage company may wait out in the suit. Adjudicate the claims. If it is adjudicated,
then
it is not a report. Once it is adjudicated, whether it can be said that.
I understand that because we all have the same confusion. Only thing I am saying that when parties are consenting, this can be resolved here, the Lordship. No, that is a.
Clarify.
I go to appeal court. Appeal court will let's say it's 2018 order.
If the both parties, my lord, arrive at the terms of appointing the special referee as an arbitrator, then it could have been done.
That's correct. That is different.
That is a different thing.
That is different thing. That is either 89 or 8.
Or Miller even commission.
18 or either 89.
You can record evidence.
I can record evidence as a commissioner or a referee.
That is evidence recording. Adjudicate. That's why striking this.
I know, Miller. I know this. We all stuck with the same confusion.
If the special officer file the report adjudicating that you are not entitled for that, can this court interfere in that? Can this court interfere in that? Or how this court can accept that report?
Can't be, my lord. I do not have the power.
So that is why we thought of mentioning this and getting it started.
But they are not taken when the order of 2018, 5 years.
I know. Now today, if you go to appeal court said that both the honorable judges were there none of them are there now.
Nobody is there.
Yes, nobody. So appeal court will say we were not party to the. So you file terms before a court division bench. Whatever division bench felt good, pass the order. Now the only solution probably is the consent of parties at this stage. That let the evidence is over, let it be filed before the court.
But law is also to be seen. The order is to be.
But I know, but we not. If another bench, I do not know what will happen. Lordship is here, and parties are consenting. Lordship can and I'm sure Mr. Ghosh as a special referee will be very happy to hand over the files to the court for adjudication. He on from the first day is saying, what am I to do with this matter? Am I supposed to pass a decree? I am not a judge yet.
In fact, Lordship, because I come myself and mention once. Your Lordship will say you record the evidence, but I can't modify the division bench's order.
That is because I can this court even today. Suppose see the simple way. Today I accept the submission of both even consent. With the consent of the parties, whether the higher authority judgment or order can be modified by this court.
Even otherwise, even if they consent, they cannot vest me with the power to pass a decree.
That is all. That is a second aspect.
Either that consent was there, it seems not, but then that was a meaningless consent because court, I am by consent, I cannot ask any individual to pass a decree, but now that we are before your Lordship, parties are consenting. This can be resolved, if Lordship only the evidence is over, complete. So let a report be filed then. If we come and argue this matter, we'll forget as if he acts as a commissioner. So we forget that order of completion. Remaining part will remain. But in any event, the terms have been already acted upon.
Is it non-commercial?
Yes, non-commercial. We have handed over possession, received a portion, remaining portion is with the court. So my lord, I am either to get the remaining portion as a decree or he is to get my lord, rent from
Go
me.
and take the clarification, sorry. Yes, next.
Very well, I'll try once then I'll come back to because I know I have to come back to your lordship only.
Come with the clarification, no problem.
Very well, sir. Grateful.
My lord, I appear for the petition in item number 6, my lord. My lord, my application to withdraw the bank guarantee, my lord. Suit has been decreed, counterclaim dismissed, my lord. The decree
last occasion.
Yes, my lord. And may I hand up the affidavit of service?
Have you served?
Yes, my lord. I have served directly on the parties, my lord, through mail as well as through post, my lord. The affidavit of service is ready.
Yes, where is the decree?
My lord, the decree is on, my lord, page 35, my lord.
35.
Order dated 26th of July 2017.
35.
Page 35, my lord. And my lord, the
operative
page
portion.
39 also, my lord.
No, where is the operative portion? 35.
My lord, kindly comes to page 37, my lord. My lord, the second paragraph, may I place it, my lord?
Yes.
Upon such circumstances, the defendant number 1 shall deposit Indian money equivalent to $11,349.50 with the Registrar High Court original site and shall also deposit the amount representing 0.75% more of the contract value upon receiving payment of with the ONGC with the Registrar High Court. The advocate on record for the defendant number 1 shall intimate receipt of payment to the advocate on record for the plaintiff within 2 weeks from the date of receipt of the banker of ONGC shall deposit the amount with the Registrar High Court, my lord. And thereafter, my lord, by the order dated 1st of April 2019, passed by Honorable Justice Orijit Banerjee, my lord, that records, my lord.
Page number?
Page 39, my lord. My lord, the first paragraph, my lord. By an order dated 13th of September 2000, my lord is
yes.
39. My lord, by an order dated 13th of September 2018, whereby GA number 13 of 2018 was disposed of. That was my application for summary disposal, my lord. The plaintiff was granted liberty to obtain release of the amount deposited with the registrar original site by the defendant number 1 upon furnishing an unconditional bank guarantee for the said sum on an undertaking that such bank guarantee shall be kept renewed till the disposal of the suit, my lord. That has been kept renewed, my lord. It has only expired on 22nd of April 24, my lord, during pendency of the application. And my lord also comes to page 41, my lord. That is my lord's order dismissing the counterclaim filed by the defendant number 1. My lord, because there was a counterclaim, my lord, I had to furnish a bank guarantee to withdraw the decretal proceeds, my lord. Now the counterclaim has also been rejected by my lord.
Where is the bank guarantee?
My lord, that is on page 43, my lord.
Yes. Yes, sir.
Are you discharging court? Immediately, no response.
Consistency appearing for the plaintiff. Consistency appearing for the defendant number 1, but has filed and but has submitted that he may be allowed to discharge from the instant case as an advocate of the defendant number 1. He has also submitted the affidavit of service showing the notice submitted upon, served upon the defendant number one, but in spite of, through the email, but in spite of service of the notices, no instruction has been provided to the learned counsel by the defendant number one. The plaintiff has also filed affidavit of service in terms of the order dated 2nd May 2024, showing the notice served upon the defendant number one, informing the date of hearing, but in spite of the notice, none appears on behalf of the defendant number one. Let the affidavit of services be kept with the record. The learned counsel for the defendant number one is discharged from the instant case. The plaintiff has filed the present application being GA5 of 2024, praying for an order, praying for leave to withdraw the bank guarantee being number 0505219 capital P capital G 0000629, lying with the registrar, insolvency of this court, which was deposited by the plaintiff in terms of the order passed by this court dated 26th July 27. Counsel for the plaintiff submitted that in terms of the order dated 1st April 2019, the plaintiff was granted liberty to release the deposited amount deposit by the defendant number one by furnishing an unconditional bank guarantee for the said sum on an undertaking that such bank guarantee shall be kept renewed till the disposal of the suit. What about the suit?
My lord, suit has been decreed, my lord. My lord, my lord kindly comes to page 24, my lord. The order dated 13th
The suit filed by the plaintiff was disposed of.
My lord, GA 13 of 2018 was my application. My lord, page 24.
Disposed of by an order dated 13th September 2014.
2018.
By disposing of GA 13 of 2018. But the suit continues as the defendant had filed the counterclaim. By an order dated
22nd February 24, my lord, page 31.
By an order dated 22nd
February 24.
Page 41.
31, my lord.
By an order dated 22nd February 2024, the counterclaim filed by the defendant number one is dismissed for default. And as such, as on date, neither the suit nor the counterclaim is pending. As suit along with the counterclaim has been disposed of, accordingly the plaintiff has filed the present application for release of the bank guarantee submitted by the plaintiff in terms of the order passed by this court. Consider the submission made by the counsel for the plaintiff produced the orders. This court find that by an order dated
26th September. My lord, perhaps page.
That the 1st April 2019, this court has allowed the plaintiff to withdraw the amount by furnishing the bank guarantee, furnishing unconditional bank guarantee, and the same was complied with. But the said bank guarantee is to be continued till the disposal of the suit. Now the suit has been disposed of, and thus this court find that there is no impediment by allowing the plaintiff to withdraw the bank guarantee which is lying with the registrar insolvency of this court. In view of the above, the registrar insolvency of this court is directed to release the bank guarantee number 0505219 capital B capital G 0000629 to the plaintiff with the proper identification within a week from the date of receipt of the request from the plaintiff. Grateful. Grateful. We have the above GA 5 of 2024 and disposed.
Your Lordship, I am for the plaintiff. On the last occasion, the defendants were supposed to give the details of the survey.
Valuer, my lord. Valuer.
Yes.
Yes.
Given, my lord, the fee structure and the scope of work.
Given.
Yes, my lord.
Yes, Your Lordship. May I appraise Your Lordship with the facts? Initially, Your Lordship, may I hand over a copy? Initially, the surveyor that was appointed by the commissioner, may I hand over the credentials and the cost of that surveyor, Your Lordship? It was around 4,25,000.
It is your
Not mine. That is the commissioner who had appointed.
Yes.
Not the commissioner, my lord. With the consent of the parties, it was appointed.
Yes.
Commissioner had appointed with the
Whatever
consent
it
of the
may be,
parties.
commissioner
but it was
appointed,
not.
both all the
Yes.
parties are given
Yes.
consent, subsequently one party
Yes.
will back down.
Yes. Now, what happened? The other parties, they had objected with regards to the cost. And so they had initially given the details of the same surveyor, the details of which has been provided today. And at that time, they had said that the cost of it will be 40,000. Now they have further again served us a copy on 29th April 2024, wherein the professional fees they have indicated is 3,50,000. My contention, Your Lordship, between the earlier surveyor and this survey, there's hardly a difference of 1 lakh. There are 5 parties, which would be around 20,000 difference. So cost is not a factor, my lord, and the credentials was better with regards to the previous surveyor. And also, since it has been appointed by the commissioner, there would be no element of bias or element of any other disputes between the parties. So our humble submission was
Where is
let the previous.
Where is the report? Where is the further?
This is the fee structure. The copy.
Yes.
Similar as that, my lord, only the value is less.
What here? See, it is. Give it to me. This is the way.
This is not.
Yes. So now what is the total? 3,50,000.
Yes.
And the earlier was 4,25,000, Your Lordship.
Four lakh 75,000.
4,75,000.
75,000.
Yes.
I stand corrected, Your Lordship.
Yes.
There's a difference of 1,25,000.
Yes, Your Lordship. So with regards to 5 parties being there, if it is divided equally, not much of a difference is coming, Your Lordship. We are
25,000
humbly
is not
praying.
less.
We are humbly praying that the previous surveyor who was appointed by the commissioner on consent of the parties, may that person be continued, Your Lordship. That is our contention.
The cost of the.
Okay,
Yes,
do
we
one
bear-
thing. The court is appointing is the listed commissioner. What
Yes,
was
Your
the cost? Either 5 lakh, 10 lakh,
Yes, Your
whatever
Lord.
it may be.
We are
Bear
agreeable to
cost
that
has to
also. We are
bear the
agreeable
cost.
to that
The
also.
cost has to be bared by the parties, my lord.
That's why
But
if you are not coming to the conclusion, they are not coming to what the court will do.
let the commission.
Your Lordship, I have
decide
instruction.
at
Your
least, my
Lordship
lord,
can
the-
also appoint.
my lord, they had objected that this valuer has not given the
That's
scope
why
of
there
work.
is a difference
But
between
this is
the
the
parties.
same scope of work, only less value, less cost.
That's
So what
why
is the difficulty in the less cost? Why will I go to the higher cost of the same work? That is the problem with the parties are facing, my lord. 25,000 is not less for someone who is at the flag end of their life. They are over 70 years old.
Okay, this court is appointing a commission.
I would kindly
You
give
are
some
grateful,
time
Your
to take
Lordship.
instructions in this matter then, my lord.
What
I have
instruction?
to take
Court is
instruction.
passing an order if the
My lord.
parties are not coming to a conclusion.
Yes, Your
Whether
Lordship.
the parties can pay the higher cost or not, my lord, that has to take.
It is
my
there. If it is not paid, then the suit will be pending. What can be done? If it is not paid,
I
not
will
paid.
kindly keep it the next week then.
Your Lordship, I have
Take
instructions. If you are
instructions
agreeable,
for-
my lord, please kindly
But
appoint.
I have to take instructions whether they can pay that value, higher cost, my lord. Higher cost, the previous value of what has been stated, 4,75,000. 3,50,000 is reasonable, my lord. Why?
That is correct. This court is not going to decide 3,50,000, 4,75,000. This court, if the both party consent, then only the officer is to be appointed with the consent. If not consent, the court will appoint. And
Yes, my lord.
the engineer will give the bill and the party has to bear the cost.
My lord.
That is the problem, my lord. Yes.
What is the problem?
The money is the
So
problem.
you are not coming to the conclusion.
Yes, my lord. I have to take instruction whether they can pay the 4,75,000 now. Now I've got the opinion of the court, my lord. I shall say that.
Take the opinion, otherwise the court will appoint.
Yes, my lord. Keep it next week.
Grateful, Your Lordship.
Grateful, man.
So and so appearing for the plaintiff, so and so appearing for the defendant. You are for the defendant.
Yes.
The defendant has submitted the details of scope of work.
The valuer, my lord.
And
proposed
the counsel for the defendant submitted the scope of work provided by the valuer. Is the valuer
Yes,
or
my lord.
engineer?
Valuer, my lord.
Valuer.
State valuer, panel valuer
Valuer.
of the Calcutta High Court.
Showing the total fee would be rupees 3,50,000. The earlier, the valuer appointed by the partition commissioner has submitted his fee of rupees 4,75,000. Counsel for the plaintiff, and you are appearing for?
Your Lordship, plaintiff.
Counsel for the
Is it-
plaintiff submit that there is no such difference between the cost and the remuneration and between the fees quoted by the valuer appointed by the learned partition commissioner or the valuer proposed by the defendant and submits that the valuer appointed by the learned partition commissioner may be allowed to continue the work. Full stop. The counsel for the defendant raised the objection and submit that the proposed valuer appointed by the defendant has given the low fee structure, and as such he may be appointed as valuer. This court find that there are differences between the parties and both the parties are not coming to the conclusion for appointment of a valuer with respect of their respective fees. And as such, the counsel for the defendant, full stop. The counsel for the defendant prays for time to take instructions whether the defendants are agreeable to appoint the valuer appointed by the learned partition commissioner who has given the fees structure of rupees 4,75,000. It is made clear that if the parties will not come to the conclusion with regard to the appointment of the valuer for partition of the suit property, this court will no other option to appoint the valuer by this court from the approved valuer which is available with the court. Let the matter appear on non-commercial matter.
Yes, ma'am. 15th.
Let the matter appear on 12th of June 2024.
I will keep it on June.
Okay, I am fixing. Let the matter appear on 9. Today we are on 9th, 15th of May 2020.
Grateful, Your Lordship.
Deeply appreciate.
Next.
My lord, only one thing, my lord, the original letter that was given.
You submitted, you're not having.
But I'm giving a photocopy, my lord. I do not have the original. That was the original submitted by the valuer.
The original will be there. You take the Xerox copy. You're not having the Xerox copy.
No, I do not have. That is.
Take and give the.
I'm giving.
Yes.
My lord, in item number 8, I am appearing for plaintiff, my lord. This matter has been came up for our instance, my lord. This matter was actually very embarrassing situation. The old advocate record was not giving old advocate record, my lord, was not giving the no objection. That's why this matter was mentioned, my lord. So now the plaintiff have paid the entire amount, whatever the previous advocate record has claimed as a fees, my lord. So presently they have promised that as soon as the check will be cleared, they will give no objections. So my lord, kindly keep it after a vacations, even though in the meantime all the formalities will be, my lord, completed, my lord.
I'm appearing for victim or this other old advocate.
Though the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff.
Plaintiff, my lord.
Plaintiff, but the counsel for the plaintiff prays for fixing the matter after vacation. Let the matter appear on 12th June under the same heading.
Much of it. Similar order may be passed in the next matter, my lord.
9 also?
9, well, same.
9 also same.
Much.
Okay. These are 10.
This has come up at my instance.
Yes.
Suit for specific performance of agreement for sale. Lord, during the pendency of the suit, Lord, defendant number 2 expired, leaving behind the heirs, brother and sister. Lord, they are already on record. Your lordship had passed an order, Lord, directing expunging the name of the defendant number 2. Now, Lord, there was a subsequent correction with respect to Lord the notice of motion and master summons. But unfortunately, that was passed on Lord 19th of December 2022. Lord, unfortunately, the time for Lord carrying out the amendment of this expunging of name expired Lord within the time frame provided in the 29th of November order. Lord, only extension would be required, Lord, so that this innocuous amendment may be
29th of November.
My lord. Only the name has to be expunged, nothing more than that.
That order is passed.
That order is passed, but the time frame, my lord, has expired. That has to be extended.
Where is the order?
Lord, the order. Copy name.
There's no order here. Because
Lord,
that is an interlocutory application. This
Lord,
is
kindly excuse me, my lord, but I have, my lord, if your lordship, my lord, permits me, my lord, I have, my lord, a net copy of 29th order. This is the order of correction, and my lord, this is the original order. 29. I'm kindly excuse me, my lord, I should have, my lord, carried out. So, no objection. Retire.
Yes. So you're not carried out.
Lord, that is the Lord. Fault on our part, Lord.
November 2022,
Lord,
sir. Now we are on 24.
Yes, Lord.
Lordship, one thing. I'm appearing on behalf of the defendant number 1 and 3. Lordship, I've been trying to contact my clients, but they are not responding, Lordship. Lordship, kindly note my submission that I'm retiring from the brief, Lordship, on the matter.
Only to be mentioned, only correction. When the suit will come, I am not taking a suit. Only mention.
Lordship,
When the suit will take, you come.
Lordship, great.
So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has and the plaintiff. You are for the plaintiff.
I'm for the plaintiff.
Plaintiff has mentioned the matter for extension of time to carry out the order dated 29th November 2022. In view of the submission made by the counsel for the plaintiff to carry out the order dated 29th November 2022 is extended for a further period of 2 weeks from date.
I'm grateful. 2
weeks from date.
I'm also grateful, Lord, for permitting me to use the mobiles.
Nowadays the electronics.
I'm grateful.
My lord, before 11 start, my lord, item number 7, that copy I have taken PDF.
Give.
Lordship, I appear for the defendant number 1.
Yes, who has mentioned?
I'm appeared for the plaintiff, my lord. It is not appearing at my instance.
Why?
I was not mentioned. We
Because
have
my lord,
not
this
mentioned.
case already disposed of on 2nd of May.
I
don't know why it's appearing in lordship's list, my lord.
None of us has mentioned the matter.
Acha, no. Acha, this one, no? That Mr. Manakdar.
Yes.
Where is he? He filed one application making some submission. When I was going to pass an order, signing the journal, I find that there is what he is making a submission, that is not an application. That's why I fixed the matter today as to be mentioned. Where is Mr. Manak?
He's not in another courtroom, my lord. Then kindly fix it on Monday, then, my lord, if any clarification is required.
Because I dismissed, but subsequently when I signing, I'm checking that what he is submitting, that is different than the application. Yes, madam. What is the problem only with regard to the see?
Remuneration.
Huh?
With regard to the remuneration of the receiver. Your Lordship will kindly see the 14 January 2021 order. Lordship, page 2.
Page 2. Yes.
Lordship, page 2, the plaintiff will pay the initial remuneration of 2000 GMs to the learned receiver at the first instance.
Correct.
This was the first order. And then subsequently, this is the second time they had made an application for appointment of receiver. And the order is of 26 July. And your Lordship, it is not mentioned that who will pay the remuneration amount.
Correct. That's why I'm clarifying, because this that is with regard to the preliminary one.
Yes.
Now it is the final one.
2020.
It is because this officer has been appointed, receiver is appointed, so that the final decree can be passed. Kindly come to that.
Lordship, this receiver is not appointed in accord with regard to the passing of final decree. This
with regard to the all the things is to be what the court has given is, kindly come to the page number paragraph 17, paragraph 19. As per the report of the receiver and as per the contention of the defendant number 1, the building in question is dilapidated condition, and if all the parties are ready and willing to repair the said premises, the same shall be informed to the receiver and presence of the receiver, and after the approval of municipal corporation can be carried out by the parties. So if it has been carried out by parties, so all the parties will be benefited. If all the parties will be benefited, the fee is to be borne by all the parties.
Lordship, this is not only with regard to the repairing of the dilapidated condition of the. Kindly come to paragraph 18.
Yes.
It is found that the.
With regard to the rent.
Yes.
The rent also, if the rent is collected.
How many tenants are residing? What is the occupational charge? They will induct new tenant. This was their prayer.
That's why that is also for the benefit of all the persons.
Yes, it is all benefit for the
50,000 3% for 17,000 will become.
And it has fallen from your lordship to pay for to bear all the fees by equally by all the parties.
That's why I have not recorded. Now there is a confusion, then I will clarify. It will be
equal. The confusion arose because there is no specification.
That's
and
why I will.
In the earlier order, it was specified that the plaintiff will pay because it was their application.
Correct. That is their application.
Yes.
2000.
Yes.
Now here is this liberty has been given to all the parties. If the rent is corrected, the details of the tenants will come. That will benefit to all the parties at the time of partition of the property. Because whatever the rent is collected, that will be deposited in the receiver's account, and at the time of partition, it will be decided amongst all of you. It is not the defendant will take, and with regard to the repair also. If you will repair, the receiver will
the repair, Lordship, we had said that we will do the repair on our cost because they were not.
No, their cost, there is no. I am not with regard to cost. The fee of the receiver. The receiver, you have to give the intimation to the receiver,
yes,
and the receiver will see whether the proper work is going on because of the disturbance by each and other parties. Because all the parties are distributing with regard to the repair and all these things.
Yes,
So
yes,
that is to be
they were
carried out.
disputing, yes.
They disputed. So
Yes.
that is to be carried out in presence of both the parties,
Yes,
in presence
yes.
of the receiver.
Yes.
So receiver has to do the work for all the parties, not for the one.
That is true, your lordship. Lordship, the problem was that since there was no mentioning, I am answerable to my client.
So I
No,
am
my client is,
clarifying.
yes, my
I am
client is
clarifying that.
asking me.
And with regard to the name also,
It will be MANIK.
Manak, and another thing is then
I think paragraph 20.
and with regard to the family members, which is in possession of the defendant.
Actually, what my lord
And they
is-
come to the
Paragraph
page
18.
9, page 9, paragraph
Paragraph
2.
18.
Or you are having the order? Paragraph 18.
Yes, your lordship.
Receiver shall not disturb.
Paragraph 18. The receiver shall not disturb the possession of defendant number 1, which is in possession of defendant number 1, not the family.
Not the family member. That's it, my
Which
lord.
is in possession of the defendant, not the family. That will I clarify.
That's it.
Correct.
They are not occupying there. They are not
So that I
residing
will
over that
not-
premises.
That premises cannot be occupied because it is in very dilapidated
Not
condition.
occupy, not occupy. If it is occupied,
It is not
because
in habitable condition
because as
to
per
be
one
occupied.
report of the special officer said this person is this person is this. That's why I am telling. If it is that,
Lordship, in the receiver's report only it is mentioned that here.
kindly come to the page 33.
Lordship, 33 is the tabular sheet.
Tabular sheet?
So, not in the tabular sheet. In the paragraph, it is mentioned that inside the structure, paragraph 9, that inside the structure of main door 1 as annexure 1 of the instant report, we found to be in extremely dilapidated and dangerous condition.
So that's it.
It is already noted by the receiver.
Okay, no problem. So I will clarify these 3.
These 3, my lord. That's it.
I will clarify these 3 points.
Grateful, my lord. Good.
Yes, next. Hey, Manutosh, वो ना मेरा ऑफिस में भेज दो, बना के रख दो। मेरा ऑफिस में भेज दो, ऑर्डर बना।
Lordship, this is my application. Lordship, this is an application for appointment of a joint receiver in respect of a trust estate. There was a dispute because the voting had been done. 31 people had selected my client. 17 had selected my learned friend's client. Now the dispute has been resolved. May I file a supplementary affidavit? Lordship, in this we have come to the meeting. The minutes of the meeting has been enclosed. Lordship, we have agreed that both should be joint receivers appointed. Your Lordship, the initial minutes is at page 13 of the application. And the subsequent minutes is in the present application at
page 13.
Yes, my lord, of the application of the originating summons.
नहीं चलता है क्या? ऐसे नहीं चल रहा. Yeah, this is a report.
Lordship, the first minutes is at page 13.
Yes.
Alok Krishnadev, as receiver of the above estate, chaired the meeting. He was one of the receivers. He is of advanced stage 85, so he wanted an additional receiver to be appointed to administer the estate. Lordship, your Lordship will then take the next paragraph. As per notice given to all Shebaites, Alok Krishnadev described and requested the Shebaites to select 1 or 2 fit persons among the Shebaites as joint receivers to help him to continue the Shiva Pujo of Sri Gopinath Jew smoothly and regularly, and other matters of Thakur and Thakur Badi. Accordingly, 31 number of Shebaites have selected Devashish Krishnadev and 17 numbers of Shebaites have selected Shumit Krishnadev as first preference and second preference respectively. So the application was made for appointment of Shumit Krishnadev, I'm sorry, my lord, Devashish Krishnadev as the joint receiver. That was the original application. Lordship, today we have come to a consensus because of the advanced stage. The erstwhile receiver, Alok Krishnadev, wishes not to continue any further, and the joint receivers should be appointed.
Where is the order earlier? By the order of this court?
Lordship, the appointment, original
Alok Krishna Dev was appointed by the order
appointed
of this
pursuant to
court.
order of this court, Lordship.
Where is the order?
Lordship will find the order dated 29 January 2013. It's at page 10 of the application, my lord. Your Lordship will find the second paragraph. Mr. Alok Krishna Dev, one of the Shabaits, is appointed as receiver in place and stead of Mr. Roy Chaudhary.
Earlier, Mr. Gauraj Chaudhary was there.
Yes, my
Then
lord.
in place of Mr. Alok Krishna Dev was appointed.
Yes, my lord.
Okay, now he has taken the resolution.
Yes, my lord.
So-
Lordship, I have specified in page 4, paragraph 4 of my application as to why this change is being sought for. He is 85 years old.
Application of the main application?
Main application, my lord.
Yes.
Lordship will kindly see, I am 85 years old and suffering from various age-related ailments. He's unable to basically sign, because of which the checks are not being passed.
Suffering from various agents, I have been able to carry out. So here he stated that he is ready and willing to work as a joint receiver.
Yes, my lord.
So now you said that no, he should be discharged.
Yes, my lord. Lordship will find that at page 6.
Yes.
Lordship, of the supplementary affidavit. He now comes and says, Sri Alok Krishna Dev apprised the assembly of his advanced age, 87 years.
Page 6.
Lordship, page 6 of the supplementary affidavit, my lord. Lordship will take the second paragraph.
Yes.
Sri Alok Krishna Dev apprised the assembly of his advanced age of 87 years and deteriorating health conditions encompassing hearing impairment, vision impairment, and mobility challenges. Citing these challenges, he conveyed his inability to continue serving in his current capacity. Thereafter, the two people have jointly been appointed as the joint receivers.
Debashish and Sumit.
Lordship, Devashish and Sumit. Devashish Krishna Dev and Sumit Krishna Dev. Lordship, this is
Proposed to be appointed.
This is jointly accepted by all the 31 Shabaits.
Where it is? How many Shabaits are there? 31?
Lordship, there is 31 Shabaits. Your Lordship will find that again at page 13 of the original. I'm sorry, my Lord, there is 48 Shabaits.
The 28th, the meeting was.
Yes, my Lord.
AGM was conducted on 28th, were present. So what about the others?
Lordship, it's by the members present, the Shabaits present have agreed to it. And the only contesting candidate is my learned friend's client who has consented because he has also been appointed. Originally, it was
for different number 9, your lordship.
both the parties were named. One got 31 votes, one got 70 votes. Now both of them have been made jointly the receivers.
So you are the defendant number 9.
Yes, your lordship.
What is your name?
Subhasis Krishna Dev, your lordship. Subhasis Krishna Dev, your lordship.
But you are not one. Sumit and Devasis were appointed.
Yes, I appear for Devashish Krishna Dev.
No.
Lordship, number 13 is Sumit Krishna Dev.
13 is Sumit.
Yes, my lord.
And second is the Devasis.
Devashish, I am appearing for.
Where is the Devasis?
Lordship, number 8.
Devasis. And he is appearing for the Subhasis. Subhasis has not been appointed.
Lordship, Subhashish has not been appointed. 13 has been appointed. Sumit Krishna Dev.
Sumit was appointed. So what is your contention?
No, I'm not contesting, your lordship.
You're not contesting?
No, your lordship.
You have no objection?
No, your lordship.
If these two persons have been appointed jointly in place of Mr. Alok Krishna and he will be discharged.
Yes, your lordship.
And what about the accounts and all these things?
Lordship, all have been disclosed. Your lordship will find that we have also specified that in the main application. of the assets that are lying in my, and the accounts were filed regularly in court. Your lordship will find all the assets you have disclosed at paragraph 5 at page 6, my lord.
Yes.
I'm sorry, my lord, paragraph 6. The assets that are being handled by me are as follows. The details of all the assets have been disclosed.
Okay. Okay.
And lordship will find page 7, paragraph 7, filing of accounts in the honorable court from time to time in respect of the dealings and transactions made by me relating to the debtor estate. All accounts have been filed, my lord. Your lordship will, in fact, we have also annexed at page 13. Lordship will find annexure B. We have disclosed the accounts that we have been filing. I'm sorry, page 12, my lord. The accounts also we have disclosed.
Yes. So who has filed this application? Ashok?
Lordship Alok Krishna Dev had filed this
You
application.
are appearing for?
Lordship Alok Krishna Dev, as also now the affidavit has been filed by one of the appointed receivers. That's been.
No. Who is appearing now? You are appearing for the Alok?
I am appearing for Alok Krishna Dev, the erstwhile receiver, as also was Shri Debashish Krishna Dev. We filed the supplementary affidavit of Alok Krishna, Debashish Krishna Dev.
Alok Krishna, the present application being CSOS.
Lordship originating suit.
The originating someone.
Lordship, it's interpretation of the trust deed.
The present originating summons, CSOS originating summons, CSOS 4 of 2022, filed by Mr. Alok Krishna Dev, son of late Dinendra Krishna Dev, Dinendra, D-I-N-E-N-D-R, Dinendra Krishna Dev, who was appointed by this court by an order dated 29 January 2013 as receiver of नहीं क्या बोला कृष्ण देव no Alok Krishna this no, who is one of the Sibayat is appointed as receiver by this court in TA number 15 of 2013 with TA number 30 of 2013 dated 29 January 2013 in place and instead of Mr. Gaur Roy Chaudhary, barrister at law and receiver, by discharging him as a receiver with effect from 1st December 2012. Now, Mr. Alok Krishna Dev, the receiver appointed by this court, has filed the present application. Praying for to select one or two fit persons amongst the Sibayats as joint receiver to help him to continue Seva Puja of Sri Gopinath Jew smoothly. Gopinath Jew smoothly and regularly, and other matters of Thakur and Thakur Bari. Full stop. The Mr. Alok Krishna Dev has filed the present application due to his old age and suffering from various ailment. Subsequent to filing of the present application, comma, another joint affidavits have been filed by
Only a single affidavit. It's not a joint affidavit.
another affidavit has been not joint. Another affidavit has been filed by Mr. Devashish Krishna Dev, also known as Devasis DEPASIS. This one, 3. Who is the respondent number 8 in the present case? Praying for appoint him as well as where he has given the name of the other person. He has not given the name of the other person.
Lordship will find that page 6 of the supplementary.
That is the minutes. But in the affidavit, he has not stated anything.
No, my lord, in the affidavit, he has not stated
Not
anything.
stated.
Only the minutes have been disclosed to show that this is the consent which has been agreed upon.
But he has to submit here.
Lordship, Alok Krishna Dev is not capable of coming to court. That's why it's been done by them.
No, not joint. Another applicant, another affidavit has been filed. Joint na. Another affidavit has been filed. 8. Praying for appointing him as well as Mr. Sumit Krishna Dev, who is the respondent number
13.
Who is the respondent number 13, and both are the Sibayats to be appointed as joint receiver in place of Mr. Alok Krishna Dev. In CSOS 4 of 2022, a minutes of annual general meeting held on 7th March 2021 is annexed as at page 13, wherein it is recorded as follows. This one, page 13, first paragraph, set up. Subsequently now, the Devashish Krishna Dev has filed an affidavit by enclosing the annual general meeting held on 26/11/2023, which reads as follows. This one, page 6. Not page 6. This one. Consider the submission made by the counsel on full stop. The counsel for the respondent number
9, your lordship.
Respondent number 9 submits that he has no objection for discharge of Mr. Alok Krishna Dev as receiver and to appoint Mr. Devashish Krishna Dev and Sumit Krishna Dev as joint receivers of Had the learned counsel for the respective parties perused the application and the documents. This court, by an order dated 29 January 2019, appointed Mr. Alok Krishna Dev, who is one of the Sibayat, as receiver. Now, the Alok Krishna Dev has attained the age of 83,
87, my lord.
87
Today
years,
he's 87.
87 years, and is not in a position to act as a receiver due to old age and various ailment, and accordingly, initially a annual general meeting was held, wherein the Alok Krishna Dev was of the view that along with him, 2 joint receivers should be appointed. But subsequently, another annual general meeting was held on 26/11/2023, wherein it has been decided that Sri Devashish Krishna Dev and Sri Sumit Krishna Dev, who are also the Sibayats of Sibayats, may be appointed as receiver, discharging Mr. Alok Krishna Dev as receiver. Full stop. In the application, in paragraph 4 and paragraph 6, the details of assets and the obligations which is to be carried out, and the assets of the assets of in paragraph 5 and paragraph 4, in paragraph 4, the duties and obligations of the receiver has been mentioned, which Mr. Dev, Alok Krishna Dev was carried out as receiver, and he has also given the details of the assets in paragraph 6 of the application. He also mentioned that he is submitting the accounts, details of the accounts before this court from time to time. Considering the above facts and circumstances and the meetings of the annual general meeting dated 7th March 2021 and 26
November, my lord.
26 November 2023, this court finds that the decision has been taken by all the Sibayats in the general body meeting dated 26th of, where is that?
November
26th of November 2023, that the Mr. Alok Krishna Dev should be discharged due to his old age and ailment, and Mr. Devashish Krishna Dev and Sumit Krishna Dev should be appointed as joint receivers. Accordingly, Mr. Alok Krishna Dev is discharged as receiver, and Mr. Devashish Krishna Dev and Mr. Sumit Krishna Dev have been appointed as joint receivers. The joint receiver from the date of this order. Full stop. The Sri Alok Krishna Dev, the outgoing receiver, is directed to hand over all the documents and the details of the assets and the reports and the details of the report submitted by Mr. Alok Krishna Dev before this court to the incoming receivers within a period of 2 weeks from date. Full stop. The joint receivers appointed by this court, the joint receivers, namely Devashish Krishna Dev and Sumit Krishna Dev, shall carry out their duties and obligations as mentioned in paragraph 4 of the present application and also to file their quarterly report before this court from time to time without fail. In view of the above, CSOS number 4 of 2022 is disposed of.
Would it be your lordship's pleasure to record that the summons as per rules was served on all the Shabaits?
That earlier order it was not required.
Perhaps not recorded. But we filed the affidavit of service. It records service on all of them.
The affidavit of service showing that the notice of writ of summons is served upon all the Shabaits be kept in the record.
Lordship, it will be on the originating summons itself,
Also,
because on the originating summons,
originating summons be kept with the record. Not writ of summons, originating summons be kept with the record. ठीक है? Without any without fail.
Review, your lordship.
Well, item number 13, I do appear for the plaintiff, my lord. Now, this is a suit for eviction, my lord, and an unusual thing has happened. Suit framed, my lord, the original tenant has died, 5 years have expired, the son does not have a right to stay in the property. Now, the son appeared in the suit and contends that the father is still alive. We have opposed that, no, because our specific information was that the original tenant, the father of the present party who is appearing, has died 2016. Now let them bring some documents to show that life certificate of.
Why mentioning?
My lord, this is my application, my lord. It is coming at my instance. I have filed an application under Order 7, Rule 11 for dismissal of the rejection of the plaint and dismissal of
So
the
why
suit, my lord.
mentioning?
My lord, it has, since it's ready for hearing, I have mentioned it for it to be taken up for my lord's consideration. Because it's a very short point. My lord, the issue is whether the person is dead or alive, the tenant is alive. And there are documents to that effect, the person is alive. And they have gone on the premise that that person has passed away. So the cause of action for the suit itself is barred. And it is also barred by law on other issues as well. My lord, it is completely barred. So I am only
So what is your application?
My application is for rejection of the plaint. Order 7, Rule 11, my lord. It does not.
My opposition.
Item number 13.
13, my lord.
J1 is not on record, not in the list.
But my lord,
GA3. Who has filed the GA4? What is the GA4?
GA4.
My lord, it's GA4. My lord, in my notice of motion, it's 4 kore din. The application shows 4. It should be GA4, my lord. It is my application appearing in my instance, my lord.
The pleadings completed.
Pleadings are complete. And I fix it for hearing any date.
I can cut it down the matter short, my lord. My lord, whether a person is live or dead, my lord, that cannot be decided in Order 7, Rule 11. I can cut down the matter short if they bring up with certain documents, my lord, that he is alive. Then we will take another.
Why not the person should bring before this court?
That can
with the proper identification.
Absolutely, my lord.
That's all.
Now let me fix it date, my lord. I'll have the person.
How the document can be created, but the person cannot be created.
That is also.
We will show, my lord. We've sought leave to crave on reliance on all the documents, and also the person can remain present. He may remain present virtually because he's unwell, but my lord, he's 78 years of age. He's recently been discharged. If my lord is
where he is residing
in Bangalore, my lord. My lord, sorry, my lord. In Hyderabad, he's gone there for treatment, my lord. So he's staying there with his.
Where is the permanent resident?
No, the permanent residence is
Kolkata. As per
Central
your case,
Avenue.
As per your case, he is residing in the suit property as a tenant.
No, he's using it as a shop room, the suit premises.
Correct. So he is using a suit premises, residing.
My lord, presently he's residing in Hyderabad.
Presently residing for the treatment.
Yes,
when he will be back?
My lord, presently he's staying there for some time.
Okay, I am fixing in the month of June. After vacation, let he come.
I am agree.
In the meantime, come.
Virtually, you can. Yes.
Well, if my lord permits, he will be present virtually. I'll show reports. There are reports from medical reports and doctors' certificates.
So that all the thing is to be proved, not by documents, medical document, life certificate, that is to be proved. If the person is come and with all the original documents of the identification, if it is
My
right,
lord, his son may remain present. He may join virtually with all the documents because he's in Hyderabad. My lord, commuting him from Hyderabad may be a problem. And secondly, my lord,
plaintiff census and suffering for the defendant. Full stop. The defendant has filed an application praying for rejection of plea. The counsel for the respective parties submit that pleadings have been completed and matter is ready for hearing. In view of the submission made by the counsel for the respective parties, let the matter appear on 19th June 2024 under the heading adjourned motion.
If they can bring it, my lord, in the matter will be.
Yes.
And my lord has given a very.
there are the person has not been made a party.
Let us see. That's why I have not passed any order. Let me see the what is the black and white in your application, then we'll see to that. क्या fix? What?
The reply, man.
Reply filed by the plaintiff defendant. Defendant be kept with the report. Yes.
The next matter, the other side has mentioned to fix a time, my lord. If your lordship just takes it up.
Which one?
My lord, 14, my lord.
Item 14.
Ah.
My lord, the other side has mentioned to fix a time for hearing, my lord. That's what
Fix
I'm
a
being
time for hearing. What is the matter about?
My lord, it is about recovery of monies dues and payable when the defendant.
What is the application?
My lord, there are two applications which are pending. One is GA1, which is the maintainability of the suit which has been filed by Mr. Ray's client, and GA3 is my application for injunction. GA4, which is appearing in today's list, was an application for substitution which has been disposed of by an order dated 12th of September. So all the amendments have taken place. So now we are pressing
So now
for
injunction
our
application and temporary application.
Yes,
Two
your
applications
lordship.
are to be heard.
Yes.
Pleadings completed.
Pleadings are all completed, your lordship.
Record an order number.
And your lordship,
detail number 14.
I want to point out that no written statement has been filed.
That I am not taking at this.
There's already an order, my lord.
Appearing for the plaintiff, appearing for the defendant. Counsel for the respective parties submit that. The defendant and the plaintiff has filed an application for judgment.
Application, we have filed an application for injunction, which is GA3, your lordship.
Counsel for the respective parties are present. Counsel for the plaintiff submit that. The plaintiff has filed an application for injunction and the defendant has filed an application for dismissal of the suit.
And as well as section 8 in the alternative.
Dismissal of the suit or referring the matter
arbitration.
For arbitration. For arbitration. It is further submitted that pleadings have been completed and prayed for fixing the matter for hearing. Considering the submission made by the counsel for the respective parties, let the matter appear on 20th June 2024 under the heading adjourned motion. Yes.
Very grateful. Very grateful for the indulgence, your lordship.
Yes. Fixed matter.
My lord, before my learned friend, it is his application.
Which one?
But this is the fixed matter, my lord. Fixed at 12 noon. Well, Lord, this is an application taken out by third parties in execution proceedings. So, Lord, I am the decree holder. So, Lord, I have certain preliminary objections regarding the maintainability. May I just indicate that? Only the preliminary objection, then my learned friend can continue.
My application.
Yes,
preliminary.
That's why I said, my lord, preliminary objections on the maintainability only. I'll just indicate those preliminary objections. If my lord will kindly take the cause title of the application. My lord, Jagriti Trade is the decree holder.
Correct.
Well, and the judgment letter, if your lordship will kindly turn to the next page, is a company by the name of Augustus Avani Land Developers. And then, my lord, your lordship will see the applicants the Starlight Real Estate Mauritius Limited, and the other is Starlight Real Estate Mauritius Limited. These two are the applicants.
Where from your date?
Well, your lordship looks at the GA.
Yes, GA. GA.
Yeah, their application.
Yes.
Because now the GA is being heard.
Starlight.
Yes, my lord. I am the decree holder. I am seeking execution of the decree, which is an arbitral award against Augustus Avani. And my lord, the present applicants are the Mauritius companies, the two applicants. My lord, now I'll tell you, lordship, what's my preliminary point. They claim to be the shareholders, my lord, of Augustus India, which is the Indian counterpart of a company by the name of Starlight United Kingdom. Now, my lord, there is a joint venture agreement, my lord, which was constituted between Augustus and Jagriti, which is the decree holder. And my lord, the joint venture was called the Ascot joint venture. My lord, under the joint venture, my lord, there was an obligation, my lord, of Augustus, which is the Indian counterpart, to invest $5 million US. And my obligation was also, my lord, similar obligation to also invest 5 million. I did, they did not. There was an arbitration clause. I went, and there are several other proceedings which may not be relevant for the preliminary issue. So that when I went in arbitration, I got specific performance, and by that arbitral award, my lord, this company, which is Augustus India Company, the Indian counterpart, was directed by the award to deposit the $5 million, which I seek enforcement. My lord, here what happened is, my lord, the UK company went into liquidation. So now, my lord, they say that they had invested, my lord, there are investments made in the Augustus to the Mauritius shareholders. My lord, now when the arbitral award was passed, a suit was filed by them before this honorable court on the ground. The two applicants before your lordship filed a suit challenging the arbitral award. My lord, I just need to indicate, because my point here is the suit was partly I filed. I was the defendant in the suit. My lord, I filed an application for rejection of plaint. One of the defendants in the suit partly allowed. I was aggrieved. I went up in appeal. In appeal, the entirety of the suit stood dismissed. And thereafter, they went before the Honorable Supreme Court. The SLP stood dismissed. So now today, the division bench order, I just wish to indicate, your lordship, a few of the findings of the division bench, which my respectful submission would operate as a res judicata against them in the present application.
What is the present application? 47?
An application under Order 21, Rule 58, which has been tried as a suit. The Supreme Court has, because this is also going to be tried as a suit, the Supreme Court has rejected, it said, we're not inclined to interfere in SLP with the specific direction that I'll be allowed to raise all my points before the executing court. And hence, my learned friend can raise objection, because the reason why I'm sorry, I know it's a maintainability application, but the facts itself, the way it's being presented, are slightly misleading.
Okay,
so let him continue, and then I'll just come to the facts.
Just two more paragraphs. Now, if your lordship will kindly take once the division bench judgment, which starts at, kindly take the opposition filed by us. Don't wish to trouble your lordship with the single bench's order, because the division bench records everything.
Page number?
My lord, page 67 of our opposition.
Yes.
Kindly give me a moment. It starts at this is not the opposition. The first volume. My lord will kindly come to page 67. The division bench judgment at 67.
Yes, I am there only.
Now, my lord, before that, may I just show your lordship the plain touch? Lord, kindly take the first paragraph at page 68. The plaintiffs are in appeal against the partial rejection of their plaint on the first defendant's application under Order 7 Rule 11. The first defendant has also joined in the fray with its cross objection and insists that the entirety of the plaint ought to have been rejected. It may be worthwhile to refer to the narrative in the plaint before attempting to discover the plaintiff's cause of action in respect to the matters complained of, or the cause of action as disclosed in the plaint and the legal basis for the reliefs claimed therein. My lord, kindly have a look at this. According to the plaintiff, the following relaxation of the norms as to the foreign investment in the real estate business in the country, the plaintiff caused. Then, my lord, your lordship will see what is the there is a averment in the plaint which they have the relief. My lord, kindly have a look at page 72. This is what the single judge held, the quoted portion in italics.
Yes.
But kindly have a look at paragraph 8 at page 72.
Yes.
On the basis of the allegations recounted above, the plaintiffs instituted CS number 284 to claim diverse reliefs ranging from declarations that the purported award, of which I seek enforcement today, of 16th May was illegal. To a decree for setting aside the purported award and consequential relief by way of injunction. Well, now kindly come straight away to para 36 and 34. If I may just also trouble your lordship once with what happened, what was the order which was passed by the single judge, para 9. This was the scope of our cross appeal. By the judgment and order impugned, the interlocutory court in essence held that the challenge to the arbitral award could not be maintained and was barred by limitation, but in the same breath observed as follows in the penultimate paragraph. Lord, allow me to place the quoted portion. Insofar as the other reliefs are concerned, in my view, they are required to be adjudicated at the trial and the suit cannot be dismissed as against the other defendants. Since the prayer for setting aside the award is barred by law, I hold that the suit, so far as it relates to setting aside of the award against the defendant is concerned, is not maintainable. The application is allowed in part. So you are aggrieved by this part. Now, my lord, kindly come to paragraph 36 once, which your lordship will find.
Yes.
At page 85. It is possible to imagine several scenarios where an arbitral award or a decree of a court is made against a person, but it affects another who was not a party to the arbitral reference or in the suit. Clearly, in such a scenario, such a person cannot be proceeded against in the enforcement of the arbitral award or execution of the decree. The fallacy in the plaintiff's case here is that they claim to be affected or prejudiced by the arbitral award or the enforcement thereof in course of the execution proceedings instituted in this court, which is the present proceeding before your lordship. Legally speaking, the award of 16th May was not rendered against the plaintiffs or either of them. Again, the arbitral award was not enforced against the plaintiffs or either of them. We're not pausing here for a moment, but they claim to be the shareholders of the company. So, we're not Bacha Gazdar, 63 moons is now settled. As a shareholder, you don't have any interest in the assets or the business or the firm. The money which came, the money became the asset of the company. And this is the money which we have obtained in course of execution. Clearly, the arbitral award was against the pro forma defendant, and it was also enforced against the pro forma defendant, which is the judgment debtor before your lordship. and the money went out of the bank account of the pro forma defendant. If at all the plaintiffs are to blame for the circumstances in which they find themselves, it is the plaintiff's admission that the third defendant was appointed on the board of directors of the pro forma defendant. Though the plaintiff claim, my lord, board of director issue, I'll just indicate, my lord, what is that, my lord? There was a situation when in the claimant company, in fact the decree holder company, my lord, against whom we were seeking the enforcement of the arbitral award, the Indian counterpart of the UK company, one director was there. So that director went and appointed two more directors. So it is this is dealing with that situation. If at all the plaintiffs are to blame for the circumstance in which they find themselves, it is the plaintiff's admission that the third defendant was appointed on the board of directors of the pro forma defendant. Though the plaintiffs claimed that there were other directors on such board, but upon the resignation of such other directors, the third defendant came to be the sole surviving director of the pro forma defendant. Ordinarily, there cannot be a single member director or single member board of directors of any company. And when a director finds himself to be in the lone member of the board of the company, usually such director has the power and authority to induct another, and thereafter for the two together, a co-opt or induct further directors as the articles of association of the relevant company may provide. That's exactly what the third defendant in the suit did. Without being overtly critical, it is plain to see that there is no legal basis to the claim in the plaint. For instance, the plaintiffs claim that the plaintiffs held a meeting on such and such, revoked the authority. This continues to say that the plaintiff has no right in law, no right to sue. So that's what has been held. Then, my lord, if I may just trouble your lordship with, my lord, the fact that they had no cause of action is, if I may just trouble your lordship with one para 38. On the most charitable reading of the plaint, which is what is required of a court in season of an objection in the nature of demurrer, it discloses no semblance of any cause of action against any of the defendants, whether in respect of the arbitral award or otherwise. As noticed above, only the party aggrieved by the arbitral award may challenge the award, and the plaintiffs are not parties to the award. At any rate, no suit is maintainable to challenge an arbitral award, particularly since the Act of 96 is the entire repository in respect of the arbitration law in the country, and all matters pertaining to arbitration in the country are covered by such statute, and the rights and remedies pertaining to the arbitral award are governed there. Then, my lord, if my lord kindly take the trouble of coming to page 89, paragraph 41. Since the plaint pertaining to the present suit is found not to disclose any cause of action, and the plaintiffs are found not to be legally entitled to any of the reliefs claimed, the plaint is liable to and is rejected as a whole. Accordingly, the plaintiff's appeal fails and the first defendant's cross-objection succeeds. Stands modified to the extent. Well, I'll just trouble your lordship once with the Supreme Court order at page 92. If I may just place before your lordship paragraph 2 at page 92, the Supreme Court order. We are not inclined to interfere with the decision of the High Court. We, however, make it clear that any other remedy that the petitioners would have invoked, either in the proceedings for execution of the award or before any other forum, are kept open. All contentions that are available to them in law can be raised in argument. So this is the proceeding. I say there is no remedy available to them in law. Because, my lord, the issue, what they are raising or what they propose to contend in the present application has already been decided. There is no new proceedings or no new contention which has been raised in the present application. My lord. So what has been held by the division bench and what was their cause of action in the suit is effectively the cause of action in the present application as well. And my learned friend said, my lord, Order 21, Rule 58. My lord, it concerns attachment, a post-attachment situation. If your lordship will see what has been attached is the asset of the judgment debtor company, which is being dealt with here, is the money which was parked in the bank account of the judgment debtor. So this is in my respectful submission, my lord. I'll deal on the merits if required, my lord. My lord, this is nothing but another attempt, a second attempt. So, my lord, the first attempt had reached a finality.
Yes.
Nothing but a second attempt. But otherwise, my lord, my respectful submission, this application is otherwise not maintainable and is squarely hit by the principles of res judicata. And well, and Supreme Court has not given them the liberty that. So, well, it has to be in accordance with law. So, law says that the maintainability of the application, whether this application is at all maintainable and if it is otherwise barred by the principles of res judicata and even if it is under Order 2158, but they don't even satisfy below the test which is required or the qualification under Order 21 Rule 58 is also not satisfied in this present proceedings. These are my submissions on preliminary objection.
Yes. May it please.
No, as my learned friend has pointed out, this is the execution to execute an arbitral award. We had filed objections in this court as well as a civil suit, saying that this arbitral award is a product of fraud and collusion between the so-called decree holder and the so-called judgment debtor to siphon off the funds of the applicants which was parked in their account. I have been non-suited by the civil side under Order 7 Rule 11. The single judge, the learned single judge, partially allowed. In that, my learned friend, what he's just argued, the learned single judge actually recorded his argument that a suit is not maintainable. I have to do this at the time of execution to say what is the nullity. I'll just show it from the learned single judge's order itself, their submission, which is they are arguing to the contrary today. The division bench was pleased to reject the suit in entirety. So these are Order 7 Rule 11 proceedings. Supreme Court says it's an in limine order. It does not, I'm carrying the case law to show it does not approve what the High Court is saying. It does not approve, does not disapprove. It's an in limine order, but saying that I'm entitled to raise all arguments in these proceedings. The court is well aware that after the 1976 amendment of Order 21 Rule 58, it is no longer a summary proceedings. I've got those judgments of the Supreme Court and the High Courts. It has to be, it can't be decided on affidavits. It has to be treated as a suit. There has to be adjudication whether this award is fraudulent and or collusive or not. So I'll come to that.
But with regard to you already filed a suit, but then you failed.
If on the Order 7 Rule 11, so since it is not on merits, it can't be res judicata. I'll cite that case law for the proposition also for orders for res judicata to come into effect. There has to be a previous decision on merits. Here I've been rejected, non-suited on the ground that the Arbitration Act ousts the jurisdiction of the civil court. And hence, I've not been ousted on merits. So there's no question of res judicata.
But when there is no jurisdiction, how the merit will entertain?
No, no jurisdiction. That's what Order 21 Rule 58, and I'll show Your Lordship the judgments on that point, that even a stranger, forget a person who's affected like me, even a stranger can get into Order 21 Rule 58 and file execution saying fraud is being practiced on the court, on them, and the court has to adjudicate on that. I'll come to that case law. But before we talk about the legal position, the facts must be stated properly. What my learned friend has stated is just cherry picking, if I may say so, with utmost respect to my learned friend, few facts, which does not give the entire picture, because this is the second attempt to siphon off the money. Earlier attempt had been rejected by the Honorable Bombay High Court. That had been approved by the Supreme Court. So what I have done, since the record is voluminous, I have, for the benefit of to assist the Honorable Court, just made a list of dates. If I just take the court through the list of dates, That will show where we are coming from. I'll give a copy to my learned friend. Thanks. If I may just read this. The applicant number 1, a foreign body corporate, entered into a 50-50 joint venture dated so-and-so with the petitioner. So the first there was the JV between the applicant and them directly. This was of 2006. To form a private limited company named Ascot. The respondent was incorporated as a wholly owned subsidiary of the applicant herein on 3rd May 2007. The Foreign Investment Promotion Board issued the approval letter, this date is very important, 14 June 2007, in favor of the applicant number 1, in terms of which the wholly owned subsidiary was to make downstream investments in the wholly owned subsidiaries and joint ventures, and the foreign equity participation was to be 100%, amounting to US $10 million in the paid-up capital of the company. This was the approval letter.
Yes.
Now, the joint venture agreement dated 26/9/2006 was superseded by the joint venture agreement dated 12/7/2007 between the respondent, that is my subsidiary. The Honorable Court has it.
What was the 12/7/2007?
That was on item serial number 4, page 2. The joint venture agreement dated 26/9/2006 was superseded with the JV agreement of 2007 between my subsidiary and the petitioner.
Okay.
The FIB letter dated so-and-so transferred the approval to my subsidiary, the respondent, and conveyed the government's approval to Messrs. Tala Investment Limited UK, making the investments of 26 crores in the respondent as specified therein. The other terms and letters of the FIB approval letter did so-and-so remain unchanged. The applicants, I have put in this money, the applicants duly created share subscription funds in sum of $6 million in the bank account of the respondent. The balance requirement of USD 4 million out of the minimum capitalization of USD 10 million in the respondent under the FDI policy was fulfilled by Starlight Investments Limited UK by subscribing to CCDs issued by the respondent for 26 crores.
Correct.
As of 23/4/2009, only Neeraj Kumar Pandey remained as the director on the board of directors of the respondent, as detailed in the application, and being a sole director, he could not hold a valid board meeting. Yet he illegally and without the consent of the applicants held a board meeting of the respondent and illegally appointed 2 new purported directors, so-and-so, as additional directors in the board of the respondent. Neeraj Kumar Pandey, without any authority and or consent of the applicants, unilaterally and illegally co-opted Rajinder Kanchan Deshpande as the authorized signatory of the respondent to operate bank account with HSBC. Serial number 8. The aforesaid facts were brought to the notice of applicants while emails it is so-and-so sent by Neeraj Kumar Pandey. I'm in Mauritius. The illegal appointments of so-and-so as directors by the respondent by Neeraj Kumar Pandey was contested by applicants by email dated 1/10/2009 addressed to Neeraj Kumar Pandey. So 2009 itself, you're saying you're not the director, you can't do this. The named 3 individuals colluded on 1/10/2009 to get Rajan Kishan Sikka appointed on the board of the JV, purportedly as nominee director of the respondent. The 4 named 3 individuals illegally held themselves to interest-free loan of 1 crore each from the bank account. It's my money. But the respondent of HSBC Bank. The applicants, by notice it is so-and-so, notified HSBC Bank of such fraudulent action and requested to freeze the account and not to permit withdrawals therefrom. The applicants, by the letter dated so-and-so, addressed to the aforesaid individuals inter alia, challenged the authority of grant of such loans and called upon them to rectify the position. Then the applicants, being the 100% shareholder of the respondent, held a meeting on 5/12/2009 and inter alia resolved to the effect that the 4 named 3 individuals were prevented from contracting obligation for on behalf of the respondent and from committing, signing any documents or acting as a signatory or otherwise binding on the respondent. The certified extracts of the minutes of the meetings were sent by courier on so-and-so day to Neeraj Kumar Pandey and the bank. The applicant. Thank you. The applicant advocate issued a bank to the HSBC bank, issued notice to the HSBC Bank requesting it to freeze the bank account of the respondent and stop permitting withdrawals. With a view to stop the illegalities of 4 named 3 individuals, the representatives of the applicants requisitioned an extraordinary general meeting wherein the aforesaid 3 individuals were removed as directors of the respondent and Mr. So-and-so appointed directors of the respondent. The bank account of the respondent was frozen by the bank with effect from 29/12/2009. This date is important. With a view to siphon off the funds from the bank account of the respondent in collusion with the aforenamed three individuals, the petitioner now made a false and fraudulent application dated 3/9/2010 to the RBI, inter alia seeking a direction to the respondent to infuse the sum of 5 million in the joint venture of Ascot. The case set up by the petitioner was that in addition to the requirements of the capitalization of 10 million by the applicants and the respondent, there was a further requirement of the respondent to infuse the minimum of $5 million in Ascot, supposedly to meet the requirements of the Press Note 2 of 2005, reaffirmed by Press Note 4 of 2009, issued by the DIPC, Department of Industrial Policy and Promotion. The petitioner, however, itself referred in the application dated 3/9/2010 to the FIPB approval letter dated 14/6/2007 and the letter dated 7/2/2008 pertaining to the applicant respondents, and hence was fully aware there was no requirement in the said letters for the respondent to infuse a minimum of US $5 million in Ascot. Rather, para 6 of the approval letter expressly confines Press Note number 2 of 2005 to construction development activities undertaken by the company as well as downstream entities, while providing that the downstream investment shall be as per Press Note number 9 of 99. So if I pause here for a minute, there are two press notes. One is of 99, one is of 2005. 2005 did say 10 million and 5 million, but the approval letter given to us, it was not automatic approval. That we didn't take that route. Approval letter expressly said for the money to come in, 10 million is okay. It's only for construction activities, you go to Press Note number 2005. And hence, the requirement of capitalization of 5 million towards joint venture in Press Note 2 of 2005 or 4 of 2009 was inapplicable. Rather, Press Note 9 of 99, it inter alia provides that the foreign-owned Indian holdings companies will make downstream investment within foreign equity levels permitted for different activities under the automatic route. So 10 million was sufficient. The petitioner was fully aware that even otherwise, by virtue of the terms of the approval letter, requirements of capitalization of US 10 million in terms of Press Note 2 of 2005 would have been satisfied, and that with the joint venture being eventually between the petitioner and the respondent, not the applicants. There will be no requirement, even under Press Note number 2 of 2005, for further capitalization of US million towards the joint venture. The said Neeraj Kumar Pandey, who continued to masquerade as the director respondent and purport to act on behalf of the respondent, sent a fraudulent and mischievous letter dated 11/10/2010 to the RBI to the effect that 2 checks of 15 and 5 crores has been issued towards infusion of minimum capitalization of US 5 million in Ascot as per prescribed in Press Note 2 of 2005. Applicants write letter so-and-so to the Neeraj Kumar Pandey reiterated that he had no authority to represent the respondent or to bind it or deal with the frozen bank account of the respondent, and there was no requirement of the respondent to infuse the minimum US 5 million in Ascot. The applicants also addressed a letter to HSBC Bank on so-and-so, reiterating the fact they had already revoked the authority of Neeraj Kumar Pandey as to act as signatory on behalf of the respondent in respect of his bank account with HSBC Bank. Now, Neeraj Kumar Pandey, again purporting to act on behalf of respondents, sent a letter dated so-and-so to HSBC Bank to the effect it has been informed by Ascot, that's the JV, that the 2 checks of 15 crores and 25 crores have been returned unpaid with remarks referred to drawer. Neeraj Kumar Pandey, while referring to the approval letters, required the bank to honor the 2 checks purportedly towards the respondent's liability. Neeraj Kumar Pandey, again purporting to act on behalf of the respondents, sent a similar letter dated so-and-so to HSBC Bank. Ascot, on its part, complained to the RBI against the dishonor of the check. I was not on Ascot because the directors have been masquerading my directors. So Ascot, on its part, complained to the RBI against the dishonor of the said checks, which matter went before the Banking Ombudsman and then before the Honorable Bombay High Court through writ petition so-and-so. Thus, petitioner who had 50% shareholding in Ascot was throughout aware of the true state of affairs and knew fully well that the said individuals had been removed from the directorship of the respondent and were not competent to issue any check on his behalf. The petitioner was party to the efforts of the forenamed 3 individuals to siphon off the funds from the bank account of the respondent. Significantly, the Kolkata address of both Neeraj Kumar Pandey and Ascot was the registered address of the petitioner. They all operate from the same address. Further, Rajan,
Neeraj Kumar Pandey and
Ascot and the petitioner, they all have the same address, which is 3A Shakespeare Sarani, Kolkata, as is evident from the execution application in Annexure 34. Further, Rajan Kishan Sikka continued not only masquerade as director of the respondent, but also act as nominee director of the respondent on the board of Ascot. So they can't distance himself. Since HSBC Bank did not honor the two checks for 15 and 5 crores, these three individuals filed a writ petition so-and-so in the Honorable Bombay High Court, supposedly on behalf of the respondent and themselves, against the RBI and HSBC, seeking inter alia honoring of the said checks. The applicants were not made party to the writ petition and were unaware of same. The Honorable High Court, white order dated so, was pleased to direct the implement of the applicants. The Honorable Bombay High Court, white order dated so-and-so, was pleased to dismiss the writ petition with the sort of enforcement of these checks, the honor of these checks. The Honorable High Court, white order dated so-and-so, was pleased to dismiss the review petition. The Honorable Supreme Court, white order dated so-and-so, was pleased to dismiss SLP. Because we had brought the facts before the Honorable Bombay High Court. Now, both joint venture agreements provided for appointment of the sole arbitrator as per the ICC rules of arbitration, and the arbitration was to be held in Singapore and in accordance with the set arbitration rules of the International Chamber of Commerce. Now, this is the JV between the petitioner and the respondent. We are not signatory. We are not party to it, to this JV. Shortly after the dismissal of the writ petition by the Bombay High Court, the petitioner now, by letter 13/3/2012, the dismissal is just about a couple of months before, now fraudulently invoked the arbitration clause in the JV while seeking arbitration in India instead of Singapore as stipulated. So first they changed the seat of arbitration. The respondent unsurprisingly and conclusively agreed by this letter dated so-and-so within 4 days. Significantly, it was the petitioner who proposed the name of the learned arbitrator, who has passed the impugned award dated so-and-so at Calcutta, as has been recorded in the award itself. So here, these three individuals, who are no longer my directors, suffer a collusive award, saying, yes, we owe 20 crores.
So how the arbitrator was appointed?
But what they did was the petitioner sent a letter to the subsidiary saying, we can't go to Singapore. Let's do it in Calcutta.
Correct.
The director said, we very well do it in Calcutta. The name was proposed by the petitioner and the arbitrator gets appointed.
So you are not challenging that.
So that's why I can't under 34. I'm not a signatory to the arbitration agreement. I've not filed 34. And because of the view, I'll show the judgment which say that fraud is not a ground under section 34. So that can be raised at time of execution. That was their own argument for the learned single judge here. So it is not a question of challenging on a ground available under 34. This is a case of a non-signatory to the arbitration agreement, who is not participated in the arbitration proceedings, who is not appeared, who is not party to the award. He can, so that's why we had filed the civil suit that our case before the learned single judge was Arbitration Act does not ask the jurisdiction of the civil court to the extent that a non-signatory can challenge an award on the ground of fraud. However, the learned single judge took the view that it completely outs the jurisdiction. Very well, we bowed down to that. But that does not preclude me from raising that in execution. That's the reason why the Supreme Court said raise it in execution. I'll just take the court order to Order 21 Rule 58. Well, I'll just conclude. There's only a few more paras left. Though there's no provision in either of this is on the 16/5/2013 is the award. Yes. Though there's no provision on either the joint venture agreements imposing a contractual liability on the respondent to pay ₹20 crores to Ascot, nor any requirement in the FIPB approval letter dated so-and-so or the letter dated so-and-so to do so, the respondent, presumably through said persons masquerading as directors of the respondent, supposedly admitted the fraudulent claim of the petition in arbitration proceedings to the effect that there was such requirement. So these are people who have been trying successively to get money out. Bombay High Court blocked it first. Immediately after that, they invoke a collusively an arbitral clause, which was supposed to be in Singapore. They bring it to Calcutta. The award dated so-and-so, which was thus collusively and fraudulently procured by the petitioner, it accordingly holds that the respondent has admitted its liability of investing the said sum of ₹20 crores and directs such payment with interest in favor of Ascot. The applicants who were not party to arbitration agreement were unaware of the arbitral proceedings of the award. Neeraj Kumar Pandey again emailed HSBC Bank in connection with freezing of the bank account of the respondent. HSBC, by the letter so-and-so to Neeraj Kumar Pandey and copy to applicants, detailed the force of litigation and clarified his stand in the matter. So we filed this execution in 2014 itself, wherein, the petitioner filed this instant execution petition in 2014, wherein inter alia made a false and fraudulent claim before this honorable court that there was a requirement. This is in the execution itself, that there's a requirement of the respondent to invest a minimum of $5 million escort, that the respondent had issued two checks for rupees 15 crores and 5 crores consequent to the complaint dated 3/9/2010 to the RBI, which was dishonored. The petitioner sought the execution of award dated so-and-so, directing the respondent to make a payment of rupees 20 crores with interest to escort. The applicants were shocked and surprised to learn from HSBC letter dated so-and-so, received by them on so-and-so in Mauritius, informing them of the present execution proceedings. It transpired that the HSBC had been served with an order passed by this honorable court in the instant execution proceedings, which directed the said bank to pay the court-appointed receiver a sum of this 28 crores from the counter respondent. It is now that applicants learn for the first time of the arbitral proceedings, the award dated 16/5/2013 and the instant execution proceedings. Within 12 days, the applicants filed civil suit before this honorable court, inter alia playing for declarations that the award dated so-and-so was non-honest and illegal and not binding upon them, and that the said three individuals had no authority to represent the respondent, a decree setting aside the purported award, and the decree of injunction restraining recovery of money on the basis of the award and the refund of the money if already realized. This honorable court, by order dated 12/8/2014 in the instant execution proceedings, was pleased to direct the receiver to keep the sum of rupees 42 lakhs in fixed deposit. This sum is towards further interest. The petitioner filed GA so-and-so in the suit under Order 7, Rule 11, seeking rejection of the plaint of the applicants. The learned single judge of this honorable court, by judgment dated so-and-so, was pleased to partially reject the plaint to the extent it pertained to the challenge of the arbitral award. This honorable court, by order dated 17/8/2015, as corrected so-and-so of the applicants, was pleased to inter alia modify the award to the extent that escort as beneficiary, because the money is, they say, the decree holder. How are they the decree holder? It's escort where the money has to go, not to Jagrati. To the extent that escort as beneficiary would retain the money subject to any order that may be passed in execution of the award. This honorable court, by order dated so-and-so, this in 2014, in the present execution proceedings, was pleased to stay the execution of the award till further orders. The petitioner filed APO so-and-so, while the applicants filed OCO before the Honorable Division Bench against the judgment of 14/5/2015 of the learned single judge. This honorable court, by order dated so-and-so, in the present execution proceedings, were pleased to adjourn the matter sine, with appeals were pending. The applicants filed company petition number so-and-so before the Honorable National Company Law Tribunal, Mumbai, in pleading the respondent, the forenamed three individuals, Ministry of Corporate Affairs, Registrar of Companies, inter alia seeking appropriate orders. This is for mismanagement, oppression, to get rid of these directors. And this petition is still pending. The Honorable Division Bench of this Honorable Court, by judgment so-and-so, was pleased to reject the plaint in its entirety, not on merits, but inter alia on the view that no suit is maintainable to challenge an arbitral award. The applicants filed the present application objections dated so-and-so in the instant execution proceedings under Order 21, Rule 58 and 151, whereas Section 66, primarily on the ground that the arbitral award dated so-and-so sought to be executed is a product of fraud practiced upon the applicants in this honorable court by the petitioner and the aforesaid three individuals masquerading as directors of the respondent in collusion with each other, and hence a nullity, non-est, void, insecutable, and hence the reliefs as sought in the application objections be granted. The application objections filed under Order 21 Rule 58 and CPC are required by law to be adjudicated as suit, with affording the parties an opportunity to lead evidence so as to enable this honorable court to pass a decree. Because a decree comes out, it's even an appealable decree. The applicants preferred SLP before the Supreme Court, impugning the orders of the Honorable Division Bench. The Honorable Supreme Court, by order dated so-and-so, was pleased to grant stay for the execution proceedings. The Honorable Supreme Court, by order dated so-and-so, has been pleased to interhold in the earlier hold, which has already been read, and so we've been relegated to this court. Now, this is the factual background. To start with what my learned friend has said, just to address that before I come straight to the law, because what is left is basically, it has to go as a suit, but let me just deal with the preliminary objection. First of all, I've been non-suited by the civil court on the ground of under Order 7 Rule 11, not on merits. On the contrary, if the court may just see for a minute what objections filed by my learned friend. What was this stand? Page 48. That is from the order of the learned single judge.
48 of your application?
No, 48 of the objections.
There
of the objections. That is from the order of the learned single judge, where their argument was, don't file the suit, raise your objections in execution. This was the argument.
Yes.
Page 48, second para, it is submitted. The judge, I'm so sorry, the judgment starts from Annexure A, page 38, and the relevant para is on page 48, second para. The argument was, which is succeeded in, it is submitted
Yes.
that an award cannot be challenged by a third party. By the instance suit, the plaintiffs are seeking to do indirectly what the law prohibits them from doing directly. Determination of questions relating to the execution, discharge, and satisfaction of the said award can only be determined by the court executing the award and not by way of a separate suit. Hence, the suit is barred under Section 47 CPC. So it was their case, don't come in suit, go in at the time of execution. Now, if I made, so the first point is, I've been non-suited on the ground of non-maintainability of a civil suit. The second ground is what my learned friend said, the Supreme Court order does not approve of the division bench order. It only dismisses my SLP in limine in view of the fact that the execution proceeding is pending. There's nothing in the order. It's anyway Order 7, Rule 11 applications. They can't appound to res judicata. There's nothing in the order of the learned single judge or the honorable division bench which precludes me from raising these arguments.
Yes.
On the contrary, the Supreme Court expressly directed that I should come here because I'd argued the matter in Supreme Court. And the whole issue is we are going on the suit on the civil side. Whereas Order 21, Rule 58 itself says the objections will be treated as a suit. So the court said, pursue that.
What was the prayer in the suit?
Prayer in the suit was saying that this arbitral award is a product of fraud. Set that aside. And injunctions, etc. So what the learned single judge and the learned single judge and the division bench both were on the point that you cannot challenge an arbitral award in a civil suit because Arbitration Act 96 ousts the jurisdiction of the civil court.
Correct.
Now the matter when we came into the Supreme Court said you've anyway filed execution.
Yes, you
And in execution, there we raised all the arguments. So why this? That's the reason why it has been disposed of in limine. There's no finding of the Supreme Court against me. On the contrary, Supreme Court says, raise all your arguments before the executing court. So with that, just to answer the arguments, they have raised, I'll just add to what my learned friend has said in his objections. Once they say res judicata, then they say quiescence, then they say limitation. These are the grounds they've taken. And I brought the judgments of the Supreme Court and of the various high courts on each of this point to say none of those objections are legally sustainable. So I'll just straight away take the court to the law. If I may just, what I've done is to assist the court, I have formulated the proposition, indicated the page and the para numbers.
Good.
So if I just go, just issue the propositions, that will save the time of the Honorable Court. So the first case is that of the Supreme Court, 2008-14 SCC 258. The provisions of Order 21 Rule 58 cast a duty on the executing court to adjudicate all questions relating to the rights of parties, and as such is obliged to adjudicate upon the objection of the objector that the decree between the decree holder and the judgment debtor is a collusive decree merely meant to defeat the rights of the objector. The reason has been further clarified by the Honorable Madras High Court, which is in the next page. The application under Order 21 Rule 58 contemplates a full inquiry into all questions, including questions relating to rights, title, or interest in the property attached which arise within the parties for proceedings, and mandates that the court inquiring such a claim petition shall determine such questions. There shall be an embargo on the institution of a separate suit, because I can't file a separate suit, even under this provision, for the determination of such questions. Subclause 4 of Order. Oh, sure. I'll give a copy of the citation. No. Just give the citation. Citation. I'm so sorry. Which judgment are you referring to? One that you purchased. I've referred to 2008-14 SCC 258. That was the Honorable Supreme Court. I'm referring to one of the Honorable Madras High Court, which is 1991 Madras Law Weekly 243. So, subclause 4 of Order 21 Rule 58. CPC says that after the claim objection has been adjudicated upon, the order made thereon shall have the same force and be subject to the same conditions as to appeal or otherwise as if it was a decree. Though perforce an order is contemplated to be passed under Order 21, Rule 58, the law order has the legal effect of a decree. Such an order is a substitute for a decision resulting in a decree in an ordinary litigation. Such being the intent of the amended rule under Order 21, Rule 58, the inquiry contemplated under the Order 21, Rule 58 is no longer of a summary nature, but should be full, realistic, and after giving adequate opportunity to the parties concerned to prove their respective claims, rights, title, and interest in the property attached by leading evidence. The next judgment. Why don't you just, if you just give me a minute, I'll give you a copy of the index itself. That will give you everything. I'll just.
You can tell your juniors to mail it to.
We'll just do it. There will be just an index, out here in one of them.
Tell them to mail it to.
Or just mail it to them. Very well. So the next judgment, a claim, this is case number 3. The claim submitted under Order 21, Rule 58 CPC by a third party to decree is similar to a suit. It needs to be examined in detail, duly recording the evidence that may be produced for the parties. The reason is that the adjudication leading to the decree and execution takes place without participation to a claimant, and the law provides for a full opportunity to him to substantiate his claim. So this is for a third party. But I have no chance, I've not had occasion to show how the fraud has been practiced. My suit was thrown out on the ground of Order 7, Rule 11. Which court do I go to? So this is the remedy as per Order 21, Rule 58, and it makes no difference. Rule 21, Rule 58 does not make any difference in removable and movable properties, even where an amount which is not with the judgment debtors attached to execution, it is possible for one to invoke that provision. The next decision is that of the Madhya Pradesh High Court. The provisions of Order 21, Rule 58 CPC has been amended in the year 1976, and thereafter it is not a summary provision. It gives a mandate to the executing court to hold the inquiry of such objections in the manner in which the civil suit is tried, and requires inquiry in respect of validity of rights of the party on which the findings can be given by the court only after extending the opportunity for adducing the evidence to the parties. Similar provision of the Orissa High Court, that it's going to be adjudicated like a suit. It has the force of a decree. Then the Andhra Pradesh High Court, which is case number 6, Order 21, Rule 58 cast a mandatory duty on the executive court to hold an inquiry. The inquiry possesses the opportunity to be given by the parties to deduce all necessary evidence in support of the claim and to resist such claim by the opposite party, and thereafter to give finality to the objection by that court, subject to a right of appeal provided for under sub Rule 4, thereof treating the order thereunder as a decree. Now, the next two cases are for the proposition that even if somebody is saying you're delaying the execution, even to show there's no been delay, in this case, there's been no delay. For the material part from 2014 till 2024, almost entire period has been stayed either by this court or the civil side or the Supreme Court. I filed immediately. So there'll be no delay. So we can skip that and we come straight to case number 9. Section 36 of the arbitration, this was the Delhi High Court. Section 36 of the Arbitration Act provides for the enforcement of the arbitral award under CPC in the same manner as if it was decree of the court. Order 21 of the CPC provides for execution for decree of the court. Rule 58 of Order 21 provides for preferring claim objection to the attachment of any property on the ground that the property is not liable to such attachment, and for adjudication of such claim. Such adjudication has the force of a decree. The remedy for a non-party to an arbitration proceedings who cannot prefer objections under Section 34 of the Arbitration Act is by filing objections under Rule 58 of Order 21 CPC. Apart from what my learned friend had stated before the learned single judge, there's a direct judgment on this point. Then Kerala High Court, there's no bar under law for a stranger to a proposition who has an independent legal right to appear and contest execution proceedings and whose property interest will be adversely affected in the execution to point that the decree sought to be executed is a nullity. It is well settled decree which is nullity in law is no decree. It is so. I'll also come to this is relevant from the point of view: can this court go behind the decree? So I'll come to the Supreme Court decision, which says that the duty is of the court to actually see the proceedings up to the decree. We're not going behind a decree. You have to see whether there's a decree at all. To pronounce on the executability of the decree if a contention is properly raised that the decree is inexecutable because it is a nullity. If an award is declared to be a nullity in the execution proceedings, it will not amount to adding one more ground to Section 34 of the Arbitration Act. In order to set aside a decree or order or award, there must be one in existence. In other words, a decree or award not in existence cannot be set aside. Therefore, what is provided in Section 34 of the Act is only ways and means to set aside an award made in arbitral proceedings. What is sought to be achieved in execution proceedings is to seek a declaration that the decree here and award sought to be executed is a nullity. In other words, seeking pronouncement, there is no executable decree or award at all. I should come to a judgment of this court also on similar lines. Then the decision of the Sikkim High Court. The objector, though not a party to the arbitral proceedings, can seek and obtain relief if the award has not been given fairly. Objector has a remedy at the stage of execution, and the executing court has a duty to find out the true effect of a decree. Then the decision of the Honorable Supreme Court on the role of the executing court. An executing court, this is case number 12. An executing court cannot go behind the decree under execution, but that does not mean that the executing court has no duty to find out the true effect of the decree. For construing a decree, executing court ought to take into consideration the pleadings as well as the proceedings leading up to the decree. The omission to construe the decree is really an omission to exercise jurisdiction vested in law. And then, of course, comes to the issue of fraud. Just one decision will suffice, case number 13. It's a settled proposition of law that a judgment, decree, or order obtained by practicing fraud on the court, tribunal, or authority is a nullity and non-est in the eyes of law. Such a judgment, decree, or order by the first court or by the final court has to be treated as a nullity by every court, the superior or inferior. It can be challenged in any court at any time in appeal, revision, or even collateral proceedings. Even most solemn proceedings are vitiated if they are actuated by fraud. Fraud is thus an extrinsic collateral act which vitiates all judicial acts, whether in rem or in personam. The principle of finality of litigation cannot be stressed to the extent that absurdity that it can be utilized as an engine of oppression by dishonest or fraudulent litigants. And the other proposition was an order of the Honorable Supreme Court under Article 136 of the Constitution does not attract the doctrine of merger. What my learned friend had argued, an order refusing special leave to appeal does not stand substituted in place of the order under challenge. All it means is that the Honorable Supreme Court was not inclined to exercise the discretion so as to allow the appeal being filed. In this case, the fact consideration was the pendency of this execution. And the NCLT matters. And that's what the court says you've raised it there.
What has happened to the NCLT?
NCLT matters, orders, I'm carrying those orders. There have been directions being told, the applicants have been told directions been given to the subsidiary, give inspection, let them inspect the record, and we have been asked to appoint our directors on our subsidiary. So those matters that is pending, and now because the same individuals are blocking, contempt notice has been issued by the NCLT against them. I'll place those orders on record. Then coming to case number 14, the plea that an arbitral, this is of the Supreme Court again, the plea that arbitral award is a nullity can be taken at any stage and also in collateral proceedings. Waiver, estoppel, acquiescence is no bar against a plea that an arbitral award is a nullity. Then the decision of this particular honorable court. The question that arbitral award is not executable being a nullity can be raised before the executing court can decide the question. A decree which is nullity in the eyes of law is no decree, and hence even by consent of the parties, such a decree cannot be executed by the court. If the court finds a decree is a nullity, the court cannot proceed to execute it, and it is the duty of the court to hold that the decree is not executable. And so the next two judgments are similarly or also relate of this honorable court. Item case number 16. In the case of a non-est arbitral award, guidance has to be sought from the jurisprudence of the apex court, vis-a-vis decrees passed while lacking inherent jurisdiction, even if the 96 Act is viewed as a complete court in itself. That's the view taken by this court. Such decrees do not exist in the eyes of law, and similarly, non-est awards can be said never to have existed. The execution proceeding petition has no legs to stand on for the reason that the award sought to be enforced is not a legal decree. The decree does not exist and is non-executable. The next case, wherever the court receives the execution application in either arbitral awards, which are non-est in the eyes of law, it is duty bound to exercise judicial discretion and restrain from itself from executing them. A similar view of the next judgment of this honorable court. Then we come to case 19, Union of India. There's a Delhi High Court. A plea that arbitral award is void can be raised in execution proceedings. A judgment of decree can be directly attacked by the procedure prescribed, namely by filing objections thereto or appealing against the order rejecting the objections. But that does not preclude a collateral attack on the award and decree in execution proceedings. The proposition that the judgment debtor may claim the decree to be a nullity execution proceedings and that the decree is void is too well settled. A collateral attack is not barred because the opportunity to raise the same question by direct attack was not availed. This is the well-settled principle applicable to civil courts executing decrees. So this law is well settled that my application is maintainable. Today, my learned friend is saying it's not maintainable. It is maintainable. There's no other place I can go to.
No, they have taken this stand because already the court has decided in the civil court how this application is maintained.
They have to.
Okay.
So they had said before the civil court that go in execution, not in civil suit. When I'm coming in execution, they're saying now that I'm barred from doing that.
I have taken note.
And they've cited res judicata. Case 20 says that's again a decision of the Honorable Supreme Court. The doctrine of res judicata belongs to the domain of procedure. And the previous decisions on merits alone as res judicata. A decision on an issue of law will not be res judicata in subsequent proceedings when the decision relates to the jurisdiction of the court to try the earlier suit. I've been thrown out on the ground of jurisdiction.
Correct.
Anything else, there is either arbiter, though I'll take the court to the division bench order. My learned friend did not read on very relevant para where the division bench itself says that it is the money of the applicants which has been parked in the account of the respondent which has been stolen from that account. That's the words used by division bench. I'll come to that right away. But let me just complete this. A decree passed by the court without jurisdiction is a nullity, and the plea can be taken up whenever and wherever the decree is sought to be enforced or relied upon, and even the stage of execution or collateral proceedings. Now, what my learned friend has raised this issue, that is the money of the company. That's where the lifting of the corporate will comes in. Because the court has to see, and as the division bench has pointed out, it is the money of the applicants which was parked in the wholly owned subsidiary to be put in for projects in India. And that's what the Supreme Court says in this case, Delhi Development Authority. The court will lift the corporate veil when the corporate personality is being used as a cloak for fraud or improper conduct. It may be a separate corporate identity. The concept of corporate entity was evolved to encourage and promote trade and commerce, not to commit illegalities or and to defraud people. Where therefore the corporate character is employed for the purpose of committing illegality or defrauding others, the court would ignore the corporate character and will look at the reality behind the corporate veil, so that to enable it to pass separate orders to do justice between the parties concerned. If it is found that someone has acquired properties by defrauding the people, and if it is found that the person defrauded should be restored to the position which they would have been but for the fraud, the court can always make necessary orders. This is because equity means, and in India, courts are not only courts of law, but also courts of equity. So this whole argument that the money, once I've transferred the money, it goes into my subsidiary, is no longer my money. True. No, that's a general proposition. Because it becomes a separate corporate identity. I'm a separate corporate entity, my subsidiary is a separate corporate identity. But if that money is being siphoned off to commit fraud, then according to the Supreme Court, the court will see the true character. Who owns that money? It's my money. Admittedly, I brought it in. Now, coming to the next three judgments on 22, when a learned friend says that you have no locus standi, it's not your money. Next to the judgments on the ground that even if I had no locus standi, I do have the locus standi, even then I can maintain this order 21 rule 58 and the court has to go into the issue of fraud. This is of the Madras High Court. Even where the objector lacks locus standi, the court must invoke inherent power when fraud stays upon the court so as to ensure that benefits do not accrue to the fraudulent party. The application objector has to be treated as information to the court, and when a fraud is brought to the notice of the court, it is a duty of the court to scan the allegation to arrive at the truth. Similarly, the inherent power under 151 of CPC can successfully be invoked to the objector to prevent fraud or collusion being practiced. The Punjab Haryana High Court, the power of vacating judgments entered by mistake or relieving against judgments procured by fraud amongst several inherent powers of the court. These are inherent powers these inherent powers are not conferred on the court by statute, but they're necessary to ordinary and efficient exercise of jurisdiction. Its protective function power necessary to the existence and due functioning by the courts and to the due administration of justice. These powers are necessary attributes and concomitants of judicial tribunals. Even if the objector has no locus standi, the court has an ample reserve of inherent powers to satisfy itself so moto that the process has been abused, even where the source of information happens to be a person who has no locus standi, the court cannot close its eyes and decline to exercise its inherent powers on being satisfied that as a result of conspiracy or fraud has been perpetrated and its process has been abused. The next judgment is again on the issue of res judicata, where this is of the Supreme Court again, where the former suit was dismissed by trial court for want of jurisdiction or for default of plaintiff's appearance in respect of which such class of cases, the decision not being on merits would not be res judicata in the subsequent suit. And last judgment is fraud admits on no bar or limitation in matter of granting relief against it on the court's power to undo the mischief caused by such fraud resulting from same. That's the decision of this honorable court. The only one decision I put on admission says there's a reason for that. I had filed this application where I have detailed, the court will see the record is so voluminous, how the fraud has been practiced. In their response and the objections, they simply say all these issues have been decided. They've not specifically denied. It's a evasive denial. They have not even denied. I can take the court through the pleadings of both sides, where I've detailed in my objections that this is what Pandey was doing. He was not authorized to do. This is what happened to Bombay High Court. They have a 3-line reply, simply saying all these issues have been considered by the civil court. And that's about it. So that's why they have constructively admitted the case. But my submission today, since the Honorable Court is pleased to give the case for 2 dates, my submission today is that this is the factual matrix, this is the law. If it has to go for trial, and I'm entitled to lead evidence to establish that it is my money, I'm entitled to lead evidence to show that this is where the fraud has happened. I need to exhibit all these documents.
First, you have to satisfy this court with regard to which document you relied upon and how it has been siphoned. Now, if the court is found that yes, you are satisfied, then it will come to the as a part.
No, if the court will see what the order for it, if I may just read directly from the court will give me a minute. If I may just read Order 21, Rule 58.
Yes.
I'll just my counsel is giving me. May I just read? Where any claim is preferred or to any objection is made to the attachment of any property attached in the execution of decree on the ground that such property is not liable to attach such attachment, the court shall proceed to adjudicate upon the claim or objections according to the provisions herein contained. Now, attachment has been made by the honorable court. In the civil suit, it is you will not use this particular money. Some money is lying in the FDR with the receiver. So attachment has been made, and my claim is, objection is, this is not liable to be attached. Money should go back from where it came.
Okay.
So the court shall proceed to adjudicate. That's what the decisions which I've cited is, that adjudication means giving me chance to lead evidence. So it cannot be decided on a summary basis. Provided that no claim shall be maintained where before the claim is preferred objection is made, the property attached has already been sold. That's not applicable because it is still there. Where the court considers that the claim objections were designedly or necessarily delayed, again, it's not applicable to us. All questions relating to the rights, title, or interest in property attached arising between parties to a proceeding or the representatives under this rule and relevant to the adjudication of the claim objection shall be determined by the court dealing with the claim objection and not by a separate suit. So this is the embargo where I can't go to a separate suit. So this objections has to be tried as a suit.
Correct.
Upon determination of the questions referred to in sub-rule 2, the court shall, in annexure with such determination, allow the claim or objection and release the property from the attachment either wholly or to the extent as it thinks fit, disallow the claim, etc. The rules which are there. Subclause 4, where any claim objection has been adjudicated upon and the order made thereon shall have the same force and be subjected to the same condition as to appeal or otherwise as if it's a decree. So this honorable court would be passing a decree on my objections. For that, I have to lead evidence.
No,
kindly
come to 2.
Yes.
All questions, including question relating to right, title, interest in the property attached.
Yes.
Arising between the parties
Yes.
to a proceeding or their representative under
Yes.
this rule and the relevant
Yes.
adjudication of the claim or objection shall be determined by the court dealing with the claims and objection and not by a
separate suit.
Correct. So this is the application you file. Now come to 3.
Yes.
Upon determination of the question referred to this 2, court shall in accordance with determine allow and claim the objection or release the property.
Yes.
So first we have to go by the 2.
So we need to, for that reason, we need to have adjudication.
Correct.
And adjudication as construed by the Supreme Court and different high courts means giving an opportunity to parties to lead evidence. And so what I have with the list of dates the court will be pleased to see, I have in the side indicated the documents. Each document which I want to tender in evidence. So that is, if the court will see the list of dates, I have mentioned that, which is the annexures. And so that's the reason there's no longer before 1976, it was summary procedure. On affidavits, it could have been decided.
Correct.
Now it cannot be decided on affidavits as per the view taken by the Honorable Supreme Court and the different high courts.
Yes.
Now the court will also be pleased to now coming to my submission for that reason. Of course, I can take the court to the pleadings, but if it has to go, my humble submission would be that if the court be pleased to pronounce whether it will go for trial, then there's one way of going and taking the court through all the pleadings. The other, if it's not going, and if it's going for trial, then let my learned friend agree take his view on that, since the matter is also listed tomorrow. If it's not going to go on trial, there's one way of proceeding with the case on objections on affidavits. If it's going for trial, then we don't want to take more time of this honorable court.
Correct.
I just want to point out page 84 from their objections for a minute, what the Honorable Division Bench has said.
Page 84.
84, that was the order of the Division Bench, which starts on page 67. Now their defense is basically on page 31. Though all this and orders and Rule 1 proceedings, none of this is constructive res judicata nor conform with the Supreme Court. But the court will see what even the division bench was pleased to note.
Page 31 of
it is page 67 in the decision of the Honorable Division Bench, page 84. Page 84,
yes.
para 31.
Yes.
On a plain reading of the plain, this is a civil suit. Since a more searching reading of the plains are unnecessary for the present case, the wrongs alleged have been committed are wrongs committed by the company. It is true that the plaintiffs park their funds in the company. This is the admitted position. But upon company receiving the funds, they became funds of the company, and the allegation that the plaintiffs made merry with the funds of the pro forma respondent has to be seen legally to be monies apparently stolen from the pro forma company, not from the plaintiffs. And I've cited the decision of the Honorable Supreme Court to show that where this is a fraud, if theft is going on, then the court will be pleased to raise the corporate veil to see whose funds it is.
Yes.
There's nothing in the division bench order or the learned single judge order which precludes me from raising a contention before this honorable court that these are my funds which have been stolen from my subsidiary by the petitioner and the respondent in collusion with each other by suffering a fraudulent award. I'm entitled to make the submission.
Yes.
So to answer the question that fell from this honorable court, to satisfy that yes, there's something wrong.
Correct.
On the face of it, there's something wrong because it is admitted position that it is my funds. It's admitted position. I brought them into India. It is admitted position. They say I had to put the subsidiary to put 5 million in the JV. I say I do not need to put 5 million in the JV. I'll take the court through the documents if the court wishes to proceed on merits as opposed to going for trial. I'll take the court through the press note of 99, press note of 2005 to say I'm not required to put this 5 million. I'll take the court through the Bombay High Court order to say where the Bombay High Court has said has dismissed the petition for honoring the same 20 crores, which is the subject matter of the arbitral award. The Bombay High Court says that they dismisses the petition for getting those checks encashed. And within 2 months, they invoke the arbitration clause for the same 20 crores. So I'll take the court through all the pleadings. After lunch.
Yes.
So if the court, since I'm told is 1:15, we can continue to after lunch at 2 o'clock.
Yes, Mr. Bose, what is your contention?
My lord, my respectful submission is that, my lord, first it has to be decided on the preliminary issue. My lord, what my learned friend is relied upon, a series of judgment, my lord, the propositions are not in dispute. My lord, those propositions have to be applied to the facts of this case.
But the submission made by you during the evidence, during the hearing of the on the single bench before this court.
Page 48.
That if your lordship will see, with respect to my learned friend, that would be misconstruing the recording of the judge. If your lordship will kindly have a look at that paragraph once again.
Yes.
It was possibly paragraph 30.
No, that's page 48.
Page 48, second paragraph.
Yes. Of the opposition.
Of your opposition, yes.
Your lordship reads it as a whole. And if I may just draw your lordship to a few paragraphs before that. If my lord will kindly come to page 46 once.
Yes.
Kindly take the second paragraph.
Yes.
Mr. Chatterjee, senior counsel appearing on behalf of the applicant defendant number 1, which is my client, submits that the suit challenging an award is not maintainable in law. It is submitted that in the suit primary challenge is the award passed against the pro forma defendant and not against the plaintiffs. The pro forma defendant neither has filed the present suit nor any application challenging the award. The suit has been filed by 2 shareholders of the pro forma defendant. Now, kindly make a note of this. This was one of the principal contentions of the present decree holder in their suit. The suit is misconceived and the derivative action is not maintainable. So, this is also in the nature of a derivative action on behalf of the company. Then, my lord, kindly have a look at what the court proceeds to hold. This is only on submission. The suit who do not have been instituted by the shareholders of the pro forma defendant. The pro forma defendant alone is entitled in law to challenge the said award. The present suit is an unknown form of action. My lord, under these perspective, that paragraph has to be read. Now, my lord, kindly see the suit as framed is a personal action by 2 shareholders and is not maintainable insofar as it complains of alleged wrongs done to the pro forma defendant company. So his action before the National Company Law Tribunal under 241, 242. That's his cause of action. That's his remedy in law if he has any. Oppression, mismanagement. Management has done things which the majority shareholders or the qualifying shareholders under 241 is aggrieved of. He's already initiated that action under 241, 242 before the appropriate forum, which is the National Company Law Tribunal. So, my lord, these were the issues that were raised. Now, my lord, kindly see, it is well settled that if a wrong is done to a company, then it is the company alone who is the proper plaintiff for the initiating a suit for wrongs done against it. So, my lord, there is a heaven and hell difference between an action by the company, where the company is affected, the rights of a company is affected, a juristic person. Well, this is an action by the shareholders. So it's a derivative action. It was held that such derivative action, when the company was there, the company's action was under challenge, was not maintainable.
Yes.
In the instance suit, the company, namely the pro forma defendant, has not been made a plaintiff. A derivative action will not lie, even on the assumption that the allegations in the plaint are taken to be true and correct. The plaintiffs are 100% shareholders, that the plaintiffs are 100% shareholders and are in control. They are not entitled in law to maintain the instance suit without making the company pro forma defender plaintiff. Accordingly, in the present form, the suit as framed is a creature unknown to law, without a head, body, or tail. Mr. Chatterjee has relied upon the following decisions. Then, well, if I may trouble your lordship to the paragraph which my learned friend had relied upon. Kindly, it is submitted that an award cannot be challenged by a third party. Para 48, page 48. By the instant suit, the plaintiffs are seeking to do indirectly what the law prohibits them from doing directly. Determination of questions relating to the execution. Determination of questions relating to the execution, discharge and satisfaction of the said award can only be determined by the court executing the award and not by way of a separate suit. So we're not pausing here for a moment. If today you file a suit, I have an execution proceeding. If you are an affected party in the execution proceeding, you have a right. You filed an application, so this application has to be decided on its merits. I say that today you don't have a right to complain of either the arbitral award or the extent to which I'm seeking enforcement of the arbitral award. Why? Because you are an unaffected party. Why are you an unaffected party? Because you are a shareholder of a company who has suffered an award. So it's the company's right at best which is affected. So you, on behalf of the shareholder, it is not their case that the directors are not there. So they are trying to make out a case of alleged fraud. So now this fraud issue, if your lordship will see that Neeraj Pandey, single director, has been specifically dealt by the division bench. This was their contention that there was a fraud, there has been a fraud has been perpetrated. The question of perpetrating the fraud is the certain actions of the company. So you take that action of the company before your company tribunal proceeding, which is the operation mismanagement proceeding. Well, today, if your lordship will kindly appreciate, today certain actions have been taken by the management of the company. Who will complain of that action? And where is the forum? If today those actions are challenged, 430 would be a specific bar.
But if the fraud is there?
No, who will go into the fraud? So today you are complaining about fraud by whom? Not by me, by your directors. You please go to the company tribunal. You should have got appropriate protective orders from your company tribunal. That's your forum. So, well, that's my preliminary objection. You have initiated a proceeding under 241, 242. So, well, today, that's what I said. They are before the NCLT. So, well, there is no, to the best of my knowledge and to the best of the documents that they have disclosed, there is no protective order or any order, so to say, in their favor. So I am sure they have complained of oppression by the board. They are the 100% shareholder, they claim. So if you're the 100% shareholder, well, I need not tell my learned friend. I'm sure my learned friend is well aware. You can initiate, you take appropriate action on the Companies Act. So if you've not done that, and if you have initiated a proceeding, you don't have any order in your favor, how do you complain of an action taken by the company? And today you say the award, appointment, everything is void.
Yes.
How is that permissible under Order 21, Rule 48? Now, if your Lordship will kindly see Order 21, Rule 50. Well, tomorrow we also have a 12 o'clock.
Tomorrow also?
Yes, ma'am. This matter is fixed. So your Lordship can continue at
Tomorrow will continue.
12 o'clock.
Well, I can just hand over this or bring it tomorrow. These are decisions to show that 430 Companies Act will not be applicable because Companies Act is summary proceedings. Questions of fraud can think.
That's why I put the question. But what is the nature in the NCLT?
So for removing the directors, mismanagement, etc., we can't challenge arbitral award before the NCLT.
No, not award. So what is the prayer before the NCLT?
For this mismanagement of the companies, get rid of these directors. Let us appoint directors on our subsidiary.
And whether this allegation, this is also allegation before with regard to this.
No, we have to be.
What are the grounds in your application before the NCLT?
I have attached NCLT with my to take the thing, but the point is that before the NCLT, we have traced the entire history to show that this is the way these three persons are masquerading as directors, colluding with the petitioner. He can't just distance himself that we are between them only. That there's a collusion between them and they've taken the arbitral award to show as the instance of mismanagement. But the relief there is more to do with the mismanagement of the company, operation, etc. I cannot raise a ground or impugn the arbitral award with the NCLT and their decisions on this point that the NCLT has no jurisdiction to get into issue of fraud. If it's a question of fraud, go to civil court.
In that case, that whether you have initiated in a civil case against the company with regard to the fraud which you had to prove in the
that's the civil suit or I was non-suited
in the application.
No. I had precisely for that reason I had filed the civil suit before this honorable court where I've been non-suited on Order 7 Rule 11.
No. In the suit, you have challenged the award.
Yes.
You have challenged the award.
And
you have not taken that the directorship. What?
Yeah, that also taken.
What are the prayers in the suit?
The prayers in the suit were apart from arbitral award that these directors are masquerading. They're not directors. We remove them, restrain them, tell them to give back the property. We've taken that, which is the reason it was partially rejected. It was allowed to that extent, but honorable division said no, the entire thing must go. And the Supreme Court, when we argued it out there, the issue is that when your execution is pending, NCLT is pending, the court says you've invoked your remedy. Order 21, Rule 58 is a civil suit by itself. So if it's tried as a civil suit itself, then why do you want to go on the original side of the Honorable Calcutta High Court? You proceed in the execution. So these are judgments of the courts to show basically that NCLT cannot get into allegations of fraud. That's a summary proceeding in NCLT. 430 Companies Act jurisdiction. 430 Companies Act does not exclude the jurisdiction of the civil court.
That is the
that is the law. So that way I'll bring this tomorrow. I'll cite that tomorrow. So tomorrow at 12.
No, 12.
Well, I'm deeply obliged for a patient hearing.
Son suffering from the plaintiff. Sir. Applicants have filed an application being J1 of 2020.
Just mail it. Can I share you my email ID?
The applicants had argued at length, but due to paucity of time, hearing could not be completed. The matter is already fixed on 10 at 12.
Before my lord rises, my lord, there is my lord will recall, there is a originating summons suit where my lord, the mother had given the properties to the two sons, my lord, in respect of a flat, my lord, we had filed an original summons suit, my lord, where my lord had called upon the society to come back, my lord, because the brothers were unanimous, the beneficiary and the executor all unanimous, my lord. This is item 15 today, my lord. My lord has called till 14, my lord. My lord, I was only beseeching, my lord, can accommodate it for 5 minutes at 3:45, my lord. It can be disposed of today, my lord.
Oh no, 3:45 because
Or 4:30 whenever, my lord. Or tomorrow, my lord. Because after tomorrow, my lord will be, my lord, not available for some time. This will get delayed.
Wait for 1
My lord, kindly, my lord. This is kindly, my lord. I will be humbly beseeching, my lord. The parties are from, my lord. They're not from India, my lord. They have been, my lord. Kindly, my lord, if can accommodate this today or tomorrow.
What is the matter?
My lord, the matter, my lord, recall, the mother had left a will, making two sons beneficiary of all her estate, plus a lady who was her niece. Now, my lord, who was the executor also. The will was probated. The properties have been divided. The entire probate has been given effect to except one flat which is a Ballygunge flat, which is a society, my lord, where the society says that if a person has to stay there, he has to give an undertaking that he has no other flat and that he intends to physically reside over there. These undertakings he cannot give because he is a resident of London, my lord. So, my lord, in these circumstances, we had prayed, my lord, that we want to sell off the flat and route the money to the trust.
Yes, sir.
My lord will recall. So, it's very short matter, my lord. Kindly, my lord, accommodate us today, tomorrow, whenever.
In B.
Or tomorrow early, my lord. Whenever, my lord.
No. Okay, your matter is the next matter.
Yes, next matter.
So after the fixed matter, if it is time permit,
I'm deeply obliged. I'm deeply
the
obliged.
next matter, it will become on the serial.
We thought this would go on, my lord.
No, this is
Yes, yes.
May I have your lordship leave to mention item number 48 of non-commercial list, your lordship. The lordship was pleased to direct that matter to be listed as undefended suit.
48?
Yes, your lordship. As undefended suit, but it is appearing as in the suit list, your lordship. Lordship, can I? And your lordship, the matter was fixed for witness action. If your lordship can accommodate me any date after vacation, your lordship, for witness action.
Seventh May, witness action. Have you filed the judge's brief document?
Yes, yes, your lordship. It is duly filed, your lordship.
Record and order. 47?
48.
48. Census and suffering for the plaintiff. As per the order dated 3rd April 2024, the suit is listed as undefended suit, but inadvertently it has been listed under the heading suits. In view of the above, let the matter appear on 26th June 2024 under the heading undefended suit for witness action.
If your lordship fixes any time, your lordship. Much obliged, much obliged.
If your lordship takes up, my lord, I know this is not the time for mentioning, my lord. Item number 56, my lord. My learned friend is on the other side.
I appear for the defendant, your lordship, actually.
Yes.
I appear for the defendant.
Interim order is expiring today, my lord. Your lordship on 1st of May had directed that I should file my affidavit in reply by 7th of May, and had kept the matter today, my lord. But I have done that. I have also served the copy, my lord. But the interim order is expiring today. My lord, if it is not taken up, my lord,
You are
the plaintiff.
Your lordship, for the defendant, your lordship, only one thing, item number 69 and 70 in your lordship's list. Your lordship, those are all connected matters. In item number 70, I don't believe that they have filed their opposition. So, lordship, all the three are connected. Your lordship, all the three applications be taken up together. Your lordship, that is my only prayer.
Yes, those can be taken up together, my lord.
But we have filed the affidavit.
Affidavit in GA1, which is
69 and 70.
No,
that
GA3 in 70 they have not filed. 70 they have not
20 have not filed, my lord. 69 and 56, the pleadings are coming.
And is also not 70 is an application where your lordship, my grandfather funds have been siphoned more than 2.83 crore. So I'm seeking that money should be returned by the
one
plaintiff.
thing is, my lord, one thing which I want.
These are complicated. I am not extending. Yes.
My lord, only thing is, my lord,
Call the matter. Call the matter.
And I have my in the probate proceeding, I appear for the propounder, my lord. My witness was in the box. Cross-examination was going on. Yes, he is present.
My lord, Mr. Jishnu Chaudhary is leading me in this matter. May I just
continue?
Yes. Subhashi eसे गए. Subhashi eसे गए.
একবার exhibit 1টা দেবেন
अपना नाम
महेश कुमार केजरीवाल.
महेश कुमार केजरीवाल.
Mr. Kejriwal, I'm showing you a document which is exhibit 8, exhibit 1. Kindly seize this document and tell who has drafted this document.
हाँ.
Sorry, Miller. Yes, yes. Just put the question.
Who has drafted?
वो जी ने किया था, मुरारी मोहन केजरीवाल जी ने किया था.
This document drafted by
From the
my father, that is Mr. Murari Mohan Kejriwal.
एकदम देखिए नोट शेयर करा बेनिफिट I was reading yesterday. In the morning, he asked me, what will you do? So I said, now it's so easy to share notes that I'm sharing my note with you. Continue. And it's so much beneficial for everybody.
Correct.
That's why it's a paperless now.
Paper.
I'm trying, Millard. I've taken it up very seriously. By October, I want to be paper free. Good. Let's see. Please see all the volumes. It's all here. That done with your lordships. please come to paragraph 2 of the will. You will find that your father has used the word seized and possessed. Do you think this is normal language used by an advocate while drafting a document? The 5th line of paragraph 2.
सर क्वेश्चन क्या है?
आपको क्या लगता है कि and possessive term?
My father was become an LLB.
Is it your evidence that the will was drafted by your father?
पिताजी ने ये ड्राफ्ट किया था?
नहीं, मैंने हमको नहीं पता है.
I don't know whether my father was drafted or not.
Was there an advocate present at the time of registration of the will?
एडवोकेट था जब will का रजिस्ट्रेशन हो रहा था वहाँ पर?
जब विल साइन हो रहा था तो हम नहीं था वहाँ पे.
वो पूछ रहे हैं कोई एडवोकेट था वहाँ सर?
नहीं उस समय नहीं उस समय एडवोकेट नहीं था.
Don't.
Please. No, he said something.
Please.
That should go in.
What is your
Please,
name?
I've asked a question. Interpreter is there.
What is his name? What the witness stated first? Witness stated first, my lord, that he was not there at the time of. So why you are not interpreted that? Sorry, my lord. I was not. You are playing with a witness? No, my lord. I was not there at the time of registration of the will.
Registration, execution, registration.
Registration.
No.
It is registration.
It is registration, not
Question has come as a
execution.
registration.
We have, my lord, learned. With interpreter will decide if you're not happy with the interpretation, indicate to the court. I request my learned friend not to say anything
Directly.
has the effect of leading the witness.
Yes, continue.
I also will not refrain, my lord. Did your wife, Alka Kejriwal, indicate to you whether any advocate was present at the time of registration of the will?
अलका केजरीवाल बोली कि डॉक्टर केडिया साहब आए थे, डॉक्टर दीपक लाल का आए थे और एक
केडिया साहब,
दीपक लॉयल का साहब,
दीपक
लॉयल का और एक रजिस्ट्रार साहब आए थे.
There was present Mr. Palika. My wife told me, namely that and so
अलका केजरीवाल,
Alka Kejriwal and Deepak Kejriwal.
दीपक लॉयल का.
My wife Alka Kejriwal told to me that Deepak Kejriwal and
Deepak Loyal ka,
Deepak Loyalka and
डॉक्टर केसी केडिया,
register office and
डॉक्टर केसी केडिया.
Dr. K.C. Kedia along with one officer of the registration office.
हाँ.
who according to you organized the registration at your residence?
सर फादर ही किए थे.
My father organized.
मोस्ट प्रोबेबली वही किए होंगे.
Most probably my father organized the registration.
Did he do it directly with the registration office or did he organize through an advocate?
सर वो मेरे को नहीं पता है.
I don't know that.
And for the first time, you came to know of the will in the evening of the date of execution of the document.
When I came back home, my wife and my father both told me.
When I came back home at that time, my father and my wife informed me about the will.
Did you have a copy of the will after it was registered?
विल साइन होने के बाद रजिस्टर्ड होने गया और जब रजिस्टर्ड होके आया बाबूजी ने अलमारी में रख दिया.
After the registration done of the will,
After execution of the will,
it
was went for execution and registration, and after the registration, my father has kept the said will in the Almira.
और हमको बताया कि इसको जब हाँ कि इसको जब दरकार होगा निकाल देना.
and inform me that if you need this, then you can take this from the Almira.
Question is repeated. Did you have a copy of the will after it was registered?
आपके पास कोई कॉपी था रजिस्टर होने के बाद?
No.
Did you know the contents of the will after it was registered until the time of your father's death?
आपके पिताजी के मृत्यु होने तक आपका इस विल में क्या लिखा हुआ है आपको पता था?
हाँ पता था.
Did you read it?
आपने पढ़ा था?
बाबूजी बताए थे हमको जिस दिन बिल एग्जीक्यूट हुआ था उस दिन बाबूजी बताए थे.
सिंपल क्वेश्चन आपसे पूछे हैं, आपने पढ़ा था या ना पढ़ा था? पढ़ा था आपने?
पढ़ा था?
वकील साहब का सीधा क्वेश्चन है, पढ़ा था या नहीं पढ़ा था?
सर बाबूजी बताए थे, पढ़ा था नहीं पढ़ा था याद नहीं है हमको.
सर बोलिए आप.
राइट नाउ.
ठीक है लिखे नहीं.
Yes.
In 1996, after the oral family settlement, were you not exclusively taking care of the machine division of the family business?
In 1997, I found my company, Parijat Vyapar Private Limited.
I found my company Parijat Vyapar Private Limited.
Parijat Vyapar Private Limited, and I was exclusively looking after machines of that company.
Were you involved with the Foundry division in any way?
जब फाउंड्री में दिक्कत होता था तो पिताजी के बोलने से हम इन्वॉल्व होता था.
As per the I used to involve
Whenever some difficulties in the foundry, as per the request of the father, I used to interfere.
Was this before or after 2001?
पहले और बाद में.
Sir, even after 2001.
Even after?
2001.
Even after 2001.
Wasn't the foundry closed in 2001?
Foundry was never closed, sir. Foundry was closed only in 2007.
It is your evidence that the foundry business continued and the foundry was operating even up to September 2002. Would I be correct?
Foundry business September. Yes, put the question. फाउंडरी बिजनेस सितंबर 2002 तक चालू था, ये क्या सही है?
फाउंड्री बिजनेस 2007 में बंद हुआ
फाउंडरी बिजनेस वाज क्लोज्ड इन 2007.
ना। वो कब हुआ 2007 में, बट 2007 में बंद हुआ। हाँ।
Was your
The foundry business was closed in 2007, but I cannot say when.
Was your father involved in the foundry business after 2000-2001?
Yes, sir. He was involved in the business. Foundry business.
When did he cease to be involved with the foundry business?
2000 till 2005, father was involved in foundry business. Again, in 2007, Vaishya Bank reported to BFR कि Ramesh has sold all assets
Reported
to BIFR.
BIFR. BIFR.
BIFR कि Ramesh has sold the entire assets of Foundry. I asked father, what is this happened? Father told कि after 2005, एक दिन रमेश बाबूजी को धक्का देके ऑफिस से निकाल दिया, तब से नहीं देख रहे हैं वो फाउंड्री।
One day Ramesh has ousted my father from the office. Since then, my father not look after the business. Not look after the business. Was not looking after
Foundry business.
business.
Were there creditors of the foundry division in 2002? 2001-2002?
Yes, sir.
Yes.
Were these creditors ultimately paid off by your brother Ramesh?
सर क्वेश्चन क्या हुआ? Partly.
Partly.
Do you mean to say that creditors remained to be paid?
Some creditors, Ramesh was to pay the creditors as per the family arrangement. Arrangement. But he did not pay. The creditors were paid by father Murari Mohan Kejriwal, Mahesh Kumar Kejriwal, my mother Savitri Devi Kejriwal,
Savitri Devi Kejriwal,
Alka Kejriwal,
Alka Kejriwal, my wife Alka Kejriwal.
This is with respect of the liability of Vaishya Bank.
So you and your parents paid off Vaishya Bank, or did you also pay other creditors?
Vaishya, we have paid to Vaishya Bank also and others also, partly.
Which other creditor did you pay?
बाबूजी SK इन्वेस्टमेंट को पेमेंट किए थे.
My father paid to the SK investment.
I paid money to Shri PR Lohia, PR Lohia, PRLOHIA, and Ram Surat Jaiswal. Ram
Surat
Jaiswal.
Were these creditors disturbing your father?
परेशान करते थे आपके पिताजी को.
I don't know.
I don't know.
Were any of the creditors disturbing your father?
हाँ, बाबूजी को डिस्टर्ब करते थे.
Yes.
Who were these creditors who were disturbing your father?
Disturb करता था कौन creditor?
मेजर डिस्टर्ब एक गोयल जी बोल के थे, वो डिस्टर्ब करते थे बाबूजी को.
There was a namely Mr. Goel who disturbed my father.
When did Mr.
Disturb my father.
When did Mr. Goel stop disturbing your father?
कब बंद किए थे disturb करना?
After the death of Goel ji.
After the death of Mr. Goel.
Sorry?
After the death of Mr. Goel.
This Mr. Lohia, who was a creditor, is he not your father-in-law?
Yes, sir. He is my father-in-law.
Your evidence is that your father-in-law was harassing your father for payment.
Mr. Goel used to harass father.
And when did Mr. Goel die?
Sir, I have to check.
So in all, there were 3 creditors, according to you, harassing your father.
Mr. Goel, Goel साहब बाबूजी को डिस्टर्ब करते थे.
Mr. Goel used to disturb my father.
लोहिया जी और राम सूरत हमको डिस्टर्ब करते थे.
Mr. Lohia and Mr. Ram Surat used to disturb me.
Because I was guarantor to the loan to Ramesh. Ultimately, I have paid.
When did the disturbance by creditors ultimately stop?
After the death of Mr. Goel, who was disturbing my father, and after I have paid Mr. Lohia and Ram Surat ji.
Mr. Lohia and Ram
Surat, Ram Surat
ji.
Jaiswal
Ram
ji.
Surat Jaiswal ji.
Have you ever alleged or stated that liability of the Foundry division was about 20 crores?
I do not remember, sir.
You do not recollect right now. Remember.
How much, according to you, was the liability of the Foundry division, say in 2002?
I have a figure which Ramesh has paid the liability. He has mentioned in company law board that he has paid to the bank 50 lakhs and the liabilities which I have mentioned earlier are paid. And rest of the liabilities people filed 138 एक 138 सेक्शन में केस फाइल किया.
Rest of the people filed a case under section 130. Rest of the people filed a case under section 138 NI Act.
हाँ 138B में
NI Act.
हाँ
No, NI Act.
हाँ चेक
What is
बाउंसिंग का
telling
केस,
that it be con-
चेक बाउंसिंग केस. All the cases were dismissed in the favor of Ramesh, or he did not pay to anyone.
From 96 till his death in 2016, 17,
18. Babuji ka.
till 2018, it was you who stood by your father, correct?
96 से 2018 तक आप आपके पिताजी के पास में थे.
हाँ फादर के साथ थे.
Yes, I
Your
was
father,
my father.
your father relied on you and no one else during this phase of his life. You agree with that?
हाँ बाबूजी हमको विश्वास करते थे.
Yes, my father. Hey, Manatur.
Now let us look at the flow of events. In 1996, a debt-ridden Foundry division went to your brother, while the machine division came to you. Would you agree with that?
No, sir.
No.
Can you give reasons for your disagreement by saying what
I
is
can
wrong
give
in the suggestion?
हम रीजन देगा. In 1990, our 5 partnership company closed because of the government policies. From the earning of these companies, we bought Foundry division. Bought B-O-U-G. Bought Foundry division. In 1995, from 1990 to 1995, entire family was doing the foundry business. There was no machine business. In 1995, Vaishya Bank given limit of approximately 5-6 crores. The business was booming. अच्छा चल रहा था. On 10th June 1996, खाने के टेबल पे माने डाइनिंग टेबल रमेश told father and mother कि I cannot work with Mahesh.
10 June 1996, Ramesh told to my father while Mother, in the dining table, that I cannot proceed with the business.
I cannot work with Mahesh together.
Cannot work with Mahesh together.
Together. By that time, हम लोग उसका शेयर कैपिटल 1.5 करोड़ रुपया से बढ़ाए थे हनुमान फाउंड्री का.
बढ़ाए थे.
हाँ, we have injected 1.5 crores in 95 in Hanuman Foundry. The business was giving good profit, which can be shown in the balance sheet of 95-96 of Foundry. It was decided then कि हम अपना अलग काम, I will do separate business. There was some machines in 1990 of the Foundry partnership companies. And I floated a company, Parijat Vyapar, in 1997 with 2000 capital. It's a private limited company. We can see the capital in the portal also. And I started buying machine and but Foundry was suddenly I came to know in 1998 it was referred to BFR and Ramesh Vaishya Bank DRT में केस कर दिया.
Vaishya Bank filed a case in DRT.
And it was referred to BIFR. BIFR.
Simple question. Still hasn't answered it.
So the Foundry was running good. You wanted to...
ठीक है आगे बोलिए. बस
बोलिए
इतने
बोलिए.
ही
We are
है?
waiting.
बस इतने ही है.
हाँ.
ठीक.
Witness, you are not arguing 10F appeal filed on your behalf under the Companies Act. You are giving evidence in a probate suit. Please listen to the question and answer it. Preferably in one sentence, 1 or 2 sentences. Please repeat the earlier question. যেটা আগেটা সাজেশনটা বলুন.
আগে সাজেশন যেটা ছিল.
1996. 1996.
1996.
Going to your brother while the basic division came to you.
Simple question. Did a debt-driven Foundry division go to your brother while machine division came to you? Yes or no? In 1996.
Debt-ridden वाला बात माने Foundry division gone to Ramesh, but debt-ridden वाला बात में हम ये explanation देना चाहता था.
Write that, please.
But I want to give explanation.
Which I have given.
It is correct. Foundry division went to Ramesh, but with regard to
Debt, I wanted to give an explanation which I gave.
debt, I have given the above mentioned explanation.
Sir.
Yes. Next.
Shown page 2058 of Judges Volume 7 of Judges Brief of Documents. Do you recognize what is this document?
हमको ये डॉक्यूमेंट क्या बोलना होगा कि अच्छा, मैंने यस
वो क्या डॉक्यूमेंट है बताइए, बता
अच्छा,
सकते हैं?
हाँ सर, दिस इज अ BFR order regarding Hanuman Foundry and Engineering Company Limited. Summary record of proceeding of the learned of the hearing held on 23/5/2002 before the bench consisting of Sri N.R. Banerjee and NPC members.
It may be marked as an exhibit. কত exhibit কত হবে বলো? হ্যাঁ 3 exhibit 3
তোমার exhibit B হবে তোমার exhibit but this is part of a other document.
Exhibit B.
Page কত থেকে কত?
তো the order থেকে বলে
কত থেকে কত?
Exhibit B within bracket
2058
page
no
2052
2057 2057 to 2066. No. Yes, 2066. Okay, no problem. So I'm praying for leave to exhibit 57 to 66.
057 to 2066.
দেখতো আমি কোথায় mark করেছি? Would you be surprised to find that in the BIFR order, it is recorded that the foundry was shut from 2001, which would show that your evidence to the contrary today was totally false.
कहाँ लिखा हुआ है?
2001 में किया,
अच्छा
2001 में
अच्छा एक हम समझ गए.
See paragraph 10. Otherwise 1 hour will be lost. Fifth line of line, paragraph 10. মার্ক করেছিল কোথায় গেল বলতো? আমার নোটে দেখতো কোথায় আছে? সব মিথ্যে কথা বলছে. Have you seen paragraph 10?
एक बार
Have you
देख.
seen paragraph 10? Yes or no?
No, अभी नहीं दे. हम पढ़ रहा है इसको.
I've asked you to read paragraph 10.
Paragraph 10 पढ़िए.
The
Paragraph 10.
branch drew the attention. अच्छा.
पैराग्राफ 10 पढ़ के बताइए, उसमें लिखा है कि 2001 में जो है फाउंड्री बंद हो गया था.
5th line.
सर इसमें लिखा हुआ है केजरीवाल स्टेटेड फैक्ट्री वाज क्लोज सिंस 22/10/2001.
Yes, it is written on paragraph number 10 that the factory.
It is stated that Kejriwal stated that Foundry
फैक्ट्री वाज क्लोज सिंस
factory was closed
22/10/2001.
22 October 2001.
Which Mr. Kejriwal was this? Your brother or you or your father? I have not asked you to look at any other document.
अच्छा
Why did you turn the page?
ये जो केजरीवाल कौन सा केजरीवाल है?
सर हम देख लिया उसको डॉक्यूमेंट्स में हम देख गया माय फादर वाज
His father.
आपका फादर.
हाँ.
It was my father.
So do you admit that your evidence given before my lord today that the factory was functioning till 2007 is totally false?
फैक्ट्री बराबर बंद हो रहा था चालू हो रहा था मे बी उस समय बंद था वापस चालू हो गया
The factory was sometime open and sometime was closed, but at that time, but it was continued till 2007.
हाँ हाँ. क्या बोले आप?
सर फैक्ट्री जैसे झमेला हुआ बंद हो गया फिर चालू हो जाता था और 2007 में
Continuous process.
When there
बंद होता था,
was
चालू होता था.
dispute, it was closed, but sometimes started running, sometimes closed.
हाँ.
यही है ना?
हाँ हाँ हाँ
When did it reopen after October 2001? You said you were consulted by your father. When did it reopen?
सर आई हैव टू रीड मतलब फैक्ट्री बंद होता था चालू होता था
How many times did it shut or open? Shut and open. How many times did
many
it shut
many
and
a
open?
times sir many a times
Many times.
many a times
Please give the number of times according to you.
in a year 5 times बंद होता था minimum
In a year,
In a year, about five times.
Minimum. So your evidence is that from 1996, every year the factory would shut down 5 times and reopen 5 times. And this continued up to 2007 when it ultimately shut down. Is that a correct understanding of your deposition?
आप जो बोले उसमें एग्री नहीं है हम बता सकते हैं हम क्या
I do not agree whatever you have asked me.
फ्रॉम
But I can-
99
but I can
ऑनवर्ड्स
explain.
फैक्ट्री बंद होता था
Huh?
फ्रॉम 99 ऑनवर्ड्स फैक्ट्री साल में मिनिमम 5 बार बंद होता था
From the year 1990 onwards,
1999
1999 onwards, the factory was used to sometime open and sometime closed. That is 5 times in a year.
I am suggesting to you that you have yourself filed a suit indicating that there was liability in excess of rupees 20 crores of the Foundry division. What do you say to that?
सकते हैं और नहीं भी मान सकते हैं। इस मनी की नहीं कर रहा हूँ। Contract.
119.
हमको चेक करना होगा सर
I have to check.
Shown page 120, volume 1 of the judge's brief of documents. Please come to paragraph
13
120
13
119
within bracket B and C and answer the suggestion. বার করে দাও, page 135 বার করে দাও। Just look at these two subparagraphs and answer the question. बोले दीजिए
ये क्या चीज है सर?
13B and
ये क्या चीज है सर?
13C.
Page number 135.
Sir, in page number 135, it is written to settle the outstanding dues of the unsecured creditors of the said company, aggregating to a sum of rupees 20 crores 90 lakhs 45,580. A schedule of liability including several pending criminal cases for the checks hitherto bounced is annexed here and marked D.
Witness, I am not doubting that you can read English. I am asking you to agree to my suggestion that you have yourself said that the Foundry division had liability in excess of 20 crores. Yes or no?
Can I see this application? हमने लगाया है, कौन लगाया, देख सकते हैं?
पहले आप आंसर दीजिए कि आपने केस फाइल किया, उसमें लिखा है कि फैक्ट्री डिवीजन का 20 करोड़ से ज्यादा लायबिलिटी है, ये सही है या नहीं है, पहले बताइए।
This is right, sir.
Correct.
This is
बस that is all. And in paragraph 13C, you have also stated that there was great distress and harassment from banks and other creditors. Is that correct? Now come back to page 123. Do you find that you and your father jointly filed this suit?
Yes, sir. Yes, sir.
That I'm praying for leave to exhibit the plaint in civil suit number 189 of 2009 as an exhibit.
Not exhibited.
Not exhibited. Exhibit है ना तो?
Page where?
Mark for identification because he said
Page
without
starts from
118
to
182.
page 118 to 182. That is the suit.
Yes.
CS number
189
189 of
2009.
2009. 2009.
Oh, I'm sorry, Millard, my mistake. It should be from 119, not 118.
Is marked as exhibit.
C.
Yes, next.
Yes. Now that you have seen the statement your father made before the BIFR, would you admit that in 2001, when the 2013, September 2002, when the family settlement in writing was executed, the Foundry division was shut and had liabilities in excess of 20 crores.
No, sir.
I suggest to you that your answer is totally false. I also suggest to you that under the family settlement,
Just a minute. Suggestion what you said. आपने जो अभी आंसर दिया वो गलत है.
no.
ये सुझाव दिया, आप उसको मानते हैं कि नहीं मानते हैं?
No, he has not given the answer.
No, he said no.
No, then okay.
He said no. I don't agree.
No. Okay.
No. Oh,
Yes.
then I said your evidence is false. He said no.
Okay. Next.
I used to, Millard, to digress. Before Justice Bhaskar Bhattacharya, I was once cross-examining during lunch in an arbitration. During lunchtime, he said that, do you expect your witness to agree with you? Why do you keep at it? Learn to give up. Very valuable.
That's correct.
And then I actually,
That's why in the civil suit, when I was practicing, I used to tell my clients, if I am the plaintiff, I used to tell my client, see, pleadings up till the framing of issues, it was my duty. Once you come to the dock, it is your duty to prove your case.
true, that is also very true. I have seen so many cases where the trial has gone wrong because of the client.
Two questions. Finish. Because here there is no benefit of doubt.
No.
In the criminal, you can get the benefit of doubt, but in the civil, you will not.
Criminal case I've never done.
In the criminal case, benefit of doubt you will get. If
But-
you lost one question, you can cover in the other question. But
Here it's gone.
and most this probate matters. Probate matter is very tough
Very, very difficult. Very challenging.
if it is contested.
That is true. কি জিজ্ঞেস করলাম তখন? No. I suggest to you that when the family settlement of 2002 was entered into, the machine division did not have much liabilities and was worth much more than Foundry division. And this has been held by the company law board.
अब इसको मान भी सकते हैं कि नहीं भी
क्या
मान
सोच-
सकते
क्या
हैं।
सोचा
तो
हुआ?
सितंबर 2002 में जो फैमिली सेटलमेंट हुआ था, उसमें जो देखा गया था कि जो फाउंड्री डिवीजन का बहुत कर्जा था।
फाउंड्री डिवीजन का लाइबिलिटी ज्यादा था और आपका इसका कम था।
क्या कम?
क्या बोलना है?
आप इसको मान भी सकते हैं, नहीं भी मान सकते हैं। एग्री कर सकते हैं,
नहीं,
disagree
हम एग्री नहीं करते.
I disagree.
What had actually brought about the family settlement in writing in 2002 is not what you have deposed today, but by the fact that your father was completely harassed by SK Investments and the check bouncing case which you had set up.
में फैमिली सेटलमेंट इसके इन्वेस्टमेंट के द्वारा एक किसी लोग को इसके इन्वेस्टमेंट तो बोलो এটা বলতে 2000 सितंबर 2002 में फैमिली बिजनेस जो फैमिली सेटलमेंट हुआ था, वो जो कुछ भी आपने कहा वो ठीक नहीं। और तापर बताओ, तो बोलो। इसके इन्वेस्टमेंट के द्वारा आपके पिताजी को हैरेस किया गया था और एक चेक बाउंस केस आपने फाइल किया।
I did not file any check bounce case.
I have not
Father was
filed-
harassed by SK Investment, no doubt.
I have not. Okay. I have not filed any check bounce case. इसके इन्वेस्टमेंट
Father was harassed by SK Investment, comma, no doubt. Full stop. Then
Yes, next.
हाँ, but I have not filed any check bounce.
That has recorded.
after 2002, your brother Ramesh Kejriwal was debt ridden and he had no money, to the extent that for inability to pay 30,000 rupees to the Provident Fund authorities, he was detained in custody for 3 days. What do you have to say about that?
दो के बाद मिस केजरीवाल बहुत कर्जे में थे। इतना इतना का कर्जा था कि उनके पास इतने भी पैसा नहीं था कि 30,000 रुपीज प्रोविडेंट फंड को देना था।
माने Ramesh was having no money.
वकील साहब का बोलना है रमेश के पास कोई पैसा भी नहीं था, जबकि 30,000 पीएफ को भी नहीं दे पाया, इसलिए उसको 3 दिन कस्टडी रहना पड़ा।
कस्टडी में उनको रहने पड़ा।
Ramesh did this thing intentionally. He even did not contribute money for funeral of my mother or his mother.
For the funeral of my mother.
And within 7 days of death of my mother, he bought Chevrolet car at 24 lakhs.
Chevrolet car. He purchased Chevrolet car at the rate of rupees 24 lakhs.
And during that period, I have got he kept money if खूब इंश्योरेंस बनाया मैंने एक तरफ जेल जा रहा है एक तरफ इंश्योरेंस बना रहा है
Purchase many insurance policy.
he has done that thing intentionally.
Yes, next.
I suggest to you that you are continuing to give false evidence. Since after Foundry division had stopped, your brother Ramesh for some time worked as an insurance broker. Are you aware of this fact?
हम नहीं जानते.
I don't know.
And all this while, your machine division and Parijat Foundry, Parijat Vyapar did extremely well, for which you would support father and mother financially. Do you agree?
I have always contributed in family. If Ramesh has not contributed, I given my contribution. को ज्यादा करके दे दिया.
Given your contribution.
हम अपना contribution दिया, रुपया कम था तो और दे करके family को सफर नहीं करने दिया.
But if Ramesh not paid, then I have contributed more. If Ramesh not paid, then I have contributed more money so that the family
Should not suffer.
should not suffer. So the family should not suffer.
At your
का wife और बच्चा भी involved है.
And
माने because it's a joint mess, तो जैसे माने हमारे माने his family was also there within our.
Because it is a joint mess. Because it is a joint mess, so his family also there in the family.
Are you not responsible for filing a suit against your brother Ramesh for recovery of money that you spent for taking care of your father and household expenses?
In accordance to family arrangement, जो चीज के लिए हम entitled था, हम उसका केस उसके ऊपर किया.
The thing which I am entitled, for that I have filed a case.
According to family arrangement of 29 September 2002.
According to the family arrangement dated 29 September 2002.
Yes, how much time will take?
Let me take time.
Let's fix tomorrow.
Tomorrow's my lord's last day before vacation.
Vacation.
And I must say this, my lord, I am very envious.
कल शेष हो गया तो
I couldn't resist, kindly forgive me. Lord, coupled with the fact, my lord, that I am not getting a vacation this time. But all of it put together, my lord.
I'm getting the vacation before vacation.
Pre-post.
I am very jealous. My son will, my lord, start college, so admission procedure, etc. So no vacation this time.
3 बच्चों काल किया था मुंबई.
No, clat.
Flat. That last list comes out on 28th. Admissions start from first week of June.
Okay.
So I am stuck. Wherever he
I have
takes
to
me, I have to go.
You have to go.
Yes.
Consistency of for the plaintiff. ठीक है, तर जाइए कल आइए. The plaintiff witness, na?
Yes.
Yes.
Plaintiff
Witness number 2.
Examination received during the prosecution. Two documents is exhibit B and C. Exhibit B and C. They are marked due to paucity of time. Cross-examination could not be completed. Cross-examination is deferred. The matter is already fixed on 10th of May 2020.
Obliged.
But in the Jalpaiguri, much more workload is there.
Yes, Willard.
Oh.
Much workload is there.
Oh, in Jalpaiguri.
Jalpaiguri.
Oh, Lordship is going to Jalpaiguri?
Yes.
Oh, I thought it was.
No. The better vacation place.
Not vacation.
No, this is not going to be.
Not vacation.
No, let's see us come down.
জলপাইগুড়ি অনেক কাজ।
Yes.
My application under chapter 30 for recovery of money lent and advanced.
What has happened to the appellate court order?
It's still there, my lord.
It's still pending. So what can be done? Let it be continued. Yes.
That if your lordship has IAGA 3 of 2021.
Yes.
Well, at page 16, if your lordship takes minute, is the plaint.
Yes.
Well, at, paragraph 5 at page 18. Defendant agreed to make payment of the entire principal sum of 36 lakhs along with agreed interest thereon to the plaintiff company. In due acknowledgement of his liabilities aforesaid, the defendant company on 30 December. No, first let me show the paragraph 3. I'm sorry. In or about November 2000, I'm sorry,
Yes.
page 17, paragraph page 17. In or about November 2011, the principal officer representing defendant company approached the plaintiff company's office for a financial accommodation of 36 lakhs to execute work order obtained allotted for government defendant company. It was represented to the plaintiff that such funds from the plaintiff company would enable the defendant company to cater immediate financial. Relying on the aforesaid representation and believing the same to be true and correct, the plaintiff lent and advanced a sum of rupees 36 lakhs to the defendant by way of RTGS. Such payment was made to the plaintiff to RTGS drawn on Yes Bank, Dalhousie branch. Loan granted to the plaintiff will be carried in compounded at the rate of 12% per annum. A copy of the bank statement of the plaintiff evidencing such transfer is A. Annexure A, Millard, to the plaint is at page 26. But in my copy, I don't know why it's marked B. Hey, yes. Annexure A হবে এটা এটাই তো
Annexure B. Annexure B.
Yes, annexure B. Millard, 30th December 2011. It will be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th entry from the top.
Yes.
30th December entry, your lordship sees.
30 December.
30th.
Yes.
RTGS, Gujarat Eco Textile, the defendant. This is the amount.
Yes.
36 lakhs. Thereafter, Miller, paragraph 6, in due acknowledgement of its liabilities aforesaid, the defendant company on 13 December 2012 made a payment of a sum of rupees 48,865 towards interest from deduction of tax at source. Such payment was made by the defendant company by check number 104760 encashed by the Clinton Conjure Bank at Axis Bank, Kolkata within the jurisdiction. Such amount is reflected in the bank statement, copy whereof is marked B, it should be C. The statement of Millard, 1, 2, 3, fourth entry from the bottom.
Yes. 48,660. Yes.
Thereafter, Millard, if your lordship Millard kindly comes to page 28 onwards. (28) to 31, Millard, if I may trouble your lordship, annexed to the page.
Yes.
Millard, at the top, your lordship will find the period from 1st April 2011 to 31st March 2012 at the top. The balance confirmation.
Page 28.
Page 28, Annexure D.
Yes.
At the top, Millard, vendor ledger from Millard, it could be somewhere over here.
Yes, yes. Yes.
Now, Millard, the summary of the closing balance, the last entry of that page, balance as on 31st March 2012.
36.
36,48,865 is with interest. And your lordship will find that it has been signed by the defendant's representative. With the C.
Who is the defendant?
This Gujarat Eco Textile Park Limited.
Yes.
Lordship turns over the page. So 31st March 2012 will take us to 15. Now, my lord, for the year 14-15, page 29, 13-14.
12-13, 12-13.
12-13, yes, I'm correct. 12-13, your lordship will find there is an acknowledgement of account.
That is 14th.
No, my lord, that is the assessment here.
Assessment, yeah. 14-15 and from 13-14.
For the period 1st April 2013 to 31st March 2014. Just account confirmation.
Yes.
Just
13-14.
Yes. Now thereafter, so 14 will take us to 17.
Yes.
Now, Millard, the third balance confirmation your lordship will find is for the period.
So this is also signed by the defendant.
Yes, all four are signed by the defendant.
Yes. So this assessment.
This is also
15-16.
Yes. Signed by the defendant with stamp.
16-17.
Yes. And thereafter, Millard, page 31 is for the period April 16 to March 17.
Yes. 16-17.
16-17. Now, Millard, on the basis of this, Millard, we gave them a notice of demand, which is at page 32, receipt of which is not denied. And therefore, Millard, I make my claim by filing a suit.
There is any reply? No.
Yes, there's an opposition. I need to show the opposition. Kindly, Millard, take the key. Yes. Now, Millard, your lordship takes the opposition of Dr. Sushil Das, affirmed on
Yes.
7th August 2021. Apart from the usual defenses that it's barred by limitation, it can't.
7th August.
Yes, will it?
Dated 7th August.
My copy says 7th day of August 2021.
Okay, no. Back it is mentioned 21 August, but in the affidavit portion March 21. Maybe. Dr. Sushil Das.
No, Millard, there is another supplementary affidavit. I think
Supplementary is here.
But your lordship doesn't have the 7th mark over here.
7th March.
7th August. Your lordship is. Your lordship is probably looking at the written statement.
No, affidavit and opposition.
The written statement is also annexed to the opposition.
Yes.
Millard, 3 principal points have been taken in defense. One, Millard, this is of course according to me, my learned friend will get to argue better, is the law of limitation they have argued, which is page 5, paragraph H.
Yes.
And Millard, I have shown the balance confirmation to show that the last was of 17. And therefore, Millard, my suit is within 3 years.
When you filed the suit?
I suit the filed in 2021. Millard, the period of COVID, Millard, had intervened. The 2 years had intervened.
8th October 2020.
Yes.
And
8th October 2020. That's number one. The second is, they say in paragraph 5, the said suit is bad for non-joinder and or misjoinder of necessary parties. Why? The plaintiff has not implemented Messrs. High Return Agency Private Limited, having its registered office at 75 Metcalf Street, Calcutta 1. In the absence of High Return Agency Private Limited, the instant suit cannot be properly or effectively adjudicated, and hence the same is liable to be dismissed with exemplary costs. The defendant is a company incorporated under the provisions of the Companies Act 56 and the company name so and so. Outside the defendant entirely engaged in business of providing infrastructure. Then, this is their only defense. In or about 2011, kindly Millard, this is very important. In or about 2011, the defendant availed a financial accommodation of 36 lakhs with an understanding that the defendant would repay the said amount along with interest at the rate of 6% per annum. Millard, if I pause here for a moment, Millard, loan is admitted. That it was no other transaction other than a loan is admitted. It bears interest at 6% per annum is what he says is liable. Then, pursuant thereto, the defendant paid an amount of 54,295 on 31st March 2012 along with tax deductions at source. So,
48.
acknowledge, yes. Acknowledgement is there. Proof of acknowledgement is admitted. Then, thereafter, the plaintiff represented to the defendant that one High Return Agency Private Limited owes certain money to the plaintiff. And the plaintiff instructed the defendant to repay the financial accommodation in a single payment of 36 lakhs, and the plaintiff would waive its claim of interest thereof. The plaintiff requested the defendant to transfer the said sum in favor of the said High Return Agency Private Limited to square up all its dues as full and final settlement.
Defense.
as per the instructions of the plaintiff, the defendant transferred a sum of rupees 32 lakhs to said High Return Agency Private Limited in the following manner. He says that I have paid off 36 lakhs to one High Return Agency Private Limited at your instructions on 3 dates, that is 18th March 2016, 22nd March 2016 and 29th March 2016. This story could have been substantiated, my lord. But the difficulty was, my lord, that the balance confirmation at page 30, if your lordship takes now, if I may trouble, 30 and 31, if your lordship takes.
15, 16.
Page 30, the plaintiff says that the is as on 31st March outstanding, and balance as on 31st March 2017 also is outstanding.
Yes.
So, my lord, if he had really paid it on my account, then there would not have been any balance confirmation. Now, this he realizes. So, what he does is, my lord, he goes on to say, 482, my lord, your lordship will forget, kindly come to S, paragraph S. We filed a criminal complaint, breach of trust, but that's not relevant for chapter 30. It is evident from the annexures of the said application that the plaintiff has forged, fabricated and manufactured documents claiming to be balance confirmation by the defendant, because that was the only thing that was standing in the way. So he had to put up some defense so that the court cannot. So therefore, what he says is that the balance confirmation which I am relying upon at pages 30 and 31, the said documents at pages 29 to 31 of the said application are forged and fabricated and has been manufactured for the purpose of filing the instant suit for recovery of money. The said documents were never relied and or disclosed in the criminal proceedings between the parties herein. However, the defendant has already paid the entire financial accommodation taken by it from the plaintiff, and there is no due and or outstanding payable to the defendant by the plaintiff. Now, my lord, 3 things. One is, there is no particulars of fraud given in the real estate. Number 1. Number 2, my lord, your lordship will find, if your lordship, my lord, comes to page 29 to 31, the balance confirmations.
Yes.
Factually, what he has admitted is reflected in these balance confirmations. Now, all these balance confirmations have 2 aspects. One is the signature and another is the seal. The seal is not disputed.
Yes.
Third thing is, this gentleman does not say whether he is in a position to say that a document signed by the authorized signatory is not an authorized signatory, or that a person is unknown to the company.
That is not a
nothing of that sort. So, my lord, this defense had to be taken because the payments which he could show to High Return, with whom I have no connection,
Yes.
they were in 2016. He could not do anything with that because they were reflected in the bank account that 36 lakhs have been paid to. So to counter that, he has made up this story, my lord, which in my respectful submission, my lord, is not a bona fide attempt, my lord. It's only an, my lord, to, if I may use the word, my lord, to my lord, convolute the facts in such a manner so that the court might get confused. Apart from this, whatever documents I have annexed to the plaint, none of them have been disputed. So, my lord, I would have understood, my lord, that my learned friend would have come with a affidavit either from high return, high tech return, or this gentleman who has signed the authorized, he files an affidavit before the court trying to make it an issue that no, this is not my signature. There is no attempt made. There is only one thing said it's forged. which, my lord, the circumstantial evidence shows that cannot be termed a fraudulent document. This is all. Only one thing I need to say, my lord. And there is no criminal complaint of forge of documents also. Then. Yes, correct. Yes, one more thing. Yes. No criminal complaint lodged of forgery of documents, nor is there any counterclaim filed for delivery upon cancellation of these balance confirmations.
Yes.
Those are the 12% agreement. Only one thing I must say, that in the plaint there is a pleading that it's 12% compound interest. I could not find any agreement between the parties to that, Miller. He admits 6%. I leave it to your lordship. There is no agreement. I could not find it.
Yes.
May it please the spot.
But they had filed we had filed a 482. We had filed a criminal complaint against which they filed a 482. They have disclosed that by way of a supplementary affidavit, and therefore there's a reply. I'm filing it pursuant to supplementary affidavit only concerns that 482 petition.
Yes. May it please the court. There is the first and primary aspect is that there is no agreement between the parties. Everything is verbal. So whatever has to be decided in this particular case will have to come through the way of adducing of evidence and cross-examination. The primary, they are saying that there is no connection between high-rise return private agency and the plaintiff. We are saying that it was due to their our specific pleading is that in the year 2016, the income tax had raided the plaintiff and had frozen the accounts. And that is why they could not accept any payment into the account. And that is the sole reason why we gave the money to this particular company, which was stated by the plaintiff. But nobody.
Where is the case of the CBI and frozen?
I will come to the forgery part. I will demonstrate how forgery is taking place to the naked eye. Your lordships will kindly turn to page 28.
Of the application?
Of
your affidavit?
Of my affidavit. Sorry, my lord, the petition, sorry.
Yes.
This is the original. Now your lordships will kindly see the seal. The bottom part of the seal has a particular marking. Now your lordships will kindly turn to page 29.
Yes.
There is no seal.
No, seal is there, but it is not legible. 29, seal is there, it is not legible. In my copy.
Yes, seal is there.
Seal is there, but it is not legible. After the sign of the accountant of your.
Maybe it is there, but it's completely not there in my copy. Very well. Your lordships will kindly now turn to page 30. Now your lordships will kindly take page 28 and push page 30 side by side and see the difference in the seal.
Got your point, yes.
A star comes in. Lordships will now kindly take the next page.
Yes.
We'll kindly see the seal again. Lordships will compare page 28, 30, and 31.
Yes.
Whose signature it is, we do not know. But even if we take it on the face value that yes, that it could have been somebody's signature from the company, this as per what they are saying, but the seals are different. I have taken a specific pleading with regard to that. Your Lordships will kindly take paragraph 8 of my affidavit in opposition, which is at page 9.
Yes.
Save what are matters of record and save what may appear therefrom. Each and every allegation made in paragraph 3C to 3E of the said application is denied and disputed. I deny and dispute that the defendants, in due acknowledgement of the obligations, had issued balance confirmation for the financial years 13-14, 15-16, 16-17, or by such acknowledgement, the defendants admitted to repay the dues of the plaintiff on demand, as alleged or at all. At the cost of repetition, I state that the plaintiffs have forged, fabricated, and manufactured documents claiming to be the balance confirmation by the defendant. The said documents at page 29 to 31 of the said application are forged and fabricated and have been manufactured for the purpose of filing the instant suit for recovery of money. I deny and dispute that the defendant failed or neglected to make payment. Well, it goes on. So I have taken a specific pleading, and this can only come out through the examination in chief and cross-examination. With regard to the fact that he had specifically stated to me that his account was frozen and that he had specifically asked me to pay this 36 lakhs into a different account, would appear at page 17 of my affidavit in opposition. That is the written statement.
Yes.
The defendant, with intention to repay the amount of rupees 36 lakhs, had issued a check of so-and-so to the plaintiff on 1st March 2016. However, the plaintiff did not accept the same and stated that the bank account of Evergreen Dealers Private Limited had been frozen by the Income Tax Department and represented that one High Return Agency Private Limited owes certain money for the plaintiff, and the plaintiff instructed the defendant to repay the financial accommodation of 36 lakhs directly to Messrs. High Return Agency Private Limited to square up all its dues as whole and final settlement.
Yes.
36 lakhs entered, 36 lakhs went. Now, these are all matters of all factually disputed matters which have to go to trial because they go to the very root of the case. Now, I would like to cite one decision of the Supreme Court in this regard. Your Lordships will kindly turn to the last page, para 8, at page 291.
Yes.
If objections are at the root of the case, it has to go to trial. Lordships will kindly go to the same. 2015, 9 SCC, page 287. Hospital Tower, SM Asif. Two thousand
2015, volume 9, SCC 287.
287.
Yes.
These are my humble submissions.
Thank you. Yes, Mr. Dutt.
Kindly take the opposition once minute.
Opposition?
Yes.
Yes.
It ends in paragraph 14 in your Lordship's copy. Do your Lordship find any verification over there? The statements made in paragraphs blank to blank of the foregoing affidavit are true to my knowledge. So who is taking this responsibility for inviting the court to hold otherwise?
Yes, Mr. Adalji. Where is your verification affidavit?
But I cannot go beyond this because of the fact that this is a change brief which has come to me. So I am not the whatever is there is there. But I
That's
can't.
correct. But how the can be taken as a
Evidence. Who
affidavit?
is taking responsibility for these statements?
Yes.
Your Lordship has admitted.
But it is there as part of our, even as part of our written
Very
statement.
well.
It
I
is
just
there.
showed it, my lord. That number one. আরে দাঁড়া, আমাকে পয়েন্টটা ফ্যাক্টে মিট করতে দিন। Second point which my learned friend took is this, my lord. He admits the fact, as I could understand from his submission, that the entire burden is my learned friend. Now, if something has happened, my lord, there would be some that if there is an income tax raid, then there would be some reflection in some public document. You could have shown it to the court to give some serenity or some amount of truthfulness to the statements that you make. There is nothing before the court. Secondly, my learned friend shows the seals, my lord, to show that there is a difference in the seal so far as the star is concerned and therefore as it is concerned. So, my lord, according to him, all the 4 seals, as I could hear, all the 4 seals are forged.
No, I said page 28 is the original. 29.
You have
30,
said
31.
28, 29.
29, 30,
29, 30, 31.
You have said 29, 30, 31.
Yes.
Actually, this is one moment.
29, 30, 30.
Give me one moment. একবার রিটেন স্টেটমেন্টটা দিন তো, অরিজিনালটা। No, it doesn't have that annexure. So, my lord, coming to paragraph 9, a place which my learned friend, I say that the defendant never, my lord, paragraph 9 ही तो पढ़ लो तो, no, page 9, sorry.
Page 9.
Page 9, sorry.
Paragraph 8.
Save and accept what a matter of every allegation, so I deny and dispute the defendant in due acknowledgement of its obligation has issued balance confirmation for the year so and so, 2013, 20 or 2016, has issued balance confirmation 2016-17.
Yes.
So, below, if 16-17 balance confirmation is page 31.
I denied and dispute.
I deny and dispute that the defendant in due acknowledgement of obligation has issued balance confirmation for the financial year 13-14.
13-14.
Or 15-16 or 16-17.
13-14 is the 13-14 is 29.
29.
15-16.
30 and 31.
Yes. 15-16.
Or by such acknowledgement, the defendant admitted to repay the dues or demand of the as alleged or at all.
Correct.
So, my lord, at the cost of repetition, I state that the plaintiff has forged and fabricated and manufactured the documents claiming to be the balance confirmation by the defendant. The documents appearing at pages 29 to 31 of the application are forged and has been manufactured for the purpose of filing the instant suit for recovery of money. I deny and dispute the defendant failed or neglected to make payment of the principal, loan or interest or any part thereof as alleged. I say that as the plaintiff as per mutual agreement herein has said so. My lord, with respect, my lord, I am trying to find out, the reason I'm reading it is I'm trying to find out where has he made out this case that the seal is forged.
Seal there is no. Seal there is no case made.
That's what I said. That is exactly my submission was, because I heard my learned friend say that he had made a specific case that the seal is forged.
Seal is
And Milo, so far as the question of forging a seal is concerned, Milo, It's a criminal offense of high altitude if I'm so there would be a criminal complaint straight away. So if I have called upon him to pay money, which he is not liable to pay, and if I have forged a document for the purpose of, and I've used it before a court, my lord, then the natural conduct or the natural advice or the natural consequence would be, my lord, that somebody is manufactured document, manufactured the seal of the company and has used it. So far as this gentleman is concerned, my lord, this gentleman, my learned friend, doesn't even say that the gentleman whose signature is appear is not known to the company or is not authorized. So therefore, my lord, this submission which my learned friend makes, if I have to take him to the box or if he wants to come to the box, he can only run his case so far that is there in his pleadings. And so far as the pleadings is concerned, my lord, if these basic facts are not disputed, nothing remains to be tried at the trial. So far as interest, my lord, of course, my lord, I had said, I don't think, my lord, any such case has been made out.
Yes.
To my lord, even await trial.
Yes.
I don't think that facts are clear enough. Nothing goes to the root of the matter.
So suffering for the plaintiff, so suffering for the defendant. Getting concluded in connection with GA3 of 2021 CAV.
Okay.
Next.
I'm for the petition. Apple.
Yes.
Well, I appear for the plaintiff petitioner, my lord, it's an originating summons suit, my lord. My lord, on the last occasion, my lord, 2 affidavits have been placed on records of both the beneficiaries, where they have consented, my lord, to the if the property is sold and the proceeds are, my lord. On the last occasion, my lord had directed this society, which is the defendant number 3, to come back and if they have anything to say in the matter. In fact, my lord, they have not appeared, my lord. But what I wanted to show, my lord, that the society, when we had requested them for the sale, they said you obtain appropriate orders from the court. They have made their stand absolutely clear that if the court orders, then perhaps we can allow the change of name of the owner of the flat. So, my lord, it's really for the court, my lord, to decide. But they have said if the court orders, then we'll have to do it. And we have.
What about the society?
Society, I'm saying society stand. They are saying if the court directs, we'll do it. Because they are bound by their regulations. Their regulations say that the person has to give an undertaking that he wants to reside in the property. And they don't want to deviate. That's understandably so. So therefore, my lord, I was humbly beseeching, my lord, this can be permitted, my lord, because we have a buyer who perhaps may not be interested, my lord, if it is delayed. And also, my lord, that we have to keep coming back for this only, my lord, for this flat. And it's not a valuable property, but yet it is.
But the condition of the will can be altered.
Yes, my lord, on this, my lord, the law is pretty well settled. I have, my lord, several authorities on the point, my lord, where the courts, my lord, have consistently held if it is for the benefit of the beneficiary. No, I want to cite some. But kindly takes, my lord. Yes, to think.
Yes.
My lord, kindly here, my lord, if my lord takes the facts, my lord, there was similar embargo in the will in this matter also. And I kindly straight away comes to the last page, page 701.
Yes.
This particular case falls exactly between the two cases in Vesey in the on one hand and in the case in Simmons in the other. There was a clear intention on the part of the testator that his nephew should not sell or alienate the property during his lifetime. On the other hand, there was equally clear intention that the nephew should have the power to appoint by deed or will as well as by will, so that the donee and an absolute estate and the restraint on alienation must be considered to have no effect so as to detract from gift in the absolute estate. I think, therefore, in spite of these words of restraint in clause 12, the nephew was empowered to appoint by deed or in writing during his lifetime to himself, and therefore he has the power to convey the absolute estate. The result may be that the first question to answer is that the plaintiff can either convey direct or to the defendant and so give him a good title, or he can first appoint himself and then convey. So, my lord, this is one case where, my lord, here also in the facts of this case, my lord, will note the benefit of the flat is only going to this son, and the other son has no difficulty in that. But this, my lord, the more recent judgment of this honorable court, my lord, kindly takes me to 2019 SEC online Calcutta 9 111, is it AR 2019 Calcutta 121, kindly takes this one. No, okay. Kindly comes to paragraph 5. The will has created diverse interests in favor of the legal heirs of the said deceased, who are beneficiaries under the will. The wife was given life estate, and after her death to his son. The son is also having a life estate with regard to the western portion of the property. The testator under the will did not want any legal heirs to sell, mortgage, or charge the property during their lifetime. It was in the nature of trust by which the legal heirs are the beneficiaries. The said trust would automatically come to an end on the death of the legal heirs. However, if a legal necessity is made out, then the beneficiary of the will can apply to the court for an opinion for advice or sale or encumbrance of the property, which would be beneficial for the beneficiaries of the will and or the trust, as the case may be. Although in interpreting the restrictive clause in the trust deed of the estate in so and so, Justice so and so observed that the right of alienation can be exercised rightly in the case of need or for the benefit of the state. And in another decision on so and so, AI 1959 Patna, the High Court construed a clause against the alienation of the property by the Shevite in a deed of endowment by observing that it would not be in the interest of the institution to deprive the Shevite of the power to alienate in alienation of the case of necessity or benefit. The same principle can safely be applied in the instant case as advised to the applicant in favor of the alienation, notwithstanding the wishes of the testator, primarily on the ground that it will benefit for the beneficiaries under the will. And the original clause against alienation in the present context, if construed against the beneficiary, would defeat the object and the purpose of the will. And then, my lord, this is originating suit property, suit where the permission was granted for sale. In fact, there are more cases, my lord. I will cite only one more. Following this, this is by Justice I.P. Mukherjee in 2014 SEC online Calcutta 834. But may I cite this? Here also, similar restraint was there. Kindly comes to page 2, second page, top. I must not omit to mention. Page 2, third. I must not omit to mention that the trustee under the deed of trust do not have any right to sell the property. This is why they have come up before the court by way of an originating summons to seek the permission of the court to sell the property. I am firmly of the opinion that the income of the property does not match with the value of the property, and the purpose for the trust would be realized only upon the sale of the property. After all, it is a private trust for the welfare of the beneficiary, and some of whom are also trustees. But here also it was allowed. The idea behind this, my lord, it is for the benefit of the beneficiary. In the case at hand, my lord has noted the beneficiary is not resident of India, and it's a very small flat. It will serve no purpose unless it is sold out.
Where is the will?
Yes, my lord. Kindly takes, my lord. Will is at page 10 of my application. And my lord,
who has filed this application?
The executor has filed the application. I am for the executor. I'm sorry, my lord.
Pururaj Jatto.
Sunita Ghosh is the executor, my lord.
No, who has filed this application?
Constituted attorney.
The attorney, the signatory, my lord, she, in fact, the executor is also a resident of the United States of America, my lord. So through an attorney, she has filed it before this honorable court.
Sunita Ghosh
Is the executor, my lord, under the will. Kindly takes the will, my lord. I'll show, my lord.
executrix or executor?
Executrix, I stand corrected, my lord.
Para 3 at page 10.
And Jati Mukherjee?
My lord, may I place it? I appoint my nieces, Sunita Ghosh, which is the applicant, and Shamuli Banerjee and Jyoti Mukherjee to be trustees of the Ranjan Mitra Trust Fund, hereafter referred to as. In fact, my lord, paragraph 2, my lord, takes, I appoint my niece Sunita Ghosh and Jayati
Jati Mukherjee.
to be executors. Jayati has passed away.
He passed away?
Yes.
Actually, jointly or separately?
So to act jointly or severally, my lord, kindly takes the 4th line of the second paragraph.
Correct.
So
when Jati died?
Jayati died, my lord, split it.
Probate granted.
Probate granted. I had that's 15, page 15.
That is in the name of
Sunita Ghosh.
Sunita Ghosh.
Sunita.
Yes, my lord. Page 15 is the probate, my lord, of this honorable.
15.
Page 15, 1-5.
Yes.
And my lord, will find it page 16 that Sunita Ghosh has been allowed, my lord, to execute, my lord.
Last but 4 lines.
At page 16, last but 4 lines, my lord.
Yes. Probate is granted.
Yes, that's granted, my lord. Now the difficulty arose when, my lord, I'll show that clause in the, my lord, kindly comes to Annexure C, page 27, which is the bylaws of the cooperative.
With regard to the will, where is the clause?
That restriction? Yes, my lord. Kindly comes to page number 11, my lord. Paragraph 7. I give devise, bequeath all my personal effects, movable assets unto my 2 sons, Ranjan Mitra and Pratap Mitra, to divide between them in such a manner as they agree, but with the general intent that they shall share the effects in approximately equal share. If my lord kindly comes,
10 and then 11.
paragraph 10 and 11 at page 12.
Yes.
Where is the restraint? Where is the restraint?
Here. 11.
Yes, paragraph 11 is what my lord is looking for.
That in any case, after that, it will.
Yes. So if para 10, 11, and 12 have to be read together, my lord, kindly seize, my lord. Because all the income of the property has to go to Ranjan Mitra Trust Fund itself.
See, the fund is for the personal use of Ranjan Mitra. We are trying to do that work.
And the fund is for the personal use of Ranjan Mitra, my lord. Paragraph 11.
No. Kindly come to paragraph 9.
Yes, my lord.
I give devise to Sunita Ghosh the remaining half of the floor, other floor of my undivided share.
That's a different property. That's 62B Alipur Road.
So this is not the property.
No, the subject property is Nobo Kailash at paragraph 10, my lord. Next paragraph.
Paragraph 10.
May I place, my lord? I give devise bequeath to Ranjan Mitra Trust Fund trustees my Nava Kailash property being flat number 10. This is the subject matter of this present originating summons. To be held in trust for the benefit of Ranjan Mitra. I empower and authorize Ranjan Mitra Trust Fund trustees to take possession of the Nava Kailash property for the personal use of Ranjan Mitra, or to rent out the property or remit him the monthly rental for his use during his lifetime. Any maintenance cost required. The last line is the problem, my lord. The trustee shall not have power to sell the Nava Kailash property. And then, my lord, kindly takes paragraph 12. If Ranjan Mitra should have issues and heir the said Nava Kailash property and the income therefrom, along with the monies held in the trust by the said Ranjan Mitra Trust Fund, shall, upon his demise, vest to his heirs absolutely and forever. If Ranjan Mitra dies without.
To the Ranjan Mitra.
He does not have children.
He does not have children. He is not married.
My lord, I appear for Ranjan Mitra. I appear for both Pratap Mitra and Ranjan Mitra. My lord, he used to reside with his mother here. But then, since his other brother, he is a resident of the UK and he is not well, which is why this trust was created, so that it can be used for his benefit. He's staying with his brother in London only.
So both Pratap and Ranjan.
They both stay in London.
What about the trust?
Malad, the trust is in existence. That Malad Sunita Ghosh is only one of the trustees there. And their other uncle, I believe he's been co-opted as a trustee. There's no problem with the functioning of the trust as such. The only requirement is, since the trust cannot become a member of the cooperative society, if the property is sold and the proceed is remitted to the trust so that it can be used for his benefit. That is the only pledge.
One, I wanted to point out one paragraph, page 11, my lord, kindly sees the will. I have two sons, paragraph 4. I have only two sons, Ranjan and Pratap. The youngest son, Pratap, is living separately with his family. Pratap is well settled in life. Ranjan Mitra, the eldest son, is residing with me. Now, my lord, takes the date of the will at page 13. This is in 2002. So, during the lifetime of the mother, the son was with the mother. And this is why she said that after me, the son would continue to live in Calcutta in this property. But after the death, the situation has changed. The son has gone back to the other brother, and they are residing together at London. This flat is of no use, this has to be sold off. So this is why we approach this honorable court.
Who will sell?
Let the trust, the executrix will sell, and the money will go to the trust fund. Sunita, and this will go to the trust. The proceeds.
The Ranjan Mitra Trust.
Yes.
Yes. That's all.
That's all.
Where is the affidavit?
Affidavit, my lord, file on the last occasion we had filed it.
We filed the app.
Affidavit.
Malad, may I also point out
that I have personally met both.
Malad, may I also point out, Lordship sees the affidavit. Malad, Mr. Singh happened to be in London, so he had the chance of carrying these affidavits himself, and he had the chance of meeting both my clients in London personally. He carried it back with him, so he was there.
I can vouch it's a genuine thing.
The plaintiff filed the originating summons for advice of this, from this court on the following questions.
Let me take minutes.
Page 8, A to D. Plaintiff says that the testatrix Manjula Mitra had executed a will on 12th October 2002 by appointing the petitioner, the plaintiff, as plaintiff and Vanjayati Mukherjee as joint as executrix, but Jayati Mukherjee has died. After the death of Jayati Mukherjee, Sunita Ghosh, the plaintiff, had filed a probate case and has obtained probate from this court with respect of the will dated 12th October 2002. In the said will, it is in the said will, the testatrix Manjula Mitra has mentioned that that has authorized her son Ranjan Mitra to take possession of Ranjan Mitra Trust Fund Trustees situated at Nabakala's property for the personal use or to rent out the property and remit to him the monthly rental for his use during his lifetime. It is also mentioned that any maintenance cost required for the upkeep of Sai Nabakala's property and all taxes in respect thereof will be deducted and paid from such rental income. In the said bill, it is categorically mentioned that the trustees shall not have power to sell the Nabakala's property. The plaintiff says that during the lifetime of the testatrix Manjula Mitra, Mr. Ranjan Mitra was residing with his mother, and after the death of the mother, the Ranjan Mitra has started residing with his brother Pratap Mitra, and now they have settled at
London in the United Kingdom.
Settled at United Kingdom. Full stop. The plaintiff says that as the trustees shall not have the power to sell the said Nabakala's property, and the beneficiaries are not in a position to reside in the said property, and as such, the beneficiaries intend to sell the said property, and the sale proceeds can be utilized for the purpose of maintenance of Ranjan Mitra Trust Fund Trustees. Full stop. Both the beneficiaries, namely Pratap Mitra and Ranjan Mitra, have affirmed their separate affidavit stating the fact that where is the society bylaws?
The society bylaws are Annexure C. My lord, it starts at page.
Where it is mentioned, it cannot be said.
My lord, page 31.
Last line card. Page 31.
Page 31, clause C 6 D.
C
6D. My lord, membership. He is a permanent resident of West Bengal or intends to reside in West Bengal permanently within a period of 1 year from the date of the application.
Where?
My lord, page 31, clause 6 D.
D.
D. D for Delhi.
At the bottom of the page, Lordship.
He is a permanent resident and reside in the bank permanently within period of 1 year from the date of the application.
And E as well, Lordship. He has genuine need for housing or additional accommodation from such society.
So how the society is connected?
My lord, because this flat belongs to the Nabokoilash Cooperative Society.
Okay. The plaintiff says that the property equated to the testator is belongs to the society, and as per the bylaws of the society, namely Namba Kailas Cooperative Housing Society, Namba Kailas Housing Society, and as per the bylaws of the society, he should be a permanent resident of West Bengal or intends to reside in West Bengal permanently within a period of 1 year from the date of application, and he has genuine need for housing or additional accommodation from such society. So, concepts of that. Counsel for the plaintiff says that both the beneficiaries are residing permanently residing at abroad, and it is not possible for them to reside in the said flat, and as such, both the beneficiaries have executed an affidavit stating that if the plaintiff is permitted to sold by this court and the proceeds thereof remitted to any account maintained by Ranjan Mitra Trust Fund, the trustees have no objection to sell the said flat. Consider the submission made by the counsel for the plaintiff, peruse the affidavit, will, probate, and the bylaws of the society. Admittedly, both the beneficiaries are settled at abroad, and it is not possible for them to occupy the flat in the society, and it is not possible for the beneficiary to comply with the conditions of the society, conditions of the bylaws of the society, particularly bylaw 6 small d and small e, which reads as follows. This page 31. Okay. The beneficiaries have also executed an affidavit stating that they have no objection if the plaintiff will sell the said property, is allowed to sell the property, and the sale proceeds is deposited in the particular account of Ranjan Mitra Trust Fund. Considering the above facts and circumstances, this court answered as follows. Consider the counsel for the plaintiff has relied upon the judgment reported in 2014 SCC Online, Calcutta 8430, wherein the Honorable wherein the coordinate bench of this court has held that the income from the property does not match the value of the property, and that the purposes of the trust would be realized only upon the sale of the property. The plaintiff has also relied upon the judgment reported in 2019 SCC Online Calcutta 9111, wherein the coordinate bench of this court held that notwithstanding the wishes of the testator, primarily on the ground that it would be benefit the beneficiaries under the will and the original clauses against the alienation of the present contest, if construed against the beneficiary, would defeat the object and purpose of the will. The counsel for the plaintiff has also relied upon the judgment reported in Indian Law Reporter, volume 56, and submitted that the question that the plaintiff can either convey direct to the defendant and so give him a good title, or he can first appoint to himself and then convey. Consider the submission made by the counsel for the plaintiff for use the application, will, probate, and the bylaws of the society. This court answer the questions as follows. The testatrix had appointed the plaintiff as testator, as executrix, but Mr. Pradeep Mitro and Pratap Mitro are the beneficiaries of the will, but they are not in a position to occupy the property, as both are residing at abroad and both have given an affidavit of consent that they have no objection to sell the property and to deposit the sale proceed in the account of the trust. Thus the testatrix and thus the executrix has given liberty to sell the property. How she can sell?
My lord, with regard to her selling, she has the authority under the will. In case of any, we have certain purchasers who, if willing, we can execute shares.
How you will get the best market price? Tomorrow she will say, I sold in the 20 lakhs.
We have purchasers.
Or before giving answer, I will appoint a special officer along with the executives. Let the best price will take and deposit the court.
My lord, my instructions are.
Following answer, na?
My instructions.
This court find that before giving appropriate answers to the questions as raised in the suit, it would be proper for appointment of a special officer.
My lord, if I may only indicate, my lord,
A special officer, so that the property can be sold by the plaintiff with the intimation to the special officer by way of white publication, so that the plaintiff can get best market price
এটা তো আমার কোনো অসুবিধা হবে না। There's no problem. My lord, may I make one submission on instructions? My lord, my clients, in fact, defendant number 2 who had come here, they had identified a purchaser who was, and they had checked whether it was getting the best market price. But if lordship wants to provide for this, but the special officer can see, this intimation can be given to the special officer who can verify whether
What is
this
the market rate today?
My
Not
lord,
less than market rate.
believe I don't know what's the exact.
So not less than the market rate.
Not less than. Lordship may provide for that.
I am fixing the after vacation. You give the market rate and the present market rate and the proposed purchaser. If it is as per the market rate, then you can be.
That lordship, grateful lordship. That will suffice.
It would be appropriate to direct the plaintiff to submit the present market rate of the property and the rate proposed by the proposed purchaser, so that this court can give appropriate answer to the question. Let the matter appear on 19th June, 19 June 2020 under the heading order. On the date fixed, the plaintiff is directed to submit the present market value of the property as well as the rate provided by the proposed purchasers.
That's okay. Grateful lordship. Lordship was provided 19 June, lordship. Lordship. We'll grateful. Much obliged, lordship.
Lord,
The item numbers.
No item numbers today.
Lord, I'll tell you, Lordship, Lord, under compelling circumstances, Lord, in respect of the matter, where there was a lot of ruckus with regard to Lord, of affidavits. Lord, item numbers 50 and 51, Lord, Siddhartha Mitra. Lord, this is that matter, Lord, where, Lord, we have been, Lord, literally, Lord, pushed to the wall, Lord. 50 and 51, Lord. Lord, pushed to the wall, Lord, my Mr. Chaudhary, Lord, on the last occasion, Lord, for not filing and, Lord, in default of, Lord, filing affidavits.
They are filed.
Now, Lord, we are, Lord, ready with all the affidavits, Lord. This, Lord.
Suspend is school.
Yes, Lord, items 50 and 51. Lord. 50 is, Lord, my suit, Lord, filed by Siddhartha Mitra, Lord, the officiating secretary.
But my
And the
application
counterblast
there
is, Lord,
for
51, Lord. Lord, my
dismissal of the
affidavits are
suit.
ready.
You
Lord,
saw.
we have given them a copy.
What do you want?
Lord, to file the, Lord, affidavits.
The matter
The
they- you served
But
it.
the department is not taking the affidavit.
They have also filed, prepared our
Why
affidavit.
the department is not taking?
It was the last date was the 6th to file. We affirmed it on the 6th, but we wanted to file it on the 7th. We served on the other
Come
side
on the
also.
next day when the matter will be taken. You serve the copy.
We have served the copy. We have given a reply also, though they were out
Give
of
us the
time.
reply. Let's come on the next day.
Then we'll
At the
file in
time
court,
hearing,
my
I will take that.
Will your Lordship be taking up, Lord,
Well,
non-commercial matters
Well,
tomorrow?
let it
Lord?
be taken up tomorrow.
This will be emergency, 12,000 students in the school.
Tomorrow there is non-commercial.
But not only one, but two things, Lord. Now, Lord, there are, Lord, two affidavits. Lord, we have given them an advance copy. Two affidavits, Lord, which have been filed, Lord, which we could not affirm.
No
Lord,
wonder they haven't taken in the department.
no, Lord, which we could not. Two of the affidavits.
You have
Lord.
given the advance copy.
We have given them
You
the
have
advance
prepared
copy.
it.
Yes.
Okay, you could not be affirmed. Let's come on the next day. If it is not affirmed, I will give the leave once you if you are.
Great.
In fact, they had sent the advance copy with a covering letter. Then there is an affirmed copy without any affirmation. The covering letter says there is an
The
affirmed
rest of the affidavits have been affirmed. But only two affidavits where the persons affirming it are outside. That is why it could not be
You have
affirmed.
served the copy.
I have
to
served
other
them the
side.
copy.
So you will not
There is
going
no
to
question
change.
of
You are
agitation.
not going to change that affidavit.
Let me take after lunch tomorrow.
Already fixed.
In case it collapses, then we'll, because this was urgent, your lordship, that's why I
That's
kept
why
it on
you
the
fixed
9th.
it. Today the
And we
to be
filed
mentioned has
affidavits
not
in a
been
day.
completed.
So did we also.
Today,
Well, these are the affidavits which are really.
This is brought to get the adjournment, but we want it heard.
Well, the kind of pressure I have taken.
You are the ones who are
personally to
mentioning
get
the
this
matter.
to my
Mentioning notice.
But I think Mr. Chaudhary owes us a lot. the kind of pressure we
Okay,
have to
let's
take it for
after reopening you mention, I will fix that.
Very well.
My lord, we'll do that.
If your lordship will kindly records to that extent that my lord, we had come my lord, and mentioned the matter. And,
You
my lord, the
mention,
affidavit.
I will
Very well, very well. Very well.
Yes.
Your lordship seeking mention to matter item number 24, your lordship.
My lord, the very next matters, my lord, in the to be mentioned list, my lord, 16, 17, 18, my lord. My mother's side is here, my lord. They were directed to file an affidavit, my lord. Only that direction, my lord. If they want, they've not filed,
I'll
my
tell
lord.
your lordship, my lord, I appear on behalf of the defendants. My lord, during the pendency of the suit and the application which my learned friend has filed, my lord, section 95 applications before the NCLT under Insolvency and Bankruptcy Code have been filed against each of the partners of the firm. My lord, in view of that, my lord, section 96, your lordships are aware.
Okay.
My lord, interim moratorium will be, my lord, on that.
Okay, my lord, let them furnish a copy of that order, my lord. We'll keep it after vacation. My lord, my lord, in any event, my lord, the coordinate bench had directed the defendants, my lord, to put it on an
Lord,
affidavit.
I
my
don't
lord.
dispute that.
They have not, my
file
lord.
the affidavit.
My lord, let them file it on an
I
affidavit.
will, Lord, I will.
Okay, you give the copy.
Lord,
I am
I'm
not
giving it
taking
here and
today.
now.
Yes, my lord.
Lord, and in the meanwhile, I'll file my affidavit for whatever it's worth.
My lord, we'll keep it after the vacation, my lord. We'll come back.
Vacation only it will come.
Yes, my lord. I'm grateful, lord.
Your lordship, your lordship seeking permission to mention item number 24, your lordship.
Yes, for what?
Your lordship, this is a matter of anti-suit injunction against the defendant who is parallelly pursuing the proceeding in a California court, your lordship. This honorable court has issued the direction in on 21st March 2024, your lordship, this year.
What will happen to the California suits?
Your lordship, this matter is being proceeded by the defendant and the matter is listed on 28th May, in this month, your lordship.
Okay, come on 28th May. Come on 28th.
Your lordship, your lordship, kindly give me an interim direction in this matter, your lordship.
So what you want, madam? What is your prayer?
Your lordship, this is an anti-suit injunction in which I am seeking a direction to restrain the defendant to pursue the proceeding in a California court, your lordship.
You come on that day. Come on that day. 21st May. You come on that day. We'll see to the what is the application. We'll see to that.
Sorry to my lord, trouble your lordship again. With regard to the matters that I had mentioned, my lord, one of the affidavit, my lord, by Mr. Krishna Damani, my lord, he is in my lord judicial custody. My lord, his affidavit could not be affirmed in time. So, my lord, if your lordship, my lord, kindly, my lord, directs, my lord, the superintendent of police to, my lord,
No, automatically you write a letter. They will do that. There's no necessity of the court order. If the person is in judicial custody and you want to
make an affirmation.
Affirm it, you made a letter, write a letter to the superintendent. He will make necessary arrangement for either notary or oath commission, whatever it may be.
Would your lordship's my lord, direction be not required in that?
Necessary. If they refuse, then you come. We'll see to that.
Very well.
Your lordship, kindly give me a permission to be to mention this matter on 28th March. Your lordship, this is item number 24, your lordship.
Okay, you mentioned, ma'am.
After a long time of losing
I'm sorry.
application.
Yes, my appellate side time.
I'm so sorry, but just one last request. Just one last request. If your lordship kindly gives me leave to file it in the department because the department is not accepting the.
Let him keep it. He served us.
You have served it.
Yes.
If they're not taking. You come on the next day. You mention that you have served it.
I'm grateful. I'm so grateful.
Yes, call. Take first.
I'm sorry, my lord, I should.
Yes. Give. Yes, who is appearing for the petitioner?
Lordship, I beg to appear for the petitioner, Lordship.
Yes.
They preferred appeal and it was heard on 30th April. Stay petition was dismissed, Lordship.
Is that dismissed?
Yes.
So then what has happened to the main appeal?
My lord, paper book has been directed to be prepared.
Stay dismissed.
Yes, my lord, I understand, my lord. I had the occasion to appear, my lord, unsuccessfully. I regret. Nevertheless, my lord, I have instruction, my lord, they are contemplating the future course of action, my lord.
What?
My lord, I have been communicated with my lord, an email.
Have you gone through the clause 7? Make it clear the appointment of the
Yes,
deputy
my lord, I have seen.
abide by the result of the appeal.
Yes, my lord, I have seen, my lord. Problem is, my lord, once appointment is given, lot of my lord, effort is to be taken for the purpose of giving appointment and all, my lord. And after this, if we become successful, then also similar complication. So our only prayer is this, my lord. I have been instructed to, my lord, apprise this honorable court, my lord. They are, my lord, exploring further legal remedies, my lord.
What remedies?
Perhaps, my lord, they will go to the.
Go.
This is the email, my lord, I have been communicated with by the general manager, my lord.
But now it is
Yeah, I
division
understand.
method.
Yes, I understand, my lord. Certainly. If we, my lord, success, ultimately we have to bow down to the whatever the direction that is passed by.
What is the post?
My lord, post is
What
perhaps
post?
technical post, my lord.
Then where is the order? Where is the order?
My lord. They have, my lord, attached with their contempt application, my lord.
Page 25,
Directed to
Lordship,
appoint the
annexure
petitioner post
P1.
of AG3 technical
AG3, yes, my lord.
in the northern zone. Who is the contender? Railway?
No, my lord,
Lordship,
Food Corporation of India, my lord.
Food Corporation of India never comply with your good experience.
No, my lord, it's not like that, my lord. My lord, subject to correction, my lord, it is their understanding, my lord. Perhaps will become successful. It is their understanding, my lord.
They become successful. I am not
Yes,
telling that.
certainly, my lord. Kindly give us some time, my lord. We have to comply. If we remain unsuccessful, we have to comply. There is no other way out, my lord.
So and so appearing for the petitioner, so and so appearing for the alleged contender. Counsel for the petitioners has handed over the copy of the order passed by the appellate court dated 30th April 2024 in MAT 211 of 2023 within bracket can 3 of 2024 where MAT 211 of 2023 with bracket can number 3 of 2024 wherein the Honorable Appellate Court had rejected the application for stay and directed and made it clear that the appointment of the writ petitioner / respondent of the writ petitioner / respondent shall abide by the result of the appeal. Full stop. The learned counsel for the alleged contender has handed over a copy of the mail dated 9th May 2024, wherein it was informed to the learned advocate that the competent authority has decided to file an SLP before the Honorable Supreme Court against the order dated 30 April 2024. The counsel for the alleged contender pressed for some time. Consider the submission made by the counsel for the respective parties, peruse the order passed by the appellate court, and the communication dated 9th May 2024. This court find that the alleged contender failed to obtain an order of stay from the appellate court, and the Honorable Appellate Court has categorically made clear that the appointment of the writ petitioner shall be abide by the result of the appeal. But in spite of the same, the alleged contenders have not result of the appeal. But in spite of the same, the alleged contenders have not complied with the order. Full stop. Full stop. In view of the above, for the interest of justice, the case is adjourned for 2 weeks.
My lord, I am told, my lord, the Supreme Court reopens on 8th of July, my lord. On 20th, it is going into vacation, my lord, summer vacation.
2 weeks. 20th. Now we are on 9, 10. 10 days is there.
10
now
days,
all
my
are
lord.
online.
Yes, sir.
All are online.
My lord, they will take some time, my lord. It's a public sector, my lord, undertaking, my lord.
Interest of justice, the case is adjourned for 2 weeks. 2 weeks, let the matter appear on.
But then at least, my lord, fix it after vacation, my lord.
Let the matter appear on 13th June 2024. And 2024. Full stop. The alleged contemners are directed to file the affidavit of compliance on the date fix. Next.
My lord, item 2, I am for the petitioner, my lord.
Yes.
My lord, that on 13th April 2024, my lord. My lord, our honorable division bench, my lord, passed the order and dismissed the, my lord, their appeal.
My lord, I appear for
Yes, marriage. Then, so
my lord,
when the order was passed, 30th
15
April.
June, 15 June
My lord, 30th
2023, my
April
lord,
is the order
already, my lord,
passed.
1 year
No,
passed.
no, no, my lord, we have preferred the appeal. Your lordship, on 30th April, my lord, it was passed, my lord. 4 weeks time was given, my lord, to pay off the costs. My lord, we were under the impression that by these 4 weeks, my lord, we could pay the amount, my lord. If your lordship kindly grants us some time, because the election is on the, my lord, for absolutely, my lord, knocking the door. And my lords, it's a municipality. No more grant, my lord, the municipality will get as of now till the election is over. So, my lord, at least, my lord, let the election be over, then we'll come back, my lord. We'll try our best to, my lord, comply with the order and to pay off the dues. My lord, after the election, your lordship.
Election has already been over.
My lord,
Election is over.
Election already.
my lord, till, my lord, kindly, my lord.
Kindly, my lord, kindly.
4 weeks time, my lord, be given, your lordship.
Suffering for the petitioner, suffering for the alleged contemner. Counsel for the petitioner has handed over the copy of the order passed by the appellate court in MAT 81 of 2023 within bracket CAN 1 of 2023, wherein the appeal preferred by the alleged contemners is dismissed with cost of rupees 25,000.
My lord, to be paid within a period of 4 weeks, your lordship. That is what.
And 25,000, and the Honorable Division Honorable Appellate Court had directed the alleged contemners to pay the cost to the Legal Service Authority within 4 weeks from date. Counsel for the alleged contemners submit that 4 weeks has not yet been completed, and he may be submit that 4 weeks has not been completed, and now the election is going on, and prayed for some time to comply with the order passed by this court.
My lord.
The counsel for the petitioner raised objection and submits that a year back this court has the 1 year has been passed. This court has passed the order, but the alleged contemners have not complied with the direction passed by this court and prayed for issuance of rule. Consider the submission made by the counsel for the respective parties. This court find that one more opportunity should be given to the alleged contemner to comply with the order passed by this court. In view of let the matter appear on 19th June 2024. By the said date, the alleged contemner is directed to, by the said date, the alleged contemner is directed to file affidavit of compliance.
My lord.
I'm okay.
Deeply obliged, your lordship.
Next. Yes. Who is appearing?
Item number 2.
Item number
But, but I was appearing on behalf of the alleged contempt number 1, that is Malda Primary Council, the chairman Malda Primary Council. The fact is, my lord, from this month, from 6th of May, my lord, I am not appearing for Malda Primary Council. They have engaged in different advocates. So,
Who's for the petition?
I am for the petitioner, my lord. There is a or they have taken time several occasions to compliance order, my lord. There is a two part of the order, my lord. There is a return back his service. Service has been returned. My lord, service benefit, my lord, that has been not in done, my lord, and arrear also not been paid. My lord, kindly page 21 of the contempt application, my lord.
21?
21. Last paragraph, my lord.
Where is the contempt application? Yes.
On the last paragraph, my lord, kindly see.
So this has not been done.
First part is done, my lord, but my lord, the
Which part has been done?
that the impugned order are set aside and the authority are directed to take back the petitioner. Petitioner already take back.
No,
But
in my view, the order impugned passed by the chairman is not sustainable. Accordingly, impugned order is set aside. Authority directed to take back the petition. The petition be released all service benefits. So you have been given the appointment.
Appointment given, but service benefit not yet done, my lord.
She was reinstated. She was getting regular salary and also arrear salary was also paid.
So what is required to be given?
Service benefit also, my lord. The tenure of service, my lord.
So and so appearing for the petitioner. Mr. Shamimul Bari, learned advocate, who used to represent the alleged contemners, submit that since
6th May.
Since 6th May 2024, he is not appearing on behalf of the alleged contemners and prays for leave to discharge from the instant case. Discharge from the instant case for appearing on behalf of the alleged contempt. Accordingly, he has been discharged. As none appears on behalf of the alleged contemner, the petitioner is directed to serve a fresh notice only informing the date of hearing to the alleged contemner and to file the affidavit of service on the next date fixed. It is made clear that if on the next date fixed, if none appears on behalf of the alleged contemners, appropriate order will be passed. This is the matter on 19th June.
Grateful, my lord.
Next.
Lordship, today they have served the statement of
Order was complied. They prayed for the details
Statement
of
of
calculation sheet.
ABSL.
You want take time? You want time?
Lordship.
Substantial compliance they have
Give it 2 weeks time, your lordship.
Very good, my lord.
Suffering for the petitioner.
Actual payment
Suffering for the. In this matter, you are appearing.
Yes, my lord.
Constituent suffering for the alleged contemner. Counsel for the alleged contemner submitted. The contemners have complied with the order passed by this court and serve the copy of the order to the learned counsel for the petitioner. Learned counsel for the petitioner prays for time to go through the order and to make appropriate submission on the next date fix whether the contemners have complied with the order in full or not. In view of the above, the case is adjourned. Let the matter appear on 19 June. 19 June is Thursday, no?
20.
Let it be on all cases 20th. Not 19. 19 is Wednesday, 20th June. All matters, huh? All matters 20. All matters 20.